You hear me now? Perfect. First of all, welcome. Looks like we have a full crowd this morning, and I understand the overflow room is doing well. There's no coffee or beverage service, so we'll try to take a couple breaks. Before we start, the meeting this morning is going to be, or the meeting today is going to be a very long meeting. We have some really intense work to do. We have some heavy lifting to do. Your patience and your decorum are both appreciated by all of us. So we want to welcome you here, but we want to keep it moving this morning. Public comments are going to be limited to 1 minute. Sometimes we get a little loose where we let 1 minute turn into 3 or 4. That's not going to happen today. So if you're going to do public comments and you're beyond a minute, the buzzer will go off and ask you to stop. We have 3 petitions this morning. I'm trusting that most of you are here for the petitions, and perfect. Public comment. I have the public comment slips that I have right now are all related to issues, specific items. Is there anybody online or anybody calling in for comments? Nobody for. Good, excellent. With that, I'd like to move forward for a consideration of the meeting minutes for the May 16th, 2025 meeting. Oh. One minute.
My name is Fred Neenstead. I'm from Macomb County, right? I have a question about turning in petitions. So I received petitions as a circulator to turn in for our petition drive. And that petition drive has 2 pages on the petition, right? There's a fold, there's another page. The circulator tore off the page with the rest of the abrogated or altered articles. Is this petition valid if it's turned in?
Obviously, the final decision is the board's, but we would recommend that be rejected. We would not count that as a valid because it's
unlikely that the board would overturn that rejection, right?
The board will probably go along with.
Yeah,
what Mr.
okay, I
Frank Davis
appreciate
said.
it. Thank you very much for your time.
You're welcome. With that, consideration of the minute meetings for the May 16th, 2025 meeting.
So moved.
Second.
Been moved and seconded. All in favor? Aye. Consideration of the de minimis change, excuse me. We have a consideration for a de minimis change to the ES and S voting systems.
Thank you. So this is a de minimis change, which again means that it's a change that once it goes through the voting system test laboratory, the VISTL and the EAC determine whether or not it affects the certification status. And if yes, then it is not a de minimis change. In this instance, it is a de minimis change because it does not affect certification of the system in general in the state of Michigan. Specifically, it's one that will not materially alter the system's reliability, functionality, capability, or operation. So what this change is essentially there are motors in the tabulators that keep things moving, for lack of better terms. This is a bracket that holds the motor in place. The current bracket has reached its end of shelf life, for lack of better terms, needs to be, in some instances, needs to be replaced, and the current version of it is not made anymore. So for long story short, in lack of better terms. So with that, we are just requesting that for ES and S services in the 7 counties, that you authorize us to replace the bracket. So happy to take any questions.
Any questions? Do we have a motion?
I move that the Board of the State Canvassers approve ECO 1185 for use with the ES&S Express Vote System in the state of Michigan.
Support.
All in favor?
Aye.
Motion Passes. And right away, we are at the first petition. It's time to talk about the consideration of the 100-word summary for the purpose of the constitutional amendment sponsored by Rank My Vote. The summary is drafted by the Deputy Director of Elections, and I'm going to read that to you. It's as follows. Constitutional amendment to establish new right. Try again. Constitutional amendment to establish new right to ranked choice voting starting in 2029. For qualified offices, require voters numerically rank candidates, determine winners by counting votes in rounds, eliminating lowest ranked candidate and redistributing votes, allow voters to rank at least 4 more candidates than seats to be nominated, elected, unless insufficient number of candidates file, authorize local charter to provide use of RCV, which is the ranked choice voting, in limited local elections. Move the August primary to June or earlier for the even year. Recognize voters' right to timely notice of election activities and to vote if in line when the polls close. Require legislative funding allocation. Authorize implementing legislation. Word count is 100. Now, terms of comment, here's how we're going to go. We're going to allow the attorneys representing and the attorneys representing both sides to present their case. And we'll go through questions and answers. Then we will allow time for general comment. Understand? Mr. Steve Liedl representing ranked choice. I'm sorry, and Ms. Flowers? Please give your name for the record.
Good morning, Steve Liedl from Dykema on behalf of Ranked Choice, Rank My Vote Ballot Question Committee.
Can I, before you push the button? Nope, there you go.
Let's try it again. All right. So likewise, good morning, members. My name is Olivia Flower. I'm here with my colleague Steve Liedl to represent Rank My Vote Ballot Question Committee. First, I'd like to thank the Bureau for their time reviewing this proposal and putting together the summary that we're talking about today. It's a busy time of year, and there's a lot of proposals out there right now, so we appreciate the work that the Bureau has put into this so far. The Rank My Vote proposal would amend the Michigan Constitution to confirm the right to ranked choice voting and to allow for ranked choice voting for certain federal and state offices. Ranked choice voting allows voters to numerically rank votes for candidates in order of the voter's preference. The proposal would also enable localities to adopt ranked choice voting if they choose to do so. We've already provided a memorandum to the board regarding our proposed changes to the Bureau's 100-word summary, so I won't repeat those remarks in full here. All of our proposed changes aim to bring that 100-word summary in line with the requirements of the Michigan election law to be true and impartial, to accurately apprise the voters of the subject matter, and to provide clarity with regard to the language of the summary used. Starting with the truth and accuracy of the summary, I would like to call the board's attention to 3 major issues today. First, the 100-word statement currently provides that the proposal would only move up primary elections in even-numbered years. That's not accurate. The plain text of the proposal allows for all primary elections to move to June or earlier. That would include city elections in odd years. Second, the summary says that the proposal will recognize voters' right to timely notice of election activities. We think this language is too broad and could encompass an unlimited number of occurrences relating to elections. That's not what is provided for in the proposal, which addresses the changes in election rules and procedures affecting election participation. So consistent with the language of the proposal, we propose swapping activities for changes. Third, the summary provides that the proposal would require legislative funding, allocation, and authorize implementing legislation. The proposal mandates both legislative implementation and funding. The summary should reflect those mandates. We propose changes to clarify that legislative implementation and appropriation of money for implementation and administration are required, not just permissive. The remainder of our changes focus primarily on bringing the summary closer in line with the text of the proposal, adhering to the statutory requirements for proposal summaries, and then implementing plain and concise language to accommodate the remainder of those changes. We expect that you will hear from opponents of the proposal today. You'll hear something to the effect that the language in the deputy director's summary indicating that voters are required to rank candidates is misleading. We agree. This proposal doesn't require ranking. It allows or permits it. You might hear concerns that the deputy director's summary doesn't clearly define how a winner is determined. We agree with that as well. And our proposed changes address that. You may hear objection to the use in the deputy director's summary of the phrase legislative funding allocation. We agree, and we've proposed a change in our submission to the board addressing that as well. You may also hear concerns that the reference to ranking 4 or more candidates in the deputy director's summary is confusing. We also agree, and we've recommended changes to the board in that regard. Finally, you may hear concerns that the deputy director's summary doesn't explain the details of the proposal. It can't. That's not the statutory purpose, which is to impartially summarize in not more than 100 words the proposal. Petition signers can read the actual proposed amendment for more details. It's on the petition. So should any other parties wish to comment on the summary, we would appreciate the opportunity to respond to those comments. And with that, we are available to answer any questions that the board may have regarding our proposed changes to the summary. Thank you so much for your time.
Other questions?
In our memo, we've included a red line of all of our proposed changes.
Comments?
Good morning.
Good morning.
One of the questions I have, and it is included in the director's summary as well, is the purpose of including language that already is in place, such as the ability to vote if in line when the polls close. Do you mind addressing that? Why you feel it's necessary to include that?
Yeah, I'll let my colleague Steve handle that.
Okay.
Thank you, Member Cummings. Happy to address that question. I think the answer begins with the text of the statute and the duty imposed on this board by the statute in terms of the elements of the summary. And MCL 16842B requires that the summary apprise the petition signers of the subject matter of a proposed amendment, right?
Mhm.
And these are not just any rights. The proposal proposes constitutional rights, right? In the past practice of the board, the practice has been if there is a constitutional right provided or affected in a proposal to indicate that if the summary permits in terms of words. The proposed write-up we indicated suggested you can indicate each of the rights detailed in the proposal within the boundaries of the 100-word summary. I also think you should be careful by deferring to statutory rights. This proposal does not address statutory rights. It's not an initiative petition. And the board has past practices here that were implicated. In 2022, there was a proposal before the board relating to abortion rights, reproductive freedom for all. At the time, this board considered the proposal, the right to an abortion was a recognized constitutional right under both federal law and the Supreme Court. And while the petition was circulating, the United States Supreme Court determined that there was no longer a right to an abortion under federal law. If the proposal summary, when it was being drafted, said, well, we don't need to address that constitutional right because it's already a right under existing law, then voters wouldn't have been informed of the actual nature or, to use the language of the statute, they would not be apprised of the subject matter. I think for those reasons, it is the proposal itself The proposal proposes newly specified constitutional rights. And we believe that the text of the proposal, if possible, within the 100-word summary, should indicate to the voters each of the constitutional rights that would be implicated in a proposal.
But would you agree there are some constitutional rights that aren't included in here?
In the director's summary,
In yours?
in our view, the proposed summary addresses each of the rights addressed in the proposal.
Say that again? Sorry.
The summary that we have proposed as an alternative to the director's summary addresses each of the constitutional rights provided in the proposal.
Okay.
The proposal itself includes in the constitutional amendment several rights. And one, the proposed Section 4A indicates in addition to the rights under Section 4. So there are a whole host of rights relating to voting that the voters have added in recent elections. So in addition to those rights, you would have the following rights: the right to vote using ranked choice voting in our proposed summary, the right to timely notice of changes relating to elections, including polling place changes, in our proposed summary, the right to vote if present in line when the polls close, in our proposed summary, the right to vote a write-in candidate if a candidate's name does not appear on the ballot, in our summary. Those are the rights provided for in the proposed constitutional amendment supported by Ranked Choice Ballot Question Committee. We believe it's important and consistent with the statute to indicate in the summary that all of those constitutional rights are provided, and the summary proposed by us in the memo to the board does exactly that.
Thank you.
Thanks.
Orders.
Excuse me, in some of our past meetings, we've discussed, and have included in the 100-word summary, how to talk about the costs that are associated with some of the things that we've been reviewing. Have you guys done an analysis on what you think the increased costs this would bring upon those who are putting on these elections?
I'm not aware of the Board of Canvassers engaging in fiscal analysis or including fiscal analysis in its proposal summaries.
We've talked about in the past, like just in our past couple of meetings, we've talked quite a bit about what the cost would be to the Secretary of State's, for example, and have included language in our 100-word summaries that make sure that the people know that there are additional costs that they're going to have to be funded by the state and by the people as part of the changes that are being made. So I'm just curious if you guys have looked into those costs.
Well, also, I think I'd also note, the Board of State Canvassers is not a legislative body. The Board of State Canvassers engages in specified duties imposed by the legislature. The case law relating to boards and commissions in state government is that they have only those powers provided by the legislature. They have no inherent or implied powers. This board is not a board of general matters relating to elections. This board performs the functions under law specified in Michigan law. One of those functions is not financial analysis. I caution the board about engaging in financial analysis because you could include some language that would be misleading. I'd also note sort of similar changes relating to voting rights and in-person and early voting that this board considered and prepared summaries for that did not address the costs. This proposal imposes the duty to implement the provisions on the legislature. And so it would be up to the legislature to determine what the costs would be if the voters do approve this. And then also, secondly, appropriate the money sufficient to meet those costs. But I have not done any sort of financial analysis of the potential impact of the changes that might occur under the constitutional amendment, nor do I think you can fully do so because no one is fully aware of how the legislature might choose to implement the changes.
Gurwitz. Vice Chair.
The movement of primary elections is applicable to all elections, but I'm looking at section 5, which refers to primary elections appearing on a ballot at a November general election. It doesn't appear to apply to the elections which are not general elections, and that is every other year.
So the new language would address all primary elections rather than modify the preceding part of section 5.
Right. Sorry, I'm having a little computer problem here. So
No.
you have to, probably my fault and not the staff. But
Absolutely not. Happy to
um,
answer questions.
Yeah, I mean, I think, well, you're looking, like, I think it's important to look what the existing language does, right? There's an exception for special elections to fill vacancies or is otherwise provided in the Constitution for this entire phrase, right? So this would arguably not apply to special elections where you might need to hold an earlier primary, right? And then what does the existing next phrase address? It doesn't address primary elections at all. It addresses when must a general election be had, right? And it says that for certain elections, they have to be held on those general elections have to be held on Monday. And then it adds a phrase, right, to the existing provision, subject to the special election exception. And after December 31st, not general elections, but all primary elections to nominate candidates. That's not a phrase that's used in the prior sentence. And it says for a public office appearing on a ballot at a November general election. Unlike the existing language in section 5, there is no reference in the new language to an even numbered year. All would include odd numbered years, and the intent is to include city elections, which are excluded from the general election provisions in the existing language of the Constitution. To give effect to all of the words of both the existing Constitution and the proposed new words, I don't believe there is any way to read that other than to indicate that the proposal would require all primary elections subject to the special election exception to be held at least 140 days before a November general election. Now, there may be language in the election law that defines November general election to be an even year election, but this does not adopt any reference the even year language from the election law. This is its plain and ordinary meaning.
I would like a little help from Mr. Rakasi here, but when I read section 5, it seems to me to be applicable only to general elections, moving the primary during the general elections. I hear you, Mr. Lidl, telling me I'm missing something, but I don't know what I'm missing, so I'm looking for a little assistance.
So I can, if it's helpful, I can kind of talk about that specific section. I can do everything at once. I can talk about this one however the board would like, but with this specific phrasing, the reason that I phrased it the way that I did and specifically said in the even number years is because when I read section 5, the changes that are being put in, it says, quote, all primary elections to nominate candidates for a public office appearing on a ballot at a November general election. So to me, that means the starting point is if it appears on the November general election ballot, the corresponding primary for that office gets moved back at least 140 days. General election is defined under election law, specifically under section 2 of election law to mean, quote, the election held on the November regular general election date in an even numbered year. And that's seen in other provisions of the Constitution as well. So for example, the general petition provisions under article, I forget the article off the top of my head, but the general petition section says that if a petition submitted, it goes on the next November general election. And that has been interpreted the same way, given the statutory definition to mean the November general. So that's why I phrased it the way that I did, because of the structure with the changes to section 5?
I think there are a number of definitions, including on the second page, many of which, reference language from the election law, right? Those definitions specifically indicate as used in this act, right? Not as used in this Constitution. And there are November general elections that occur in cities throughout this state. The city of Detroit, for example, the city of Lansing, where we are today, are holding November general elections in odd number years. Obviously, a statewide proposal cannot go on the ballot on an odd number of years because there is not a statewide election in odd number years in November. But again, the purpose of interpreting any provision of the Constitution is to use the words in the Constitution or proposed constitutional amendment. And nothing in this proposal indicates that the words November general election mean that term as defined in the election law. And there is no definition with regard to local November general elections elsewhere in the Constitution that would apply. That language only applies to state elections. That's covered. All state elections, general elections, are held in even years, as are county and township elections, because the Constitution requires it, as well as national elections. The Constitution permits cities to hold general elections in November, and there is nothing that indicates that this provision doesn't apply to both. The prior provision, the existing provision of the same section, references a November general election, but those are those held in even numbered years only for national, state, county, and township offices. The existing language is silent on city general elections, but the proposed new language is not. So I don't know how any court would give effect to the actual language used. There's no precedent that says if the Constitution doesn't define a term, you look to the legislature to define it. The precedent from the courts is that you use the plain and ordinary meaning of the term November general election. Well, where do November general elections occur in this state? Well, they generally occur for national, state, county, and township elections in November of even numbered years. But we have many municipalities, home rule cities in the state, that hold November general elections in November of odd numbered years. And this language just recognizes that both occur, and the new language applies to both November general elections held in an odd year and an even year. There's nothing in the proposed language that restricts it. And so we would urge the board in its summary to give full effect to the language actually proposed by Rank My Vote Ballot Question Committee. That's the starting point in determining a summary. What's the actual language used and what is the effect of that language? I don't believe, whether it's the Deputy Director of Elections or this board, you have authority to read definitions in to the Constitution that do not exist in the Constitution.
Thank you both.
This is a big issue, obviously, because clerks have been asking for the primary elections to be moved earlier for quite some time, and the legislature has not so far been responsive to that request. So I wonder why you qualified this, why, if it said all primary elections, I'm not.
It does say all primary elections.
Right.
You remove the qualifications.
But then you qualify it, all primary elections to nominate candidates appearing on a ballot at a November general election.
And cities hold November general elections.
You're saying November general elections is not just applicable to.
If you're aware of some language in the petition, in the Constitution, Member Gurwitz, that modifies the word November general election from its plain and ordinary meaning, I'm happy to look at that and perhaps might change my mind. I don't believe you will find it. The intent of the group is consistent with the support of many clerks throughout the state to have an earlier primary. And this language would apply to all primary elections The board has a duty to give effect to the word all, right? And there's no limitation on a November general election in this language, the new language that's proposed, that would indicate any intent that it's anything other than both even and odd numbered years, all years.
Yes. Address this.
I was just thinking, and I'm not sure I can, because I think just listening to all this, at the end of the day, there may just be an ambiguity.
Sorry.
There may just be an ambiguity if this passes, right? But as written as to what the meaning of that term may be. I hear Mr. Lidl saying that what their intent is. And then I think it's not clear, then it would be a question for the court to determine,
Right.
what it
So
means.
if your legal counsel is advising you that at best they can advise you that it's ambiguous, then our request to you is not to pick an ambiguous approach, right? Rely on the language that's actually used. Then the voters can decide what this means or if it's ambiguous to them or not. But if you were to choose a different interpretation other than it may be ambiguous, as you have been advised by your legal counsel, then you are deviating from the standards that require sort of an impartial and accurate reflection of the proposal. Because you now have been advised by your legal counsel that she has concerns that it could be ambiguous and there may be disagreements about its meaning if it's implemented.
I think it would be preferable that we not put an ambiguous term into the Constitution if we can avoid ambiguity.
Okay, but that's the proposal before you.
That
The
is,
board's duty is to summarize the proposal before you. There will be many suggestions today that if you could just change this word, or if you could just change this word. This is not a legislative committee where folks can have a debate or not. I remind the board that the purpose today is to take the proposal that has been submitted to you, and the legislature has imposed a duty for you to adopt a fair and impartial summary consistent with the content of the proposal and the statutory standards within 30 days of submission. The board doesn't have the option of not acting here. The board has a duty to reject or accept, right? And you have a proposal before you. You have an explanation of the proponents of the intent and the language, and the intent as it applies to all November general elections. Your counsel has indicated that it is ambiguous. So our position is that it would be inconsistent with the statute for you to take a view that it only applies to primary elections, because your legal counsel has not advised you definitively that that is what the provision provides.
Both about the deputy director summary and yours, which says that this would, ranked choice voting would be applicable for qualified officers. Your petition defines qualified officers in a pretty limited way. It seems to me that it would be useful for people assessing this proposal to know what those qualified officers are. Is there a reason that you don't think it's?
One, we
required?
did propose that in the original submission from the committee. You're right. It applies to federal offices. There are really only 3: presidential, U.S. Senate, and U.S. House in Michigan. So ranked choice voting would apply to all those. It would apply to the 4 statewide offices.
But
Yeah.
your original proposal said in most federal.
Yeah.
But in fact, it's all federal.
I think most may have qualified some of the other items, but it would apply to.
Oh, so you're saying most federal, that most is applicable to state? Because in fact, there are very few state elections.
Yep. I'm fine with a different word than most. I mean, I'm fine, we were reacting to provide
You're right.
comments on the deputy director's proposal, right? We were fine either way, right? Adding federal, certain state, and some local offices would add words. So if there's a way to do it within 100 words, we would be supportive of that,
And,
yes.
and I would like to find a way to do it because I think it's really critical that people understand that it is all federal elections, although that is only for 15 offices, senators and representatives in Congress.
Right,
For state, while it lists 3 qualified, governor and lieutenant governor, attorney general and secretary of state. It also says that those latter 2 offices, if they're nominated at convention, are not, this is not applicable.
no, I think it's,
For the primary, it would be applicable for the.
well, under current law, there is no primary election to select the candidates of a political party for the office of, that may change in the future, right now.
But it
So
would-
it would not apply to primary elections
the
for any
attorney
at the
general
state
and
level.
secretary
It would
of state.
only apply to a primary for governor
But it would apply to a general election for secretary of state and
and attorney general, correct.
And certain local elections, but it doesn't apply to any local elections unless some localities opt in, correct?
No. So let me just summarize. Yes, federal, it applies to the federal offices. It applies to a few or certain state offices, and then it applies to certain local elections. Primarily, the language would implement it through the charter or ordinance process for charter counties. There are 2 of those. All cities, with the exception of the city of Mackinac Island, are home rule charter cities, but they also have a local act charter, and then charter townships. Because that does not require a change in law, they can implement under their charters ranked choice voting if state law doesn't prevent it. In fact, many communities have already voted to authorize at the local level for local elections ranked choice votings. They have qualifiers in their charter provisions that said if permitted under state law. So they would need to take no further action. I think I'd also note that the proposal explicitly provides that the legislature may opt to expand ranked choice voting to future elections, right? And so this is going to be implemented by the legislature. Much like early voting, there is no way to implement this proposal without changing state law. So the legislature may opt to expand it to more elections, but I do think for purposes of an economic inclusion of the offices, if you wanted to include that in the 100-word statement, I think you could say federal and certain state and local elections or offices, and that would be probably the most efficient way to sort of provide
So
that.
if it said all federal, limited a few state, because it really is a very small number of state offices,
Well,
4 out of, and all of the state legislative.
does
the
not apply to
Senate
state
and
legislative
legislature are
races,
not.
does not apply, under its terms to judicial. I'm just thinking of like, you have 100 words. To do what the director has proposed, what we are proposing, what you're likely to hear from the proponents, there's not a lot of space. So I'm focusing on economy. So I think the fewest words you could do it is federal and certain state and local, either elections or offices. I mean, it doesn't apply to elections technically, right? It applies to offices, at an election. To be, if you want to get legally precise, right?
And I do think because we have a limited number of words that we have to address the most important parts of the proposal, which is why I think that adding something like recognizing voters' right to notice of election activities or to vote in line when the polls close,
Right.
that sticks in a lot of words which are really immaterial
Mhm.
and excludes the words that are more important. That is specifically which
Yep.
elections this is applicable to.
Yes, I expect you'll hear from others today that they believe voters should be advised that this applies to presidential elections, right? And we don't disagree with that. So happy to work with the director.
Which is a
members of the-
presidential election. I mean, a federal election,
Yeah.
obviously, right?
Yep.
Right.
Any other requests, comments, questions? Thank you both.
Now, I have
Oh,
a question
you do have
about,
another one.
allowing voters to rank at least 4 more candidates than seats. That's only for the local elections, is it not? Because it's only for multi-candidate elections.
Yeah, that's why our change to, we strike that language.
I've got.
No, 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 go ahead.
So you agree that that's not necessary?
There's too much variability
Okay.
there.
I'm
Yeah.
We expect you'll hear from the opponents the same. It's a deep,
Do you have a paper copy?
Yes, we do.
I always prefer a paper copy.
we're trying to comply with the board's rule not to provide any written materials after 48 hours, right? So,
Some of us like.
we do
this.
have plenty of paper. We're happy to share if it's helpful to you. And I think you're likely to hear from additional testimony as well, that there are folks concerned that there's a deep dive into that specificity. You could do a dive into a lot of specific things, but this board has to do a summary. And so that may free up some space to get at what you're looking to accomplish in terms of the offices affected.
We're good.
Appreciate all your time. Thank you much.
Again, if we could have the opportunity to respond after further comments, that would be helpful. Thank you.
Question, Ms. Flowers, did you bring copies for all of us or did you just have the one extra?
Yes, if you would like one, we have more than enough.
Did-
We're old and we're paper people here, even though,
Oh, yeah.
I've
even
also,
though Chair Housecamp is.
I
a
also have
tech
a
guy.
printout of
Still love
the
paper. Thank you.
compiled law provision of the standard. Now that applies to the board today. So if anyone would like a copy of that MCL, happy to share that as well.
Mr. Doster. Before you start, I have to apologize to you. I just looked at your slip and realized that you had also put yourself on for one, and we moved the comment kind of section around. So my apology to you, but you're here now. Figured if it was important, you would have thrown something over at me, but
Well, it is kind of important, frankly. But actually, the
you
previous
log-
presentation
could
kind
you
of
log yourself
underscores.
in with the,
Oh, Eric Doster, on the public comment section first. But before I begin, there's been a lot of paper on the process today and the proposed summaries were prepared by the deputy director. I'm assuming, Adam, you're the deputy director and Mr. Brader is still the director? Okay.
That is correct, yes.
Okay, so I have a preliminary issue here that I wanted to address, and thank you, Mr. Chair. I wanted to address in the public comment, because I think we're kind of getting the cart before the horse here. Because on the board's agenda today, there are 3 items which relate to the approval of the petition summary. The simple reason why a petition sponsor seeks approval of the petition summary before circulation is to prevent a later claim that the petition summary is misleading or deceptive. In this area of the law, it is likely in malpractice not to seek this board's approval of the petition summary. But getting straight to the point here, if this board were to engage in the petition summary process today, this exercise would be meaningless because the Director of Elections is not here to prepare the petition summary language. And these matters are covered by the Michigan Election Code, particularly Section 482B of the Michigan Election Code, and I quote, "The summary of the purpose of the proposed amendment or question proposed must be prepared by the Director of Elections with the approval of the Board of State Canvassers," end of quote. Now, there are enough lawyers in this room So I will spare you the litany of statutory construction cases such that a statute must be enforced as written. But I would like to make 2 points on how Section 482B is written, the one that everyone here agrees governs the standards to this board today. In particular, the requirement that the proposal summary, quote, must be prepared by the Director of Elections, end of quote. First, please note that the statute states that only the Director of Elections may prepare this petition summary. It does not say the Deputy Director of Elections or the designee of the Director of Elections. And, you know, I just did a quick search, and there are plenty of examples where statutes indicate that a Deputy Director or a designee may act for a director. I'm just going to give you a couple. There's a bunch of them. MCL 331.41, the Director of Public Health and the State Treasurer may designate a deputy or other employee of the respective departments to serve as a member of the state authority in their absences. MCL 324.501, the Director may appoint one or more deputy directors and their assistants and employees as are necessary to implement this part. I'll stop. There's a bunch. We've all seen those before. But again, Section 482B states that only the, quote, Director of Elections, end of quotes, may prepare this petition summary. It does not say the Deputy Director of Elections or the designee of the Director of Elections. I understand that in our situation today, the Deputy Director of Elections is more than qualified to prepare the summary language. But that's not the point here.
Before you go too far down this road, we have a representative from the AG's office here. Is that a question that we would address to you, or is that a question that we would address to Mr. Francesi from the Secretary of State? I'm not sure where to address the
I
question.
would suggest that Ms. Deputy Director Casey go first.
Can I continue with my remarks?
I'm sorry?
Can I continue with my remarks?
You got a couple seconds left. Yeah. Go
Oh,
for
I
it.
do? Oh, that's right. Well, you can't, okay, I'll be real quick. I had some more stuff here, but you can't add words to the statute. The statute says the Director of Elections. So now that I put this out there, you can all do what you want. And if we do go forward and am forced to participate, I do so reserving any later objection to the petition summary approval process for the reasons that I started to get into. But the goal here is to avoid a wasted effort out of the sincerest respect for the process and the people that are here today. You know, and maybe Mr. Lidl would like to come back up, and that would give him an opportunity to fix that ambiguity in his proposal, come back when we do have a Director of Elections, and we can take care of this properly. So with that, I'm happy to take any questions.
Can we, this is what I'd like to do. We could give, Mr. Francesi, if we would give you and the AG's office an opportunity to address what's just been said, but then I would like to get back onto the to proposal 4.
So I can start and then obviously defer to Ms. Meingast. So I obviously am the Deputy Director of Elections, and Director Brader is, as a civil service employee, is entitled to specific benefits as a state of Michigan employee. One of those includes paid time off. And for leave purposes, as any other employee is under a variety of different statutes. So Director Brader is on leave currently. My position description specifically says, as Deputy Director of Elections, that I am to act in the Director of Elections place in his instance where he is unavailable or where he designates me to do so. So it is in that guise that I have been acting for that reason. As far as this specific requirement, Michigan election law does mandate that that the board approve or reject summary language within 30 days. Director Brader will be gone for longer than 30 days as he is entitled to under his leave benefits and leave rights as a state employee. So I'm happy at this point to kick it to Heather if she's got anything that she would like to add, but that's the piece that I can speak to at least.
I mean, if you're looking for a statute that's right on point here, there isn't going to be one, but I agree with everything that Mr. Fracassi has said. Otherwise, if we weren't able to designate or continue the board with its work, I mean, this would grind to a halt. So I don't think that's how the law would be interpreted. The law provides for additional assistance to the director, and the director is on leave. And I don't see how a court would conclude that this process must stop and that petition sponsors are not entitled to have their petitions processed according to the statutes. So kind of a new area for this. We haven't had this question before, but I don't believe that the statute would be interpreted to bar Deputy Director Fracassi from assuming these duties for purposes while Director Brader's on leave.
If I may respond, I'm not suggesting that the deputy director can't assume the responsibilities of the director of elections in the normal day-to-day functions of the director of elections. All I'm looking at is 42B, which says that the director must, and there is no or his designee, and it doesn't say, it says director of elections. It doesn't say Bureau of Elections. Where the Michigan Election Code refers to Bureau of Elections 16 times, but not in Section 42B, where it refers only to the Director of Elections. And and in fact, in Section 32 of the Election Code, they carefully distinguish between the Director of Elections and the Bureau of Elections. And again, there are cases on point where the proper person try to delegate their statutory required, they were the ones that were supposed to be there by statute to perform this duty, and they delegated it, and then those decisions were held to be invalid. So I don't, I'm not trying to grind the Bureau of Elections to a halt here by any means. All I'm looking at is the text of the statute, and the text of the statute makes this the requirement of the Director of Elections, and I'm not trying to cheat Mr. Brader out of his family leave or anything like that, or grind the Bureau of Elections to a halt. I'm just simply looking at the statute, looking at what the statute requires, and if you go forward today, you're not doing that, and that's fine. I put it out there. But y'all can do what you want.
If what we'd like to do is, it's noted in the record, it's part of the record now that
up
you've
to you.
made the comment. The only thing I would add to it before we move on is that it's been my experience on the board that the 100-word summaries that will be approved this morning will actually be products of the board's discussion. And it'll be the board that's actually editing and working with the 100-word summary. Is that a correct assumption?
I think that's correct, and I just want to clarify that what I said, like when Director Brader is out in all instances right now with the Bureau of Elections, I am the acting director in this instance.
Mr. Chair, if I may disagree, the statute says that the summary must be prepared by the Director of Elections with the approval of the Board of State Canvassers. Now, those of you who have gone through this process, you know, there's a lot of people throwing out ideas. And I know two of you have gone through, well, you actually all went through the process a little while ago, but people are throwing out ideas, whether it's coming from the attorneys, their consultants, the board members. But when I have been a proponent, a petition sponsor, I've always been quick to be kind of anal about this and say, okay, please let's have the Director of Elections
Speak to it, I understand.
and go back and because he's gathering, in this case, it was always Mr. Brader, was always gathering everyone's ideas. And that's the way the process is supposed to work. But at the end of the day, he's got to approve it. He's got to present it to you folks for your approval or rejection. Okay, so he's got to draft it.
From a practical perspective,
And you can't do that here.
but we have to get on with this proceeding. So your position is noted, but there's no action that we as a board can or will take this morning other than to discuss the petitions that have been presented, the 100-word summaries that have been presented. Are you asking us to stop our proceedings?
I'm suggesting that that's the only thing you can do, because the Director of Elections can't prepare the summary language for your approval or rejection. So I guess I don't understand how you can go forward without the Director of Elections here. I didn't write the statute. The statute says what the statute says. So I don't know how you can go forward.
We're going to do it.
Okay, if you're going to
Yeah.
go forward, fine. Okay,
What,
We can and we will.
okay.
Yeah.
yeah, we're good. So
And maybe some of the petition sponsors are going to want to pull their, because they would no longer have that protection. So maybe they would.
if they do, if any of the
Okay.
petition sponsors would wish to pull their petitions, they certainly will not have any argument at all from me. I promise you that. So
Fair enough.
having said that, though, you are also appearing here on ranked choice.
Would you like me to go to that part?
I would really like you to go to that
Okay.
part. I've been waiting all morning.
Okay, if I may call Trent England. Trent can identify himself while I pass out some stuff.
Would you turn on your microphone? It's a button at the base of the mic.
Red button right
And would you identify yourself for the recorder?
Trent England with Save Our States and Save Our States Action.
Is this the same one that we previously?
May I begin?
Absolutely.
Thank you. Thank you very much. Again, with me today is Trent England. In case you have any technical questions on how the ranked choice voting system would work, then I'm going to defer to Mr. England here from Save Our States Action. But members of the board, Eric Doster on behalf of Defend Your Vote, the petition sponsor here, Rank My Vote, proposes to create a new system of voting in certain elections, what they refer to as qualified offices, in the text of their proposal. In Michigan, elections are decided on the one person, one vote principle, in which each voter chooses one candidate, and the winner secures the majority or plurality of votes. By contrast, voters in ranked choice voting elections must rank candidates on the ballot. If no candidate wins the 50% majority, the race goes through multiple rounds of tabulation to eliminate candidates and redistributing votes. Ranked choice voting is a fundamentally different voting system. In our public comments to this board last week and provided again to this board just now, we offered a glimpse of what those ranked choice ballots would look like. Again today, I offer another glimpse of what the ranked choice ballots look like, and it's the attachment at the end here that says fundamentally different, and you can kind of see what the difference between what we are used to in Michigan, where you have like the straight party blocks there, and then this one here, the ranked choice voting, is from Alaska. It's the one pager that says fundamentally different. I find it more than interesting that Rank My Vote, the petition sponsor here, has not offered the board any glimpse of what these ranked choice voting ballots would look like. The silence is deafening. And as we referenced in our public comments to the board that we submitted last week and again today, the ranked choice voting proposal causes harm to the voting process. Ballots in the ranked choice voting system are more complex. That's evident by the example that I just gave you. This complexity leads to lower turnout rates, increased ballot errors, despite the increased costs of voter education by election officials must bear to inform voters how to navigate this new type of voting system. A second negative effect here is that ranked choice voting diminishes the impact of a voter's choice to utilize a straight party voting option. The rank choice, the rank my vote proposal does not clearly require that a voter can rank political parties like the voter is able to do with individual candidates. I know that there's some lip service that they give to straight party voting ability to rank, but it's not laid out like the way that you are for individual candidates. But even assuming that the voter is still able to rank their political parties like candidates, which I don't think that's exactly the way that's written. But at any rate, our research has failed to locate any state where ranked choice voting has been implemented statewide in those states that allow for straight party voting. So I don't have any data to share with you, such as from the NBC News report just a few days earlier on other items such as, and I quote, by analyzing over 3 million digital ballot records from over 150 ranked choice races in New York City, San Francisco, Alaska, and Maine, the research shows that in a typical ranked choice race, about 4.8% of voters mismark their ballots in at least one way. This necessarily means that Michigan, if this proposal were adopted, would become the experiment on the effects of ranked choice voting on straight party voting. But nonetheless, common sense and the research available would suggest that ranked choice voting would very much diminish and perhaps eliminate the straight party voting from a practical matter. But again, nowhere in any materials that Rank My Vote has provided this board is there any acknowledgement that the ranked choice voting effectively eliminates straight party voting. And this may be the only time that this board will ever hear me say that I wish Mark Brewer were here to talk about. Oh my God.
Careful what you wish.
Hi, Mark, I didn't see you. Well, I'd be interested in his comments on that. Okay, so maybe this won't be the first time I say that. But with respect to the proposed summary language, which is before this board, there are two consequences of ranked choice voting on voters that are undeniable and that no one in this room can seriously dispute. First, that inactive ballots in ranked choice voting races are eliminated. The Rank My Vote proposal refers to the eliminated ballot as a, quote, inactive ballot. These inactive ballots in ranked choice voting elections do not count towards the final tally. While many ranked choice voting ballots are thrown out due to voter error in following convoluted instructions, ballots that follow the instructions to the letter can also be thrown away because the voter ranked candidates who are no longer in contention. So as candidates eliminated through multiple rounds of tabulation, voters have their ballots eliminated if they only rank candidates that have been removed during the ranked choice tabulation process. The second undeniable fact of ranked choice voting, and that ranked choice voting delays the counting process. In our public comments submitted to this board last week and again provided in paper copy this morning, we offered numerous case studies illustrating that a ranked choice voting election can delay election results days and weeks. Well, now we have yet another example just this week from the New York City mayoral primary. New York City has a population of about 2.2 million, Michigan approximately 10 million people. And even though the second place finisher lost by more than 7 percentage points and conceded immediately the results or the election, the absolutely earliest that the ranked choice voting results from this basically no contest landslide election will be known is next week at the very earliest. So we have eliminated ballots and delayed voting results are two critical pieces of information that every voter must know before agreeing or disagreeing with this proposal. And as Rank My Vote told this board just 2 days ago in their written comments, quote, the proposal also must not omit subject matter that is needed to accurately apprise petition signers of what the petition does, end of quote. We agree. Accordingly, in our suggested changes, again, that we've provided to the board, it's the very last document and it's our suggested changes from the deputy director's language. You'll notice that we have added two of the undeniable facts that must be in this proposal summary. One that eliminated ballots, that talks about eliminating ballots of voters' choices if they're eliminated before the winners are computed, and the second one about delaying election results to accommodate ranked tabulations. Those are absolutely must. I certainly agree with the comments that I heard from the canvassers in the earlier discussion about some of these other things are, they're not dealing, ranked choice voting is the key here. And the voters need to know about ranked choice voting, and talking about these other activities or these other so-called rights that already exist that aren't really the thrust here. The thrust here is ranked choice voting. And this is supposed to be a constitutional amendment. So that's not, it's not an election code matter. So that's why I suggest that the first part's there, that we remind voters that this is a permanent system. Because the Constitution is meant to be permanent. I understand it can be amended, but it's not a simple statute. So, any rate, we've given our comments and thoughts on what an appropriate 100-word summary, and we're very close to what the deputy director has proposed. We agree with the proponents that allowing voters to rank at least 4 more candidates, that would be eliminated. But we're really close to what the deputy director has proposed to this board. But those two undeniable facts just have to be in there. Otherwise, we're not doing the voters any kind of service if we don't.
You open it for questions? Four days.
I appreciate it, Mr. Doster. I think that one of the main concerns I had here with, we've talked a lot about, what words mean to an average voter when they're looking at this in the past couple of things we've done. And I've seen, this, a right to ranked choice voting. And I agree, obviously the language in the constitutional amendment is clear that they now have this right. But this is an entirely new system of voting. So I think that I'm in agreement that we need to work in that this is a brand new system of voting in here somewhere, so that people understand that, yeah, you have this right, but it's not really an option. This is a new system of voting that folks will be seeing at the polls. I do have one question when it comes to eliminating ballots if voters' choices are eliminated before winners are computed. If a voter chose not to rank and just choose that one selection, does that ballot then become inactive? Is essentially, I guess, walk me through. All right, what if they just do 3? What if they get through all 5? What if their 5th choice is standing, but 2 through 3 are not?
Yeah.
Standing, at some point.
So, I mean, this is probably the most fundamental difference in the ranked choice voting system, is that it subtracts votes and really voters from the process. And this is why we argue that this should be made clear to voters, because this is so different, right? You are changing. The typical election is an addition problem, right? You're just adding 1 vote plus 1 vote plus 1 vote. You do it once, you come to a result, very intuitive. Everybody understands that. And I think that's one of the challenges that you have here, is you're trying to summarize a very different system using language that people typically use to talk about the kind of elections that we all understand. So in a ranked choice system, you're given the option to rank. Well, you're required to rank candidates. You're given the option of whether you're going to rank 1 or rank 5, depending on this language is not specific as to whether that it might be 10 or something. We've seen jurisdictions that do that, but So you can use all the rankings or you can use some number fewer. And what happens in the rounds of tabulation is that they add up the first place votes. And if no one gets a majority in the first place votes, then the rounds of ranked choice voting tabulation begin. If somebody gets a majority of first place votes, it just works like any other election, right? The rankings and all that doesn't matter. So if there's no candidate with a majority of first place votes, they go down to the least popular candidate, the one who received the least first place votes. They eliminate that candidate, which really means they eliminate all the votes for that candidate. And then on those ballots, they look, and they is sort of a euphemism. Obviously, all this gets fed into a computer system. It has to all be centralized for the election. And the computer says, okay, on the ballots where that least popular candidate was ranked first, is there a second place ranking? Is there a second ranked candidate? And if there is, then that ranking gets adjusted up to become a new first place ranking in the second round. If there's not, and this goes to your question, if there's not, then that ballot, that voter is removed from that election. And so what you'll see in New York is going to be a good example of this. There were almost 1 million ballots last I looked in the New York Democrat mayoral primary. And so right now they're saying, okay, there's 1 million ballots and the leader had 430,000, something like that. What you're going to see as these rounds of tabulation take place starting next week is that the numerator will go up and the denominator will go down, right? And so as they lop off the lowest performing candidate, they'll redistribute those votes. Some of those votes will go to the leader and they'll go to other candidates as well. But some of those voters will not have ranked a candidate second, so they'll disappear from the election. And every time you do a round of ranked choice voting, you have some voters' votes being redistributed because they rank someone second or third or fourth or fifth, depending on where you are in the process. And some voters will be kicked out of the election. And so both the numerator and the denominator change in every round of ranked choice voting. So does that answer your question? Okay.
So my question was very similar, and you've lost me, which is probably me, not you.
Oh, no.
Because
Oh, no.
I'm extremely confused at this point.
That's,
So are you suggesting that so if there is elimination as the process goes on, are you suggesting that the outcome is affected by?
Well, so there's a couple theoretically, right, yes. I mean, and that's why people are here asking for this, because they see this as somehow changing the outcome of the election. The reality is that particularly in partisan elections, and this is why, in my opinion, ranked choice voting has not been adopted. It's used in places for municipal elections, but it's almost never been adopted, Alaska and Maine being the outliers for partisan elections, because typically in partisan elections, you have two leading candidates. And so one of those candidates either gets a really big plurality or actually gets a majority. And so ranked choice voting doesn't matter. And this New York mayoral election, again, is a good example of that, even though it is a primary where everybody knows who the winner is going to be. Even though the ranked choice voting system hasn't even kicked in, they can't even try to start doing it until a week after Election Day, because you have to have all the ballots, you have to have all the data centralized before you can begin these rounds of tabulation. But everybody knows what happens. So as a practical matter, most of the time ranked choice voting actually doesn't matter. All that complication is just irrelevant, doesn't actually change the outcome. But it can, and you see this typically or more often in municipal elections, where you have a whole bunch of candidates and you don't have a clear leader. And so you might have someone who gets 25% in the first round, but as you start eliminating candidates, maybe most of the lower ranked candidates, voters, were aligned with the person who came in second. And so, as you start eliminating those candidates and shifting votes, the person who got second might get more and more and more votes. And in some later round of ranked choice voting tabulation, they might overcome the person who initially was in first place. Does that Is that helpful?
But ranked choice voting wouldn't occur that often, in a municipal level, isn't that correct?
Under this proposal, yeah, I mean, this proposal creates a local option.
Thank you.
Yeah.
Mr. Hurwitz. Would you like to comment? Question?
You know, I'm still trying to figure that out, but, the person, obviously, everyone who has a ballot has the opportunity to rank as many or as few. And so to say that that person's ballot is eliminated or that the voters' choices are eliminated is very puzzling to me. The voter makes the choice and that choice gets factored in with the choices of all of the other voters. So
Well, what's very odd though about this system, right, is typically we think of the right to vote as including the right to vote and have your vote counted for an unpopular candidate, right? And so, I could vote in an election for someone who winds up getting 3%, and in the final results, my vote shows up as one of the people who contributed to that 3% for my unpopular candidate, right? In ranked choice voting, your right to vote does not give you the right to have your vote counted in the final tabulation for it.
did you mean shown up in the final tabulation? How many?
That's
Wouldn't it be
right.
possible to?
Oh, yeah, it certainly would be possible. I mean, the only
It would be
reason,
possible.
yeah, the only reason why ranked choice voting eliminates those ballots is to create the perception of majority support for the winner. That's the only reason. I mean, you think about it. You could because you could have a system where if a voter just ranks one candidate, then you go through those rounds, and at the end, that voter is counted as having voted for that one candidate, right? That's essentially how things sort of work today, right? I vote for an unpopular candidate. At the end of the day, my vote shows up for that unpopular candidate. Ranked choice voting is absolutely unique. I mean, there's other systems, like approval voting, right? Other alternative voting systems that get proposed where you can vote for an unpopular candidate and your vote can still be tallied, recorded, reported as being cast for that unpopular candidate. Ranked choice voting wants to create, I think part of the sales pitch, right, is it creates I was going to say mirage, but that's pejorative. It creates the image that the winner has majority support, but it can only do that by decreasing the denominator of the election, right? Because otherwise you would say, well, these voters really wanted to stick with this unpopular candidate, so this unpopular candidate gets 2% of the vote, and so maybe the winner doesn't get 51% of the vote after 10 rounds of tabulation, they get 49% of the vote, right? That's how we do it today. I don't, it certainly is fundamentally different. We could debate whether it's fundamentally fair or unfair or just a kind of a marketing gimmick.
But again, as far as our proposed summary edits, we're not talking about some of these other effects of the proposal. We're not talking about straight party voting. We're not talking about majority illusion, whatever. We're only talking about really the two aspects that the undeniable aspects that the voters really need to know before they decide whether or not to support this proposal. And that again is this concept of the inactive ballot or eliminating ballot, whatever phrase you want to use, and the fact that election results are undoubtedly going to be delayed. So those two facts have to be in the proposed summary to do justice to the statutory requirements that are imposed upon this board.
A couple of questions, maybe an observation, and just in two buckets. Part of what I'm hearing and part of what I've read, and we've all done, I think, a tremendous amount of research on what ranked choice voting represents.
Mm-hmm.
It doesn't represent to me a change in a small change. It represents a sea change in what elections mean. For one, the thing I keep hearing is that you don't have a straight election anymore. Forget about straight parties. You don't have a straight election anymore. What you have is you have an election that has now averaged and homogenized and machine generated results. You have to, because it's going to go through a series of runoffs. So the machines are going to continue to homogenize it until we get to some happy center. We have a term for that. In the technology side, we called that fuzzy logic, where you don't have a yes and you don't have a no, but if you shade it enough and you play with it enough, you can find some happy medium. The other one, though, that strikes me more is voters. And I'm a voter, you're a voter. The other one that strikes me more is that voters in our culture typically rally around a candidate or a party. And so they learn as much as they can. They look where that candidate stands on the issue. Maybe they look at the other candidates a little bit, but they have chosen a candidate. We pick winners. We don't pick losers, we pick winners. What this amendment is proposing is that model changes radically. Now we are telling the voters, you kind of have to vote for everybody. And I know I'm paraphrasing that, but it's kind of you walk in and here's a series of candidates. Here's 4 or 5 candidates on the ballot. You don't select the candidate you want to win. You rate them all in terms of numbers, which means that a voter is going to have to learn about candidates. Maybe that's healthy, but a voter is either going to have to take a position of total ignorance, or they're going to have to take a position that they know something about these other candidates that qualifies them to make a choice. Is that a fair statement?
Well, I think that's right. And I think that's why, the data suggests that ranked choice voting benefits higher, voters with more access to information, more resources. I mean, that seems to be what's emerging as jurisdictions use ranked choice voting, is that it benefits high information voters and penalizes other voters. And it also, in these elections that go to multiple rounds of tabulation where it actually matters, it is sort of odd to conflate a 5th place ranking with a 1st place ranking and sort of claim, oh, this is the consensus choice because we, the last New York mayoral primary, we'll see what it's like this time, but they eliminated about 140,000 ballots, right? This isn't a small thing, right? This is 140,000 voters who went to the polls, cast a ballot, right? What they would think of as a vote. I voted for this candidate, right? Or maybe a couple of candidates. And yet you look at the final tally and they're not recorded as having ever voted, right? Their preferences do not show up in that final tally. And the preferences that do show up include people's, they conflate a 4th choice with a 1st choice, which I think is odd. And it's hard to capture, even the language that was prepared here, right? I mean, you talk about determining winners by counting votes in rounds, right? Even that is, should it be determine winners by counting rankings in rounds, right? To help voters understand, no, this is something different going on, right? Every time you say the word vote, I think people think of what we all think of, right? They don't think of what that means within a ranked choice voting system. So I think it's important to think through the summary in those terms, right? Every time you use the word vote or voter or election, are people going to draw the wrong conclusion because this is so fundamentally different?
I still, to me, this is a constitutional change to change the whole concept of what an election is.
Yeah.
There's not there's a lot of pieces in here that are designed to put lots of flowers around this thorn in the middle. Forgive me. I don't have any other questions.
There are a lot of things that are unclear to me in the proposal, particularly with regard to straight party voting. And then there's all of this stuff about undervotes and overvotes. But I think the most important thing for us is to get the essential aspects in 100 words, which is very hard. So you are suggesting that it essentially requires the proposal to say that election results will be delayed. That seems to me like it's, of course that's going to happen. I don't know that you really need to say that.
Oh,
Is that,
you absolutely have to say that, because that is the fundamental of this new system that we're creating. I mean, voters, if a voter reads all the materials, whatever, let's say you take that out, and all of a sudden, we have a situation like in New York City where we don't even know the results for another week. We know the results, the second
know the
place consent,
results.
but officially,
strangely enough,
and I don't even get into, Ms. Gerwitz, I'm not even getting into I would have no idea how to recount this thing by hand. It would be impossible. But I don't even get into those kind of weeds. But if we were not to tell voters, if they signed this petition and then they voted yes, and we did not tell them that election results would be delayed, how are we not advising them of the subject matter of what this proposal does? That to me is a fundamental aspect of this proposal. Now, do they say that in the text of their proposal? Of course not. But in a way they do, because they talk about all these tabulations
right?
and so in a way they kind of do, but they don't come out and say that.
Well, and I think the other way in which they actually acknowledge that is, it seems to me clear that that's why they're moving the primary election, because I mean, because of these delays, right? The primary schedule, if you're going to use ranked choice voting in an August primary and then try to have a November general, right? There I think would be some concern if you have any races that need to be recounted. In particular, that would, become a huge challenge. So I think it is actually implied by moving up the primary that, the proponents here clearly understand that this is going to delay election results, and particularly in any case where there's a need for a recount, delay election results in, what I think people would consider in a kind of an extreme way.
It certainly makes elections more complicated.
Yeah.
I'm not insensitive to the attraction of it. In my congressional district, my representative is there with 27% of the votes, which nobody is happy with. However, that's, I guess, not what we're really considering today. I do want to say that, though, because I understand the idea that that this is not a good result, and what kind of result, how could we get a better result? So we're trying to figure that out.
Yeah.
But we're trying to figure out how to describe this proposal in 100 words. Without wasting words describing
correct.
things that don't need to be described because they're already part of election law. So thank you.
Thank you very much.
Don't thank you, Mr. Doster, for all of this business about us being unable, but I recognize that you are a passionate advocate. And
you.
I really appreciated your graphics in your position letter.
Oh, you like that? You like the Rube Gold?
Yeah, that was so nicely done.
Thank you.
Thank you both.
Thank you for your time.
There are no other attorneys representing official positions on petition 4. So now we get to we get to switch the game up here, so to speak. We're going to have general public comments. If you are, I'm sorry. Oh, you know what? Yes, we actually have we are going to take a 10-minute recess and let you folks walk around a bit. Meeting is adjourned. We'll be back in 10 minutes.
Meeting is not adjourned.
Forgive me. Totally wrong. We will be back in 10 minutes. Mr. Doster, you almost got your wish. The canvassers are back in session. Take a seat, please. We're going to begin a general comment section. Some of you folks have asked to speak to more than one item. We're going to let you speak to one item. So when I call you up, if you've got two items listed, I'm going to ask you which one you want to speak to. You get to make a choice. You have 1 minute, and the time is going to be held to 1 minute. And with that, the first individual is Sherry Ritchie. Would you state your name and would you spell it for the recorder? And before you do that, you asked to speak to 4 and 5. You're okay. Good.
Good morning. Is it still morning?
Would you spell
Not sure.
state your name and spell it for the
I
recorder?
shall. Thank you. Good morning. My name is Sherry Ritchie, and it is spelled S-H-E-R-E-E. Last name Ritchie, R-I-T-C-H-I-E. I am here representing Pure Integrity Michigan Elections today. So much to say and so little time. I'll just say that for everyone else here as well. I'm going to focus on the point that the summary has to accurately represent all the implications of the full amendment. It is difficult. We're in a rock and a hard place. The point I want to emphasize the most is that as I have analyzed ranked choice voting, the biggest point to me is the fact that some votes or ballots will always be discarded, not counted, as Mr. England alluded to, Mr. Doster alluded to, and explained. That is the biggest issue, and voters need to know in this summary that some votes are always discarded. It's a fact. Thank you. Is that all? I'm
That's
sorry.
it.
Cut off? Thank you so much.
Thanks for your time. The second person up is Kate DeYoung. Now as you're coming forward, let me add one more little piece here. Just to reiterate, the focus of this whole board this morning is not to decide whether ranked choice voting is a good idea or a bad idea. Our purpose is really twofold. One is to come up with 100 words that accurately describes what the petitioners provided us in their written petition. And the second job we have is to bless this petition or to not bless it because it has form errors. None of those things are things that mean it's a good idea, bad idea, I like it, I don't like it. So just kind of in perspective for your comments.
Sounds good.
Ms. DeYoung, would you state your name and spell it for the recorder?
Yes, Kate, K-A-T-E, DeYoung, D-E space J-O-N-G. So thank you for letting me speak. I'm a volunteer and field director with Rank My Vote. I came over from Grand Rapids. First, I wanted to highlight how the ballot summary uses over technical language that risks confusing the very people it's meant to inform. We all agreed, I believe, that rank at least 4 more candidates than seats is dense, it's overly technical, and opting for simple language, clear language that voters read without having to parse or pause or reread or just plain give up on should be the goal. On another note about the New York City delay and the language that apparently has been proposed to talk about delays in the 100-word summary, releasing results in New York City late, a week away, is an administrative choice to withhold results. They are waiting for absentee ballots to be turned in. That is not actually the best practices that RCV proposes.
Thank you. Jordan Green. State your name and spell for the recorder, please.
Good morning. My name is Jordan Green. I'm also from Grand Rapids, and I'm a volunteer with Rank My Vote. The summary says that candidates are eliminated in rounds, but it never explains how a winner is actually chosen. And this is a critical piece of information. Without it, voters are left with an incomplete picture of the system. More importantly, it could be misread to imply that elimination is automatic and disconnected from a voter's own ballot. In reality, the process continues until one candidate receives a majority of votes. The word majority needs to be included in this 100-word summary. Voters who want to see their vote represented numerically on TV can simply make note of the number of votes cast for the first preference choices. For the rest of us, ranked choice voting actually simplifies the most important part of this process, deciding whom to vote for. By requiring a majority through RCV, voters can finally vote their conscience rather than voting strategically against the candidate whom they most fear.
Thank you.
Thank you.
Jad Hamdan? If I mangled your name, forgive me. You're gonna spell it though and announce yourself, so I'll know.
My name is Jad Hamdan, like Chad with a J, if that's helpful. J-A-D, and then the last name is H-A-M-D-A-N. Ham like the meat, Dan like the name is usually how I say it over the phone. Good morning, thank you for having us. I believe the ballot summary does not give voters a clear or honest understanding of the proposal, specifically the misleading part of the summary that claims voters will be required to rank candidates. This simply is not how ranked choice voting works. Voters can choose to rank as many or as few candidates as they want, including just one. To be clear, no one is forced to fill out every line. Use of the word require is not only inaccurate, it could confuse or discourage people, especially first-time or less confident voters. They may believe the system is more complicated or demanding than it really is. The summary should reflect how the process truly works, not introduce fear or misunderstanding. Accurate wording is essential when explaining new systems to the public. The use of the word require is misleading. Also, to address a previous point, even in non-RCV elections, it takes time to certify the election. In the case of RCV, in fact, the majority of RCV jurisdictions, 79% release RCV results within 24 to 48 hours. I do not believe it needs to be stated in the 100-word summary.
Thank you, sir.
Thank you.
Kate Grabowski.
Good morning. I'm Kate Grabowski, Kategrabowsky. I'm a volunteer and the other field director from Rank My Vote, and I'm from Royal Oak, Michigan. I am especially concerned that the Bureau summary leaves out two critical voter rights that are clearly included in the actual proposal. The proposal guarantees the use of secure paper ballots in all elections. And I will say you can hand count ranked choice voting. It's not hard. One of our volunteers had their 4-year-old do it. And it affirms the right to write-in candidates. These are basic and meaningful rights that voters care about. The summary does include some rights, like voting if you're in line when the polls closes, but only listing a few gives the false impression of the summary that this is a full list when it is not. In a previous statement, it was talked about that informed voters participate more, but RCV actually encourages more engagement by voters, and it can have, current studies suggest 10% increase of voter turnout. Voters deserve to know the complete scope of what this proposal includes, especially when it comes to protecting their rights. Thank you.
Thank you very much. Cindy Twiddell. Did I pronounce it or did I mess it up? Yeah. You know what? It was a. No, we don't start the timer until you've, this is like a horse race. When you clear the gate, we start.
Make sure your mic is on.
There you go.
All right, can you hear me? All right, Cindy Twitchell, CYNDI-TWICHELL, Twitchell. Hello, and thank you for letting me speak. My name is Cindy Twitchell, and I'm here to speak on behalf of myself, both as a voter and a longtime teacher of the Constitution. I have led many Constitution classes over the years, covering both the United States and the Michigan constitutions. Our constitutions are written documents that tell the government what it can and cannot do. It does not give us our rights, it protects our rights. I have claims about the establish a new right. Ranked choice voting is a choice on how to do a process. It's not a right to have to do. So I wanted to clarify that, and I think that needs to be clarified. Also, I really would like the board here to take careful consideration and concerns of what the others are recommending in the summary to be revised, because to accurately describe what the voters are actually voting on. Voters count on these short ballots to summarize to help make informed decisions, and the wording you are voting on today does not fulfill this important, especially where it states a new right. Thank you.
Thank you. Linda Butler. Would you, there you go. Perfect.
Linda Butler, Linda Butler. Thank you for the opportunity to speak on the ranked choice voting summary. The phrase counting votes in rounds, eliminating lowest ranked candidate, oversimplifies RCV's instant runoff process. It omits how votes are redistributed until a candidate achieves over 50% of active ballots. This lack of explanation risks confusing voters about its complexity. A clear summary should briefly note the majority threshold to accurately reflect the process. I urge the board to revise the summary for greater clarity to ensure voters are properly informed. Chair Hauskamp, you stated correctly that this is a sea change, and the petition summary should reflect this. Our citizens will no longer be voters, they'll be rankers. Thank you.
Arnold Singer.
Morning. Ronald Singer, Ronald, Singer, Singer. Thank you for allowing my comment on the petition summary. Some of this will seem a little bit repetitive, but it's important. The requirement to rank at least 4 more candidates than seats is unclear, omitting whether ranking is mandatory or how partial rankings are handled. The amendment allows flexibility for fewer rankings, but the summary's vagueness risks confusing voters about their obligations. This fails to meet MCL 168.482B's clarity standard. A clear summary should state voters may rank up to 4 additional candidates or fewer if desired. I respectfully request the board to revise the summary to clarify ranking rules for voter understanding. Thank you.
Shelley Lake. Thank you.
Good morning. Oh, good. It was left on. Helpful. My name's Shelley Lake, Shellylake. I would like to thank you for allowing me to speak today to the board. I emailed the letter that I just handed out on behalf of the clerk and me, the deputy clerk from Irving Township in Berry County. I realize it was at 4 p.m. on Wednesday, but the wording was changed, so it's a little late. I hope you will still take it into consideration. We all know most voters do not read the entire amendment, so they really count on this 100-word summary to help make their decision. I ask that the board take into consideration from a clerk's perspective and also a voter's, but the changes here, and not approve it today so that it can be revised for a future meeting, and it can be edited to adequately meet statutory clarity standards as well as to remove vague and ambiguous descriptions. Thank you so much.
Jacqueline Eubanks.
Okay, so to spell my name, Jacquuelyn. Last name Eubanks, Eubanks. I'm a concerned citizen of Macomb County. Thank you, Chairman Housecamp and members of the board, for allowing my comment on the RCV petition summary. The summary omits the amendments requirement for secure and accessible paper ballots preserved for certification, recounts, and audits, which is a key voter right reinforcing current Michigan law. This omission renders the summary incomplete, failing to meet the law's requirement for an accurate and complete summary. Voters deserve to know all major provisions, including this critical safeguard. I respectfully request the board revise the summary to include secure paper ballots for audits to fully reflect the amendment's intent. Thank you for your time.
And a guess on the last name again. Cynthia, is it Chaby? Chaby. You know, it wasn't bad. I didn't pick up the printing there. It was a little off, so.
Good morning. My name is Cynthia Chaby, CYNTHIACHABIE. I'm a Northville Wayne County voter, and I speak only for myself. Thank you for allowing me to give public comment on this summary. My concern with the summary is that it lacks the clarity needed to explain to the voter exactly what she is asking to amend the Constitution. It fails to explain the outcome of the process. Section 11B1 states that if there are more than 2 active candidates, the active candidate with the fewest votes is eliminated, and the vote for the eliminated candidate count for each ballot's next ranked active candidate for the public office, and a new round must begin. This process is not clearly explained in the summary. I understand there's a limit of 100 words that the petition signer is reading in order to make an intelligent choice as to whether or not she wants to sign it. Every petition signer deserves a clear understanding of the ramifications of the law for which she is petitioning, but she does not get one with this summary. Thank you for listening to my concerns.
Thank you. Mark Smith.
Dare ask me how to spell that.
I would never do that. I could have had a Y, you know.
Good morning. My name is Mark Smith, M-A-R-K.
Good deal.
You can sing along if you want. S-M-I-T-H. Yeah, I'm the current chair of the Michigan Fair Election Institute's Benzie County chapter, and I'm also the chair of the Benzie County Republican Party, and I'm here on both of those groups' behalf. Chairman Housecamp and members of the board, thank you for the opportunity to share my public comments with you this morning. I should be out on the dock with 4 grandkids fishing, so that's how seriously I take this issue. But yeah, there's a couple of things. The phrase, and you've heard this all day long, but the phrase counting votes in rounds, eliminating lowest rank candidate and redistributing the votes simplifies the instant runoff process, but omits critical details such as how a majority is achieved or how ties are resolved. The amendment details that votes are redistributed until a candidate achieves over 50% of active ballots. The lack of specificity risks voter confusion about the RCV's complexity, failing the clarity requirement. I ask you to change the wording of the summary. Thank you very much.
Thank you very much. Darlene Hennessy. Thank you, Mark.
Hello, my name is Darlene Hennessy, DarleneHennessy. Chair House Camp, members of the board, thank you for the opportunity to speak today. I'm from Wayne County and I'm speaking for myself. The summary is riddled with vague, ambiguous, and overly complex language that will confuse voters. It states that voters will rank candidates and votes will be redistributed in rounds, but fails to clearly explain how and when a voter or winner is determined. The phrase allows voters to rank at least 4 more candidates than seats is mathematically confusing and offers no clarity on what happens if voters don't use all the rankings. In addition, moving the primary to June or earlier is vague with no explanation given as to why. Thank you for this opportunity.
Thank you. Dorothy Cribbs.
Hello, I'm Dorothy Cribbs. That's spelled DOROTHYCRIBBS. And I want to thank you for giving me the time to speak. I just had distributed to you earlier a definition I got from my 1987 dictionary on majority. Now I looked at that before the language was changed, but I think majority is really important to have in there. And not everybody understands majority is 50% plus 1 vote. And I was going to speak to that and say that needs to be clear. My dictionary also gave an example of 3 candidates, 500, 300, and 200 votes. That the candidate that got 500 votes isn't a majority. He needed she needed 501 votes. I also think that the whole concept is confusing, and the 100 words is supposed to simplify so the voters can, know whether or not to sign the petition. This is a complex change and confusing, and that's you can't really simplify it for an understanding. I needed to see a video of how this actually would be implemented with like 10 votes on 4 things. And it's just, it shows how things are going to go wrong. So, or be confusing.
Thank you very much.
Thank you.
Lisa Capatina. Did I mess that one up too?
No, you didn't.
Outstanding. Thank you.
Good morning, Chairman Housecamp and members of the board. My name is Lisa Capatina, LISA-CAPATINA. I'm representing myself and grateful for the opportunity to provide comment. As a citizen who served many times as an election inspector and currently serves on a county board of canvassers, I have witnessed the magnitude of voter confusion, frustration, and sometimes anger created by process change and unclear language. In the current RCV summary, the phrase counting votes in rounds, eliminating lowest ranked candidate, and redistributing votes is too simplistic. It fails to explain to voters the actual complexity of the process, both in voting and also certification, for which even I, as an experienced elector, find difficult. This language risks misleading voters, violating clarity requirements, adds ambiguity, and subsequently diminishes already lower voter confidence. I respectfully urge you to consider revising this summary to ensure it meets the intended goals of clarity and accuracy for every Michigan voter. Thank you.
Catherine Bissard.
Hi, my name is Catherine Bussard, Katherine, Bussard, Bussard. Thank you, Mr. Chairman, members of the board, for the opportunity to speak here today. I am very concerned that the summary fails to inform voters of how votes will be counted. The language, quote, determine winners by counting votes, end quote, is simply insufficient. It deceptively omits the description of the new system of determining the outcome of all elections where RCV is utilized. Furthermore, the form of the amendment does not really clarify whether a standard of majority or plurality will inform who the winner is in unqualified races. These are questions that voters deserve answers to. Second, there is a problem with the language that is proposed because it inherently conflicts with existing provisions of the Michigan Constitution, particularly Article 2, Section 4, Clause 1, the right to straight party voting, which is enshrined there. If the Board of Canvassers allows this language to pass without remediation and the proposal is adopted, we'll have two conflicting standards on equal footing, leaving a judge to decide. And quite frankly, nothing could be more undemocratic. Thank you.
Thank you very much. Melanie? Without? You know, I would have pronounced it right, but they run on each other here. Nivelt? There you go, okay. I was trying to make out a V there, and thank you.
Okay.
This is on?
Go
Yes,
for it.
okay. Melanie Nivelt, Melanie. Nivelt, NIV as in Victor, ELT, Oakland County, representing myself. Thank you very much for allowing me to speak today on ranked choice voting. First, the phrase limited local elections, which vaguely refers to municipal elections adopting RCV via charter, omitting the amendment's population threshold of 25,000 for certain offices like county commissioners, as undermining the clarity required by MCL 168.482B. Secondly, like many have spoken, requires voters numerically rank candidates. If they do not rank all candidates or skip one ranking or assign same ranking numbers to more than one candidate, they run the risk of their ballot being thrown out, effectively disenfranchising them with their right to vote. We don't want to disenfranchise voters, not now. We're trying to encourage voting. So thank you very much. I appreciate your time and your consideration.
Thank you very much. Michael Ross?
Morning, and thank you for the opportunity to be here. My name is Dr. Michael Ross, Michael, last name Ross. And my main concern here is this language is confusing, and I'll exemplify. First off, the term qualified offices does not specify whether we're talking about federal, state, or local offices, for example, senator, U.S. senator, governor, county commissioner in larger jurisdictions. And that confusion carries through with this whole piece. As previously mentioned, this is a radical change in voting. And it should say that right in here, that this comprises a radical change in the way we have voted in Michigan and in the United States, so that the voter is put on alert that they really need to scrutinize the language to make a good decision. And that's all I have to say. Thank you.
Thank you. Thomas Nemechek. Mind if I give a studio word here before you? The next individual after Mr. Nemchek is Artisha Baumer, and I'm told on her note here that she's in the overflow room. You're here. Good. There you go. That's what happens when you don't. Yeah.
Good morning,
Your minute. Go for it.
Chair Housecamp and members of the board. I appreciate the opportunity to speak this morning. I'm not sure who drafted this language, but it appears they are not familiar with Michigan election law because no less than 2 sentences are included which are presented as new voting rights which are already codified in Michigan compiled law. I am not an attorney, but as a certified election inspector for many years, I am obligated to know and understand Michigan election law. In contract law, implying a new benefit that already exists in order to induce voters to sign a document is called fraud in the inducement or fraud in factum. And I am pretty sure that the Board of Canvassers would not support fraud in a ballot proposal. MCL 168662 already guarantees timely notification. MCL 168720, right to vote when in line when the polls close, is already codified in law. The counselor for RCV stated that these are newly specified constitutional rights, which they are not. This appears to be an unfunded mandate on the state and in particular municipalities, which, thank you very much for your time.
Thank you.
Good morning, committee. May I be heard? Okay. My name is Artesia Bomber, Articia I drove here 1 hour and 19 minutes to get here to speak on behalf of all disabled Michiganders. The reason why I say this is because if some of you are confused and the people behind me, some of them are confused, then what makes you think disabled people will not be confused? And they are voters too. Also, I would like to say that we have disabled Democrats, Republicans, Libertarians. I'm sure you catch my drift by now. So this is not a party thing. This is a lack of understanding thing. And we still have issues of fraud, irregularities, mishandling of our elections. And this sounds like padded security for our current clerk. By the way, I'm running for Detroit City Clerks, and this would be very hard for me to explain to the voters in one session. So I would ask that you guys table this instead of saying we're going to vote against it or this and that. Just table it. Have a conversation and see out of the eyes of a disabled person who don't understand anything that this proposal is saying.
Vice Chair Gurwitz has just asked me to re-clarify one more time that what we are here to do is not approve or disapprove of anything in the petition. Did that state correct accurately?
Table it. We have a job to do to try to make it as clear as we can in 100 words.
Okay, but this 100 words is not clear for disabled people. That's what I'm saying. Like you guys are confused with the language.
Right.
We're gonna work through that now.
Yeah.
So you're
We're
saying
going
that
to
there's
work
no
through-
such thing as your job cannot table something?
I'm sorry?
Okay, I'm sorry, Madam Mary Ellen, are you stating to me that it's your job to do today to allow this 100 word, and you're saying that you cannot table this? Isn't that what committees do?
That's correct.
So that's you cannot table it.
No, we cannot.
Okay, thank you.
We might like to. We cannot.
Okay, thank you. And when will Brader be back?
I'm sorry?
When will Brader be back?
He's on a parental leave. He'll be back in a few weeks, I believe.
What did you say, Miss Mary? I can hear from one
Oh, I
person.
said he's on a parental leave and he'll be
Okay,
back
thank
when
you.
that
Okay.
expires.
Didn't take 3
Thank you
weeks.
very much.
You guys, I'll see you guys again.
We have reached the end of the public comments. I'm sorry? You were up here before though, sir. Give you 1 minute.
Thank you for
Restate
indulging
your
me.
name.
Board Fred Nienstedt, FredNienstedt. Simply put, I would like to make a proposed change to the deputy director's proposed wording. In the middle of the paragraph, it states 4 more candidates than seats, and then the word two. I would like to replace the phrase be nominated/elected. So strike be, strike nominated, strike elected, and replace with determine a majority. It is apparent to me that this perceived right is that majority be specified. It is clear to me that in a local civic election for council, city council, if there are 6 candidates to be elected, there is a definite dilemma if
Thank you for
15
your comments.
candidates run.
Right. Thank you for your comments. I would, Ms. Francesi, did you have anything you wanted to?
Yes.
Funny I should ask, right?
Yes, I think it might be helpful if I can find my agenda where I put the language first, but to walk through why I did what I did. Thank you. Sorry, I have a sea of paper as well now, and so so I think it might be helpful to kind of walk through why I drafted it the way I drafted it, respond to some of the comments as well. There are plenty of things that have been said, some of which I agree with, some of which I do not. So I think it might be helpful to kind of explain some of that a little bit, and then we can, obviously, you can tell me kind of whatever thoughts that the board has as well. I will also try to keep it brief myself. So we've already kind of talked about the primary piece already. The only other thing that I will say about the primary versus the general, as I read the text of the constitutional amendment, there's my agenda. As I read the text of the amendment, like I said, how general election is defined under election law. In my reading of it, that is the current everyday meaning of general election, and that the current everyday meaning of general election today is, I interpreted it as defined by election law. There are several provisions in Michigan's constitution, namely Article 12, which deals with constitutional amendments themselves when they appear on the ballot, Article 6, when judicial vacancies appear on the ballot, as well as Article 2, which is when petitions appear on the ballot, that use the exact same phrase of November general election. And election law section 2 has been passed to define those sections as meaning the November election of the even year. So that was why I did that. I am open to some wiggle room with some language with that, but I don't think that it is accurate as this is written to say all primary elections are moved, period. That's my read of the Constitution as it is now. As far as there's been discussion as far as authorize, I think it might be easier if I start at the beginning of my language. So I use the phrase establish new right to ranked choice voting. That new right was intentional. The state currently does not have ranked choice voting in elections. Some local charters have it, but they're not using it because state law does not allow them. Let me rephrase that, because state law has provisions that conflict with ranked choice voting, a couple of them. This obviously, the constitutional amendment would override those state laws. So I used establish new right because for that reason. I've heard the board previously say you want to say specifically like this is a new right versus something that we're shifting into the Constitution that currently exists. So that's why new is there. As far as qualified offices, I used qualified offices purely because of space. It's safe space. It's defined in the constitutional amendment. I am open to putting specifics in there to say for federal offices and saying the other state offices. I don't think it's accurate to phrase it in the sense of most federal, state, elections, because it's not most state elections. It's actually very few state elections. It's 3 offices technically, because governor and lieutenant governor appear on the ballot together. You're not ranking governor separate from lieutenant governor. You're ranking them as a pair. So it's really only 3 state offices that is separate from local. But I'm open to fleshing that out more. The next clause for determine winners by counting votes in rounds, et cetera, I put that in there because that's what I thought was the clearest way to try to explain how this is going to go, how the process would work in everyday language. I've heard a lot of discussion on whether or not majority. I think there's a little bit of question as to what is a quote unquote majority, as I'm understanding, and I hope I'm not misrepresenting what Mr. Toster has argued, so please correct me if I'm wrong. But if I'm understanding the arguments around majority, it's correct to say that it's a majority in the round, but it may not necessarily be a majority of the votes cast overall. And I think that's essentially what Mr. Doster is arguing. I did not use majority partially for that reason, but also I don't see the words majority in the Constitution itself. I don't see 50%. There is language that says, and forgive me, that talks about the threshold, an election threshold. But even the election threshold doesn't say that you keep going until a majority is established. The election threshold just says the minimum whole number of votes needed to be nominated or elected. I don't interpret that as one thing or the other. So that's my hesitation with the word majority in that specifically. The next piece, I skipped one actually for require versus authorize. I used the word require because what the text of the proposed constitutional amendment specifically says is under section 11 sub 2, it specifically says the ballot must permit an elector to numerically rank candidates for election to the qualified office using ranked choice voting. Meaning that for the offices that are covered, voters have to be presented with the ranking. All they will see is candidates' ranks. So I used the word require for that purpose. The Constitution does not require you to vote. You can just, like any other time, any other election, you can go and you can leave it blank. You can vote for, you can rank one person, but that rank is still a rank. You're still saying if Adam is the person that is my top choice and I don't want to rank anybody else, you're still ranking me as number 1 versus, and then just leaving the rest blank. So when I hear the word authorize, that suggests to me a permissive, in the sense that the voter is going to have some other option to vote for the office of governor other than ranking, and they won't. It's either rank or leave it blank in that situation. So that's why I used required. I'm open to different words in that if there's a different verb that we can agree to, but that was why I didn't use authorize. The allow voters to rank 4 or more, I put that in because that's specifically in the Constitution. As I read the amendment, it applies to every rank. It applies to all offices that are going for ranked choice voting unless there are not a sufficient number of candidates. But I tried to put that in there because it provides voters an idea of what they're going to be presented with. What's the difference that they're going to see? So if we wanted to look for changes for that, that's fine. And I'm also open to in the next clause, authorize local charter to provide use in limited local elections. I think that there's a couple of things, and somebody has provided from the audience that kind of tighten that up a little bit as well. But the point of that I was trying to get across with that is that local jurisdictions get to determine whether or not they want to use ranked choice voting for their offices. This constitutional amendment doesn't mandate it. It's up to the locals to determine whether or not they want to do it. And then a couple of the other things that I've heard, I don't want to get into some of the discussion about delaying election results or anything like that because I think that's a hypothetical. I don't know sitting here today whether election results will be quote unquote delayed. I don't know what that looks like. I don't know what folks would define as a delay. There's a canvass period. Is a delay defined as going beyond the canvass period? Is that defined as going at after 8:01 p.m.? I think there's a lot of ambiguity with that, and I'm not sure that any suggestion of delaying election results is accurate, to be frank. So I didn't get into any language with that. Sorry, I'm just looking through my notes to see if I had anything else. I think that's everything at a high level. It's kind of why I wrote the language the way I did. The last piece that I will say at the very end where we talk about that in the clause that says recognize voter right to timely notice. I use the word recognize because that is, again, this concept of you're establishing a new right because it is something that doesn't exist currently. And then the verb recognize means that this is a right that exists currently under election law that is being shifted from election law to the Constitution. So that is specifically why I use the word recognize there versus new elsewhere. I will say that if we're looking to add some provisions, for example, if we want to expand qualified offices, which is something I think I've heard both the boards say they're interested in and also many members of the audience, I would strike that clause out because that is not a change that voters will see. If you're looking to focus, which is what I tried to do, I try to focus on what is the change that voters are going to see. Voters currently have a paper ballot that are maintained under federal law for a certain period of time, under state law for a certain period of time for local offices. You currently have the right to vote in line if you are in line at the times polls close. So if you're looking to expand more on these changes, I would strike that clause altogether so you can expand on qualified offices, for example, and things like that. So I have been listening and hearing drafts. I am happy to, I defer to the board how you would like to handle it. If you would like, I can kind of walk through some of the suggestions that I would recommend based on what I've heard. I can pause and just keep listening and you tell me what you want to hear as well. So with that, I will kick it back to you and let me know how you would like to.
Very deliberately left your explanation until we got through everything else, because that was a good choice. You presented it extremely well.
Appreciate that.
But there's a comment too that in everything I've heard this morning, there's two things happening here to me in this petition. There's a whole list of rights that are now going to be ensconced in the Constitution. As you just pointed out, those are not rights. In effect, those are not new rights. Those are rights that are legislatively, statutally, you already have those. And then there's the real heart of this, which is the section on ranked voting. And so what I see in this 100-word summary is that's what's really changing. We're not changing paper ballots. We're not changing counting. We're not changing standing in line. But we are really seriously changing the structure and the nature of how somebody casts a vote. And so the way that the 100-word summaries has been drafted, you have focused 78 of those words on what I see as really the truly, you could take everything else out of here. It's the ranked choice voting. And I think that's got to be pulled out of the weeds, and that's just my 2 cents. And with that, it's questions, comments? I would say that we move from your explanation to us deliberating and trying to decide what the final 100 words looks like. So, and then from there, we'll break for lunch. And then when we come back, we'll go on with the afternoon. How does that sound? That work for you? Excellent.
I have one question too, because, you know, as I've looked through this, I've got a couple of additional thoughts that I'll share with the board. What is your opinion on how this affects straight ticket, straight party voting? Because if we're talking about explaining the changes of this, you're right that the ranked choice is the heart of it. But if we're talking about the massive changes that are coming to voters, you know, that would be a significant one for Michigan voters. What is your take on that?
I would put that in the category of things that we would need implementing legislation to clarify. So different provisions obviously require straight ticket voting in a November general election. And then you've got rank choice voting in this instance. So if somebody walks in and votes for the, I'm not going to use a party name, I'm just going to say the blue party, or pick a purple party. How about that? So we're being completely neutral, right? And you've got a list of candidates. What's unknown sitting here is, if I vote straight ticket, does that equate to rank 1 and nothing else? I don't know the answer to that, is the long story short. So that is something that I think would need to be flushed out in implementing legislation. And I don't know how I would put that in, to be frank, as well.
Are you suggesting that we should put that in, all that out specifically in the 100 word?
I think that if it is going to drastically affect people's ability to vote straight ticket, I mean, that's a massive thing for voters. Now, I don't know how to explain that in this, but
I don't know if it will.
It can affect the right to vote straight ticket, because that's a constitutional right. I don't know how it works, but it can't take away the right to vote straight ticket.
But it could be an implementation.
It's very confusing. That's just one of the confusions. So I agree with you that we don't need to waste words recognizing rights that we already have, because we only have 100 words. I'm sorry. Yeah, we only have 100 words. So we don't want to, I don't think we need to spend some of those words recognizing rights we already have. Mr. Lidl has come up to tell me otherwise, but no, but I was speaking before Mr.
Yes, you were.
Oh, right.
I don't want to belabor anything, but it appears as if some members may not be aware of the language in the actual proposed constitutional amendment with regard to straight ticket voting. So I'd point you to section, it's on the second page, subsection 5, D. If an elector votes using the straight party vote option under 41C on a partisan general election ballot, the ballot for the public office counts as one vote for the highest ranked active candidate nominated by the selected party, unless the elector indicates a different preference for that public office on the ballot. So it is specifically addressed. The legislature has a duty to implement things that it does not fundamentally alter or take away the right to straight ticket voting anyway. It explicitly recognizes your right to continue to straight ticket vote. Remember, even under the current system, you may vote a straight ticket and and then choose to vote for a candidate of another party. And this language specifically permits that in the proposed constitutional amendment. So I hope that's helpful for you on straight ticket voting.
We recognize that it's there. It's still confusing.
Vice Chair, would you like to continue your?
Yeah, I agree that we need to define qualified offices, and I've been trying myself to figure out how to do that. So I think it should at least say all federal offices. And then I was trying to figure out the most efficient way of saying state offices, because it's only, as you said, really 3. So you could say state offices excluding legislative and judicial offices.
I actually, I've kind of, one of the changes I had and I've been tweaking with, I actually just put in governor/lieutenant governor, because it's by striking that last clause, I have enough room to say all federal governor, lieutenant, and kind of spell that out a little bit more.
And, okay, if you, is AG one word?
I have it spelled out as
Or
attorney
would
general.
you said Attorney General and Secretary of State?
Yes.
Okay, if we have the words for that, I think that's really important. And I also think, I agree with so many people who said that it's important to get to the point where you say that that after you're redistributing votes until a candidate receives a majority. And I understand that you have some difficulty with the word majority, but I think that most people would understand what that means. It is very difficult to explain this in 100 words, as I think everybody recognizes. I wondered about eliminating lowest ranked candidate and redistributing votes. I wondered if we could say something like redistributing that candidate's votes.
Yeah, I'm thinking, sorry, I am listening. I'm looking at what I have and just thinking, sorry, I am paying
So
attention.
when you're redistributing, if you're eliminating the lowest candidate, you're redistributing that person's votes, right? I don't know if that's a clarification, but it's a possibility. But I do think that there needs to be an endpoint, and that endpoint needs to be a majority.
But am I correct in assuming by eliminating the vote, what you're really doing is you are shrinking the number of votes that have been recognized. So if there's 100 votes recognized, and if Mary Ellen votes for a candidate that's now been eliminated, and we go to another round, there's really only 99 votes being recognized. Is that?
No, because I have a vote.
You voted for someone that didn't win.
No, right, but then I have a second vote.
If you choose
Or a
to
third
rank.
vote.
If you
Right.
choose to rank.
If I don't, then that's my choice. But when you get to the second round, if my first round candidate has been eliminated, my vote for the second round candidates.
Theory being is that still, even if we're using one voter, whether the number of voters is not changing. The number of votes being counted is changing in the final. You're changing percentages.
So how I can kind of, so in the city of East Point actually had to use ranked choice voting as part of a consent judgment and local election several years ago. So I can kind of say how it worked in East Point, and then I think this is actually my understanding as to how the constitutional amendment would work as well. If you go in and rank, and there's 4 candidates, and you rank 1, 2, 3, 4. Let's say you put all 4 in whatever order your preference is. As the lowest vote getting candidate, as we calculate that, the lowest vote getting candidate is knocked out, for lack of better terms, from winning. So they're kind of eliminated. And then you go to anybody who put that person as number 1 on their ballot, you go to their number 2 choice. If they did not put a number 2, and they only said Adam was my number 1 choice, Adam got the lowest votes, then there's nothing left to tabulate for that voter. that voter is not removed from the election or anything like that. So
Right.
that's the one piece I want to make clear as well. Votes are not also being deleted or anything like that. They will still be recorded, but on the results then they show up as either like an exhausted ballot or an undervote or et cetera. Like that shows up on the tabulator tape the same way as it does now. So it would show up the same way if you go into any other office that's not covered by ranked choice voting. So let's say you go for state senate and you don't cast a ballot for state senate. The tabulator is still going to read that a ballot was cast, but then it's not going to have that ballot result for that specific race because there's nothing to count. In that instance, the same would be true with here. The tabulator in a rank, even if you go in and vote and don't rank anything, because reasons, whatever reason that somebody may have, it's the tabulator still going to reflect that 500 ballots went through the machine, and then it's going to calculate the totals for the specific rankings, et cetera. I hope that answers your question, but if not, please let me know.
It does. It also underscores exactly how complicated and confusing this section of this petition is.
Which is why I tried my best to summarize it as eliminating lowest rank candidates and redistributing votes until that winner is selected.
No, I think you,
Because it's in 100 words, it is difficult to kind of flush that out.
you,
I don't know what I said. That I agreed with you, Mr. Dastra. I'm surprised.
yeah, again, this is a very difficult, this is like trying to rewrite the laws of gravity, right? I mean, it's.
So
Is it helpful if I?
we're working on some things, and you've incorporated, and I think the comments were really full. Yeah,
To frame it out, yeah.
yeah.
Is it helpful? Would you like me to
So, yeah,
read
so-
that? Would you like me to print
Yeah,
it? Is that helpful?
Right, if you've got a,
Okay.
right,
Do you want me to read it or print it or
why don't you print
both?
it?
Can you
Print it? I can print it.
Thank you.
Give us a couple minutes and we'll print it.
Thank you.
I'm sorry. We are, I'm not sure we're going to recess, but he's going to print something off here in a minute. If I recess, everybody's going to get up and walk around and I don't want to lose the time.
Yeah.
That isn't.
Okay.
Yeah. And.
Yeah. We have 3 or 4 sets of this now. We have 3 or 4. Here, hold on.
You're allowed, because you don't have to. You don't have to rank. Yes,
Yeah, okay.
yes. So
Yeah.
I'm okay with allow.
Yeah.
I just
and-
authorize sounds submissive to
I
me
agree.
in a way that a law allow does
Yeah.
not.
Yeah,
So that's not in here, but because
That's
we've already
fine.
started.
Yeah,
I'm
that's
okay
easy.
with that.
okay.
I did put majority in.
Yeah.
If it seems like everybody might agree with majority, if everyone would agree. Oh, yeah, I'm okay. I could be wrong. So.
Yeah.
Everybody agrees with that? I'm okay with saying it. Okay.
Thank you. That's weird.
And then what? Let's.
Yeah.
I don't know, we don't have this one, but. Oh, that's why. Here we go. Okay, that's cool. Okay. Put it on legal and we've got, oh wow. I don't even think it can hold legal paper. Like, I don't think it's big enough to hold legal paper. I know, we're baby steps. The printer worked, so that's good.
Are we, I've got a copy of it right here. And so we can reconvene? Or we, I mean, we can continue our discussion. How's that? Can I push one out there that's probably just gonna put my foot right in the middle of it? Start,
Be on the record or no?
yes,
Okay, can we, just so Marcy knows,
I mean,
call us back, yeah.
you guys wanna sit down or, yeah,
Folks, we're back on the record. Need like a big buzzer.
I think that's just moving around. You all understand we're in session, right? We're good, okay. I have a question on the first line. Constitutional amendment to starting in 2029, establish new right to ranked choice voting. And right there, I'm hung up on that. Because you're letting the word right come in there, but in effect, it's not a new right. People still have the right to vote. I mean, this is a modification to how voting is done. To me, that comes through. I mean, if you tell me I have a new right, I think of something as a new right. I get something today that I didn't have yesterday. What you're really saying, though, is you're saying you have the right to vote. We're just going to change the way that your voting process is.
So you would say,
Am I looking at it the wrong way?
So the reason I use new right is, yes, you do have a right to vote. Your right to vote in general is not new. I think that is fair how you phrased it. The reason I said new right is because you have a new right to vote using ranked choice, like using this ranked choice method. I'm also, with that being said, if you want to, if the board is comfortable tweaking and just saying like establish ranked choice voting or something like that, like I think you could do something like that as well and still be accurate.
To me, the clarity with the general public is, I think we need to tell them that this constitutional amendment is fundamentally changing the way that voting is done in Michigan. Now, maybe that's only for some elections, but nonetheless, it's changing.
If I could, yeah, I agree 100%. I guess this is, you don't, it establishes new right to ranked choice voting. It almost seems like, okay, well, I've got that right. I don't necessarily have to use it. You have to vote ranked choice. There's no other option when you show up there. And I really feel like that needs to be very clear in the front line. You may have I've got a Second Amendment right to bear arms, but I don't have to carry a gun. When I show up at the polls, yes, I may have this new right to ranked choice voting, but I also don't have a choice. I have to vote ranked choice when I show up.
You don't though, right? I mean, maybe I'm missing something. Can't you just vote for one?
you don't have to rank.
You don't have to rank. Is that right?
Well, you're ranking either way. Even if you only vote for
Rank.
one, you're still ranking. You're just simply ranking one.
That's true.
Yeah,
Can I maybe,
Because the process of counting is going to count in a ranked fashion.
right.
And the process of eliminating and the process of redistributing, whether you vote for one rank or whether you vote for four, is moot.
The way it's counted,
Sure, this is part of a whole
Right.
process.
right?
can I make a suggestion?
Absolutely.
Based on that, I would, what if you collapse the first two clauses together, so that establish new right, and continuing through require, because I've heard a little bit of hesitation with the word require. If you move the word require up and say require ranked choice voting for all federal offices, governor, et cetera, and then replace that require with allow voters to numerically rank candidates, does that address the concept that for these offices, you are going to be presented with a rank choice versus just one, but then you get to decide whether you want to rank all of them, none of them, one of them, two of them. And I can repeat it or I can whatever.
I'm still hung up with using the word right in that section.
I would
Right, he would eliminate, put.
Be eliminated.
require,
Okay.
yeah.
I would
To require
Yeah.
ranked choice voting
Yes.
for all federal offices. Governor.
Okay.
Yeah,
Yes.
so it would, right.
I would say
Yeah, I like that. And then change the other require to allow.
yes.
We've still got this allowing to rank it for more candidates. Legal ones.
I'm sorry.
I'm sorry.
Oh, forgive me, I'm looking down. Would you like to approach, sir? Thank you. I get in less trouble when I look down. Go ahead.
Just wanted to make a couple of things, understand where the board is going. Don't want to belabor anything. A couple of things that you may want to consider as problematic. One, majority. That's just simply not accurate in multiple candidate elections, which ranked choice voting would be permitted here. So for example, it's a city council election. And there are 4 candidates on the ballot for 2 seats, and it says vote for 2 seats. Who gets elected? Each of the candidates that receive 25% plus 1 votes, right? So I think that's why in different scenarios you've seen majority. I think we refer you back as an alternative to the language that we had suggested on this, because I think that would be inaccurate. I think one word that might be clearer than redistribute is reallocate. You're not sort of redistributing actual vote, you're allocating which candidates receive them. So you might consider reallocate versus redistribute. I think there's a technical issue with unless insufficient number of candidates file, right? The number of candidates appear on the ballot based on the number that qualify for the ballot. There often are more candidates that file than qualify. And we think an alternative to that, at least 4 more candidates statements that we recommend is just to say until the candidate with the most final round votes is declared the winner. I mean, that is how you answer the question, how exactly do you determine a winner in ranked choice voting? Well, you can count in rounds until you identify the candidate with the most final round votes, and they are declared the winner. So there, a piece there. Again, the even year, you have guidance from your Assistant Attorney General in terms of what the Constitution means. I'll disagree with the Elections Director. I totally agree that the term has a meaning for purposes of the election law as used in this act. The case law is the opposite. Because it's used in the election law, it may be the plain and ordinary meaning for the director, but not the general populace. And my recommendation is to create words, just leave it out. And if voters want details as to which elections are you talking about, look at the text of the proposal. I think that's it in terms of the technical issues. But with that, I mean, with those couple tweaks, I think you could say some more words on the second to the last phrase where the directors indicated, or deputy directors indicated, move August primary to June or earlier. Nope, I'm sorry, I'm backing up one more. It is authorize local charter to provide use of RCV in municipal elections in jurisdictions adopting RCV. I think you could just do that in fewer words, consistent. Authorize local charter ordinance to provide use of RCV And I would probably say local other than municipal. Some folks don't consider counties municipal. And just leave it at that, and that would save a few words, but keep it in the intent of what the good, generally good recommendation you have from the director. Anything that I missed, Olivia?
No, so you could, when you eliminate that, eliminating the four or more candidates works in conjunction with adding the, how you reach the conclusion. You would do, right before determine winners, you do, allow voters to rank multiple candidates, determine winners by voting in rounds, and then you conclude it with how they, the candidate with the most final votes wins.
There's a lot of words there that you could condense down. I think if you look at the markup that Olivia shared, it essentially would read, allow voters to numerically rank multiple candidates for we may not say qualified offices, rank candidates in order of preference, determining winners by counting votes in rounds, eliminating lowest ranked candidates by redistributing votes until candidate with most final round votes declared the winner.
That fixes the number and then the number of candidates issue.
It's whether it's the final round.
Well, you'll have, like on many of these provisions, you'll have to look to the details. I mean, and it's essentially once the election threshold is reached, that's why you don't see a 50% because it could
So
be
it's
local
the final
elections.
round when you reach the threshold, but not when you reach a majority. Is that what you're saying?
Right. If it's a straight up,
Oh, but it might.
we're going to
but the
elect one
threshold
person
is-
for this office, it's a majority. If it is, we're electing two candidates among four for a multi-seat race, it's 25% plus one, right? And that's why you can't really just use majority. And I think the term election threshold is a little confusing. And I think on any of these things, it is a significant change. You know, it's a structural change in how voters select the people they elect to office. Under the current law, it's you pick one and say no to others. It's a binary choice, except when you have multi-candidate races. Here it is, we're going to elect our, determine who's elected based on our order of numerical preference. Who do we like the best in order, right?
You come back to exactly what I keep saying.
Yeah.
This is a structural change
Uh-huh.
in how the people of Michigan
Yeah.
will elect their leaders.
Correct. Yes,
And that's
This
why
is
we
a
think
massive
that,
change in voting.
it is. And that's why the director's summary indicates new and that it's clearly different and for which offices. And if folks want more details when they're signing the petition, flip it over. That's why the legislature mandates the inclusion of the text. There's also websites and folks promoting, something or indicating statements opposing. But for purposes of a summary, right, it is pretty clear that it's new ranked choice voting. It's a structural change, but it is not something radical that's never been done anywhere else, right? It's done in other jurisdictions in the United States, and democracies like Australia have used ranked choice voting to determine their elected leaders since for over 100 years.
Yeah, but that's
Okay.
that's going in a different direction still.
Sure.
This is again, we're taking people's
Yeah.
voting rights and we are taking them and putting them aside and replacing it with something else.
It's not taking their voting rights, it's allowing the people to exercise their constitutional right to choose the manner in which they select candidates for election to public office or nominating as candidates for public office. The people have the right under the Constitution to say, I'd rather choose my candidates by ranking them in order than versus one versus another. There are pros and cons with each. You know, any member of the board may not like it. Other folks may not like it. They have an option, right? Don't sign the petition. Feel free to encourage others not to. Don't vote for it, right? The purpose here today is to summarize what this does. I think the director's pretty close. I think there's those technical things that we would adjust. And I think, with a couple of revisions, you might very well be at a place where we would say, hey, we don't believe there's any legal issues. And, this is something that we could, not be opposed to or be supportive of. And you can move on to your other two items for today.
No, I understand what you're saying, and forgive me for my redundancy. I'm trying to put it in my own head.
Right.
You're not adding something to the party. You are swapping something that exists at the party with something else.
You're changing for certain elections the manner in which voters indicate their preference for who will serve in the public office. There are some folks that say, look, I'd rather just say yes or no. There are others that would say, you know what, I would really like the ability to say, hey, I like some of these, let me rank them in order of preference, right?
Well, that's where you and I disagree. I mean, that would be like playing a game and having two completely different sets of rules. If it's a ranked election, the voter is obligated by default to rank.
Well, what I'm saying is the voters have decided to change for the state, the system, that's a constitutional amendment.
Okay.
And they are
Okay.
explicitly
Yep,
saying it's a
you are
right.
correct.
But again, if a voter wants to vote for one candidate, they're free to do that. They can vote, they can rank one vote for one candidate. That occurred. Many folks that went in the New York mayoral primary and voted for one candidate, they didn't rank others. They may have. They have the option, right? If I really like one candidate, I'm going to put all my eggs in one basket. In the current system, you can vote for a candidate who is not elected, right? And so here you can rank your orders. It is a difference, but it's not a deviation from your right to vote. You still maintain the right to
As a
vote.
pure aside, while they're working this out for you as an attorney that practices challenges a lot,
Sure.
this is going to be an interesting set of,
I mean, it's different,
yes.
but I don't fear change or different, right? You know, you could say, oh, look, monitoring elections, it's going to be radically different if we decide we're going to have early voting and we make changes to same-day registration. That's going to make different. It did, right? And folks
Changes the
adjust,
landscape.
right? There are many folks say, I disagree with that policy change. They shouldn't have done that, or I disagree with. In Michigan, the first sentence of our Constitution is all political power is inherent in the people. And if the people decide to change the manner in which they elect candidates for office, that is their constitutional right.
And we are trying to come up with a way to
Right.
present it to them. in a way
Appreciate your
that
work
they can make
today.
That choice. I think we're.
So, in general, I agree with most of what Mr. Liedl has said. I've made my point with the primary election, so I'm not going to repeat myself with that. I think just by, like I've already said, I think you can start it off by saying require ranked choice voting for these offices, et cetera. Like we've already talked about switching allow. And then, so I'm going to bring it over a little bit more so we can see. And then I think you can, I agree with the switching with redistributing, reallocating. That makes sense to me as well. I think it is a little bit more precise to say that. I'm also fine with adding in that, do it with some other tweaks to pick up some words that until candidate with most final round votes is declared the winner. That I think does get at it. I put majority down and I completely agree with Mr. Liedl. It's not a majority, especially when, like he said, when you get down to that local level, it's not a majority of anything, whether it's a final round or overall. It's just not a majority. So in addition to everything, I agree that I don't think majority is precise enough or accurate in how it will work. So it does make sense to me to have in there to say reallocating and redistributing votes to active candidates until candidate with most final round votes is declared the winner. And then I think you can also pick up, like Mr. Liedl has suggested at the end, and kind of clarifying that local jurisdictions get to decide whether or not they want to adopt this. And they want to adopt the use of ranked choice voting in their elections. So I think you can pick up some words with that. I'm happy to print out another copy with what I've done, but yeah, that's kind of in general how I've.
I apologize. One minor thing that I missed. If you free up words, you might consider spelling out Lieutenant Governor. I think the common ordinary meaning, no disrespect to Mr. Gilchrist, of LG as a home appliance of some kind, right?
That is.
Yeah. So if you have a word, you might suggest spelling it out.
Mr. Dosser.
If I wouldn't mind getting a copy as opposed to throwing out comments.
Yes,
now.
I will.
The process, if I could see where we're at now.
Would you like
and
my
then look-
copy?
Is this what?
You got another copy?
Do you mean a copy of what I just read?
Yeah.
Right,
so
or like what
I-
I just talked about, I
you
should
just
say?
talked about, so I
Yes.
could see that, and I'm just trying to be as orderly a process here, because I could come out and throw out a bunch of stuff too, but maybe a lot of what Adam's already got there, we're okay with. So
I'm fine. Yeah.
I'm just trying to be
By
orderly
blah,
here.
blah,
No,
blah,
that helps.
until.
Yeah, so we'll print them.
No, but start by saying determine winners and. Oh, okay, so.
Oh, that,
Okay, so you're not using winners at the beginning and the end, okay.
all right, then.
This is up here.
Press-
This is.
Yeah.
This, you know what?
You spelled lieutenant wrong. I can't spell lieutenant. I specifically didn't put lieutenant because I don't want to read it. Yes, yep. Yeah, I think we have to.
You just wait for the print.
Yeah.
Good.
It's Friday.
Are you full? Oh, my God.
I brought a shot. I thought. Not wearing a jacket today.
I would have given it to you.
So now we get their copy. That's fine. That's fine.
Yeah.
Yeah.
Um, All right, we almost had a final. Hang on. We're almost there. All right. Mr. Francese, will you read the last final draft?
Sure. So I have Constitutional Amendment 2, require ranked choice voting, and then in parentheses RCV, for all federal offices, governor/lieutenant governor, attorney general, and secretary of state, allowing voters numerically rank candidates starting in 2029. Count votes in rounds, eliminating lowest ranked candidate and reallocating their votes to active candidates until candidate with most final round votes declared the winner. Should be is. Allow voters to rank at least four more candidates. Thank you. Sorry. I'll start that sentence over. Allow voters to rank at least four more candidates than seats to be nominated/elected, unless insufficient number of candidates. Authorize local jurisdiction to adopt use of RCV in local elections. Move August primary to June or earlier in the even year. Require legislative funding and implementing legislation. I'm going to pause because I know we've already kind of, and even as I was reading out, there's a couple of things that I already want to tweak. We had talked about one, I think right at the beginning, I think you need to say allowing voters to numerically rank candidates starting in 2029, just to make that sentence a little bit more grammatically correct. And then continuing on where it says until candidate with most final round votes, I think it should say is declared the winner. Again, to make that a little bit more grammatically correct. And then at the last, move August primary to June or earlier in even year elections is what has to, again, kind of tighten that a little bit. So, but I defer also to,
Good.
That would take us to 197.
Mr. Dusser, would you like to comment?
Yes. What was that first phrase, Adam? I see the constitutional amendment to require ranked choice voting. Were you going to amend that at all? Because, okay, because that's
The only piece I was going to amend in the third line down where it says numerically rank candidates, I want to add the word to before numerically. So it would read,
okay.
allowing voters to numerically rank candidates.
Okay. The only suggestion that we have, and that's to accommodate our prior comments and also the comments of many of the people you heard today, they need a better description of what this system is. And in the 1, 2, 3, 4th line, where it says eliminating lowest ranked candidates and reallocating their votes to active candidates, I would add a few words saying, because this is what the process is, and removing inactive ballots. And then the rest of it's fine, until candidate with most final round votes declared the winner. The rest of that's fine. So I'm just suggesting that we talk about the process, and the process does require the removal of inactive ballots, and that's right in their constitutional proposals, so they can't argue that that's not part of the process. So I would just add the phrase after the word candidates and removing inactive ballots.
I think that it's hard to understand when you start talking about removing ballots. And I know that this is something that we were grappling with earlier, but the ballots are not eliminated. The votes for that particular round are reallocated, but the ballot is still there, and
Do we
there
want,
will
would
be
you rather
other-
say, and not counting? Because they're not counted.
They're not
They're
counted.
no longer
They're not
considered.
counted for that particular candidate, but then you move on to other offices, right? And then that ballot still there and it's counted for whatever other thing the voters are ranking their ballots.
But we're only talking about this one particular, we're trying to let the voter know what this process is, and that is an integral part of this process. So if you want to say not counting instead of removing, because the ballot doesn't go away and get disintegrated, okay.
Mr. Lidl, what were you going to suggest? Looked like you guys were agreeing. I wanted to see what was going to happen.
Think, getting at the concept, I agree with Member Gurwitz, ballots is probably wrong. There's an entire ballot with lots of races. You might say remove candidates and have a couple other comments on this latest version, whenever Mr. Dostler has had a chance to present everything. But anytime there's an instance where folks agree, I want to try and emphasize that. So I think generally remove inactive candidates. Those candidates are no longer being included in the counting process in rounds, but ballots.
Reallocating the votes to active candidates, removing inactive candidates? No, but
The actual language of their measure defines an inactive ballot as a ballot that does not count for any candidate for the remainder of the count for a public office for the reasons described in subsection 6, which describes
No, I
ballot
agree.
exhaustion.
I think ballot might,
I mean,
I like the debate, but I think ballot might.
It is awkward, but it's awkward right from their awkward proposal, right? I mean, that is, and I don't say that pejoratively, right? Like I debate this all around the country, and it's hard to find words to describe this process, but exhausted ballot or inactive ballot is the term of art that's used by ranked choice voting proponents, because in that particular election for that particular office, the ballot is considered exhausted, it's inactive, it's removed or not counted or what have you. I mean, that's, if you go to a pro ranked choice voting description, that they'll describe it that way.
yeah, I understand that it's technical language in RCV, but it's not, when you talk about an exhausted ballot, that's not a concept that is going to speak very easily to a voter. Going to have exhausted voters.
I mean, I mean, you could say something like, eliminating the lowest ranked candidate, and I was trying to find some way to loop in, eliminating the candidate and eliminating the ballot or the votes cast for that candidate, if, or reallocating their votes to active candidates or something like that. Maybe there's a way to push those things together.
Even the term active candidate, I think, is a little bit strange. So eliminating lowest ranked candidate and reallocating their votes to remaining candidates, I think actually.
That's exactly what I was about to say. Remaining is better, yeah.
Remaining's fine.
I'm never going to finish.
We
just keep.
We have 2 more still, so just FYI.
It almost is, active could almost be changed to remaining.
Yeah, so
That's what we.
yeah, I'm fine with changing active candidates to remaining candidates.
Hear it in my own ear.
Oh, right, okay.
No.
I was talking that way instead of this way.
No, you were okay. I was agreeing with you. I was saying that, yes, it could be changed to remaining. Yeah.
Okay.
I should have restated it.
And I will say, as far as like, I don't agree with putting ballots in there. If we want to go down that road, I would want to use a different word than ballots, because I think the average person, I understand it is technical to say an exhausted ballot. Like, I know that is technically how it works. I think the average voter will hear that. Yes, and I think the average person will hear my whole ballot's going to get thrown out versus just the votes for this office. So if we want to say something like that, I'm okay with considering something, but I would say something other than ballot. I'm not sure what the right word is, if it's removing inactive or, yeah, I think it should be something like ranks or vote. I'm not sure about inactive either, but like something along that lines. I know I'm not precise myself right now, but that's kind of where my mind's going.
Allocating their votes to remaining candidates.
Yeah, I think it's fine. I don't think it needs anything else.
No, all they're doing is
Disagree
just,
with Mr.
they're
Dawson.
just putting.
Yeah, that's what I'm saying. What if we suggested that reallocating
Just-
any
That's what she's saying. No, we're both saying the same thing. I'm repeating back to you what I
Yeah.
think I hear you
To
leading to.
I know that's what just.
I've got that one already done.
And removing inactive ballots. Okay, they don't like the word ballots and removing inactive
I
choices,
think we make the changes.
removing inactive votes.
And I think that we're at a point where
Yeah.
we're starting to get diminishing returns here.
Reallocating.
Okay, are we all in agreement that if we make those couple word changes, we're gonna go through them with you? Yes, yeah, with these changes. Yes, would you? I would like you to read it with those changes that we just talked about.
It would read constitutional amendment. Apologies. It would read constitutional amendment to require ranked choice voting in parentheses RCV for all federal offices, governor/lieutenant governor, attorney general, and secretary of state, allowing voters to numerically rank candidates starting in 2029, count votes in rounds, eliminating lowest ranked candidate and reallocating their votes to remaining candidates until candidate with most final round votes is declared the winner. Allow voters to rank at least 4 more candidates than seats to be nominated/elected unless insufficient number of candidates. Authorize local jurisdiction to adopt use of RCV in local elections. Move August primary to June or earlier in even year elections. Require legislative funding and implementing legislation. And that would be 97 if I can count correctly.
Folks all good?
Again, you're omitting that integral part of the process of removing the inactive ballot. And if you don't like the word ballot, perhaps vote. But that's an integral part of the process, and you're just kind of skipping over that.
As opposed to,
I don't think saying that changes the understanding of any.
But it's not in here if you don't put it in
integral,
there.
it's implied with the reallocating their votes, isn't it?
but- Right, Mr. Lidl has a
You want to say reallocating and removing?
removing.
Well, you're ignoring it. I mean, you're just not, you're not using it.
Of course you're not, because you don't use it in this.
But how do you know that from this summary?
Yeah, no, Mr. Lidl, we should have 4 chairs installed. Mr. Lidl, if you would like to, if you don't mind standing, sir, then I would, or maybe we could.
So I think the possible answer to Eric's question is, how do we know, right? There is some language that says we reallocate their votes to active candidate, right? So that kind of describes the process of, like, you would cast some votes for some candidates. They're no longer applied, they're reallocated elsewhere. It probably is close enough for a summary, right? I will just point out a couple technical issues. And one recommended change that would clarify, I think, for everyone. So the first new phrase at the beginning, require ranked choice voting for all federal offices. There are certain instances where it will not be required. Let's say we have an incumbent governor running for re-election unopposed. There's one candidate on the ballot. The language of the Constitution.
No, I get where you're going, but no, here's the deal. So if we're gonna have this conversation, I'm gonna make a ruling from the chair. We are limited to talking about the issue of whether we are reallocating their votes or whether we are throwing out ballots or what. No, we are not going back to that front. I appreciate what you're saying, but that's closed. It's on the record multiple times.
No, this is something new.
Oh, I'm sorry. This is a new one. I thought you were gonna go back to require. Okay.
The director in this version. There are certain instances including for governor, attorney general, secretary of state, will ranked choice voting will not be required. So you have now created a situation where it does not apply. The specific language says that in the instance where there's, you know, basically one candidate for a nomination or election.
If they just struck all, would that solve it?
Yes.
It just indicates it's the default,
Yep. Yep.
but not
Yep.
every instance.
Yes, it would. That's a good
And
suggestion.
it saves a word.
Yeah.
Just strike the word all. It just say, yeah, it saves you a word.
Yep.
No, I would not do that either, because I don't think that's, yeah, that word all is it's attaching to a different piece here. I understand where you're going with the idea that there could be an election that only has one candidate.
Beyond that, it's that the constitutional amendment proposed actually provides for such situations and says that voters won't be ranked votes, right? So you're saying it would apply in some instances, it wouldn't. If you drop the word all federal offices, it still means all federal offices, right? I agree with folks from Save Our States, right? So I think that is a fair change that does not change the meaning, but also corrects the technicality. One other technicality, use of the word seats, right? Members of legislative bodies, city council, et cetera, are elected to seats. They're seated in a legislature, right? The folks like the attorney general, there's not a seat of attorney general. There's not a seat of secretary of state. So I think it's technically not right. I think it would be better just to say than positions as a technicality. And then one substantive change that I think better explains to voter exactly what this is. We say numerically rank candidates. Numerically rank them by what? How tall they are, right? How old they are, right? Yes.
We had before in order of preference, and we
Right.
seem
I
to
think
have
you could
eliminated
add
it.
By voter preference would be 3 words, right? Instead of 4, in order of preference. You could add that rank by voter preference. It may require, it might get you right to 100. But with that, I think you've got a summary that rank my choice vote to support. We do think it's, if you're explaining to voters, what is this whole new process? Well, you're gonna rank them by what? This one looks better than that one, right? Oh, this one is closer to me than that one, but we're ranking them by voter preference. Under our ranked choice voting scheme. I think that is clearly indicated in the text.
I think it's implied, but.
I think it's implied too. That's what I was gonna say on rank.
Like the sexiest, but.
Voters could rank them by height. It's,
That's
Thanks
it
for that, Heather.
That's it from us. There's 2 technicalities. I mean, again, I'll just note again for the record. You've been advised by your attorney general that it is not clear that this does not alter elections in odd years. I encourage the board to proceed consistent with advice from the attorney.
back to the question that we were on before. I think I have a one
Here's the
word.
deal. You guys are running out of questions really
Okay.
quickly here.
Well, I just think that phrase reallocating their votes to active
Could you speak
candidates.
up for me?
Oh, sorry. That phrase reallocating their votes to active candidates. I mean, if it said something like reallocating any remaining rankings to remaining candidates or something like that, that just makes it clear that you're reallocating them where they exist, and where they don't exist, you're at least tipping people off to the fact that they're being eliminated, right? I mean, it'd be better to say that they're being eliminated.
Remaining.
Yeah, reallocate remaining votes?
Yeah, remaining vote. Yeah, remaining votes. Yeah, exactly.
Their remaining votes.
Their remaining votes, reallocating their remaining
Giving them at
votes
least a hint of what the process is. It's not
yeah,
that clear.
to
but-
to remaining candidates. But yeah,
I know, we're trying. Good. That's not true. That's not true.
I think the statement reallocating their votes to active candidates is or to remaining candidates. Oh, Scott, yeah. The remaining candidates is extremely, it says exactly what we're doing.
Yeah, I think so too.
I'm fine with that.
To their remaining ranked candidates?
I'm sorry?
I mean, because I'm just trying to find out how we get
You're
the
working
concept
still on
of.
the ballot line. You're still working on the idea of
Yes.
throwing out ballots.
Yeah, I'm not bringing up other stuff. I'm
No,
still,
no, that's okay. That's where that's what we're trying to get to here. But,
what's your suggested change?
I like to their remaining rank.
say again, say that again.
Because that is to their remaining ranked candidates.
Getting votes to their remaining ranked candidates. I think that does help make it a little bit, it's not, I mean, it's a little more clear about what's going on, even if it's not totally clear.
Well, yeah, I'm fine with that.
Doesn't matter. I am okay with saying, I'm gonna read what I have, so I'm not making it up and misspeaking.
Sure.
I'll use this one because it might be easier to hear me. Reallocating their remaining votes to remaining candidates until candidate with.
No, not remaining votes.
That's what I'm hearing.
I think it was
Reallocating their votes. to
reallocating,
remaining ranked.
I think it's reallocating votes to their remaining
I
ranked
guess I don't
candidates.
understand what the difference
that-
is between what we have and that then.
I think I think what it says here is rather than active or remaining candidates or whatever, it attributes like it at least personalizes it to the voter, which is their it's their ranked candidates, right? And specifies that, okay, well, like they said, there may be a chance that they don't have any remaining candidates left. So it at least signifies to them that is a potential where they would run into an inactive ballot.
Remaining ranked candidates.
These touches upon it.
Remaining ranked candidate.
Can I read it again to make sure I'm understanding then? So it would say, eliminating lowest ranked candidate and reallocating their votes to their remaining candidates until candidate with most final round votes is declared the winner.
No,
Remaining ranked.
Got an extra there in there, I think.
remaining their votes to remaining ranked candidates.
To their,
Remaining
Reallocating
lowest
their
ranked
votes to
Not to
remaining.
their
ranked-
remaining.
No,
I'm
isn't it?
sorry, I'm not trying to be difficult.
No,
Can I have
no.
one person speak? So I'm struggling to understand because I'm hearing the audience, I'm hearing.
No,
the
you're right.
dialogue.
You're okay.
So if
Let me take a step.
if we could start at the beginning.
Reallocating their votes to remaining ranked candidates. Is
Okay.
that
Yeah,
your understanding?
yes.
Is that your understanding?
Yes.
Okay.
Consensus.
Until candidate with most final round votes, and the rest continues. Okay, so how I have it then is eliminating lowest ranked candidate and reallocating their votes to remaining ranked candidates until candidate with most final round votes is declared the winner. Did I hear that? And do it right?
Yeah.
Third time's the charm? That was a joke, you can laugh.
And in this,
No one laughs at mine.
in this first section.
Only laugh at yours.
Steve Lidl brought up.
Are we good?
Are you okay with the way we've got this worded?
Good.
Are you sure? Yeah.
I think we're gonna start splitting here. You're good?
Yeah.
I'm good with that, yeah.
If you print this, I think we can make a motion.
Okay. We're at 100 exactly, so there's no other changes.
Mr. Doctor, thank you. Thank you. And Mr. Lidl, thank you. I said, thank you. Yeah. Okay. We're just gonna wait for this to come back in print, just to give you an idea what happens next is, once we're past the 100 word before we break for lunch, we do want to do an approval on the form. And then the afternoon after lunch, we will deal with the referendum on wages. And we will deal with the tax related to education. Mr. Lidl, I believe you're representing on the education, is that correct? Okay. I just wanted to make sure you were coming back after lunch.
I can't. Whoops.
Okay. Mr. Francesi, would you read it from the top and then we will ask for a motion?
Yes. So it reads Constitutional Amendment 2, require ranked choice voting, in parentheses RCV, for federal offices, governor/lieutenant governor, attorney general, and secretary of state, allowing voters to numerically rank candidates by voter preference starting in 2029, count votes in rounds, eliminating lowest ranked candidate, and reallocating their votes to remaining ranked candidates until candidate with most final round votes is declared the winner. Allow voters to rank at least 4 more candidates than positions to be nominated/elected unless insufficient number of candidates. Authorize local jurisdiction to adopt use of RCV in local elections. Move August primary to June or earlier in even year elections. Require legislative funding and implementing legislation. And that is 100 words exactly.
Well done. Do I have a motion?
Yes, I move that the board approve the form of the constitutional amendment submitted by Rank Michigan Vote, conditioned upon the replacement of the summary language approved by the board today, with the understanding that the board's approval does not extend to, 1, the substance.
You're wrong motion.
Sorry. No, rank.
That's approval is to form.
Oh. Hold on, sorry, folks. Like that. I move that the Board of State Canvassers approve the summary of the purpose of the constitutional amendment sponsored by Rank Michigan Vote as drafted by the Deputy Director of Elections and presented by the Deputy Director on June 27th, 2025. Do we have a?
It's been moved and seconded. Any discussion? What? Say that again?
Okay.
Paul, I'm sorry, Paul seconded it. Yes. Been moved and seconded. Any discussion, any questions? Was that you raised your hand to raise a question?
No, I.
Oh, good. All in favor?
Aye.
Aye.
Opposed? Unanimous. All right, with that, we're going to move to item number 5, consideration of the form of the constitutional amendment submitted by Rank Michigan, Rank My Vote. And we have been presented with, this is the real.
Is that's the one I gave you this morning, right? Yes, that is a copy of the petition as submitted by us. Staff has reviewed it and we think it complies with our provisions. So we would ask that you approve it.
You've read it in your.
So staff has reviewed as our normal practice with our form. We've looked at the type, the size of the letters, et cetera. We've reviewed the warnings to make sure they're compliant. We, as normal, we do not read the back. We do not check for typos. We do not check for spacing because that's not part of the form review for us. But we've checked like the size to make sure that something is here. We've checked to make sure that like on the back, for example, it reprints in full something. We do not look at whether this is an exhaustive list of whether it's declaring everything that's been altered or abrogated, just whether something is there. So staff has done the normal review that we've done for form.
Okay. Discussion or questions from anyone here? Ms. Cummings, you're good? Vice Chair, you're good?
I am good.
Mr. Cordes, if I would ask then if we have an amendment or a motion to for approving the form.
You trust me, I can do it this time. I move that the board approve the form of the constitutional amendment submitted by Rank Michigan Vote, conditioned upon the replacement of the summary language approved by the board today, with the understanding that the board's approval does not extend to 1, the substance of the proposal which appears on the back of the petition, and 2, the manner in which the proposal language is affixed to the petition.
Been moved and seconded. All in favor?
Aye.
Aye.
All right. I think it's time for lunch. Board will be in recess. Uh, if we're back here at 1:30, is that give enough time? 1:30? We will reconvene at 1:30. Thank you.
Just as an FYI for anybody in the room, everybody does have to leave the room when we're in recess. So thank you.
Yes, good point. Thank you. Right, moving along. This afternoon, we just a preliminary here before we jump into it. We have two more petitions to go through. One is a petition on a referendum. The second one is the petition on the educational funding. We're going to do the referendum first. And so we're going to do a consideration of the 100-word summary of the purpose of the referendum sponsored by voters to stop pay cuts. The summary as drafted by Deputy Director of Elections is as follows. Referendum petition to repeal Public Act 1 of 2025, which amended the Improved Workforce Opportunity Wage Act to increase the minimum wage to $12.48 per hour, 2025, $13.73 per hour, 2026, and $15 per hour, 2027, with annual inflation-based increases, reduced tipped worker wage to 38% of the full minimum wage in 2025, 40% in 2026, 42% in 2027, 44% in 2028, 46% 2029, 48% in 2030, and 50% in 2031. Provides civil fines for employees failing to pay minimum hourly wage. This referendum petition would pause enactment of Public Act 1 of 2025 and place it on the ballot for voter approval. The word count at this point is 74. And with that, I believe we have Mr. Lancaster. Sir, I would invite you to come forward and speak to us. You'll need to turn the microphone on as well. There's a small button at the base on the right side. And you'll need to. There you go.
Thank you. Thank you, Mr. Chairman.
Would you state your name and spell it for the court
Sure.
reporter?
My name is James Lancaster. That's James. Lancaster is Lancaster. And I am the attorney for the sponsor of this petition. In looking at the statute, that if a person who submits a summary of the purpose of proposed amendment or question proposed, hold on, my bifocals are adjusting. The summary is limited to not more than 100 words and must consist of a true and impartial statement. I emphasize the word impartial statement. Oh, where I lost my spot. For or against the proposed amendment or question provided. I would suggest to the board that what the deputy director has submitted is not impartial. And let me just contrast it with what we submitted and asked to be, hold on a second, I gotta get pulled up here. What we asked to have approved. Our proposed summary was simple, it was direct, and it was completely, I believe, impartial. And it basically states a petition for a referendum election to repeal Public Act 1 of 2025, which was apologize for the delay here. Trying to use I put these things on these phones so you just.
No, I understand that. I know exactly how that works. Would you like one of us to read your
Sure.
word for you?
That'd be great.
Mr. Francesi, could I get you to read the original 100-word summary that was submitted by the petitioner?
Just to make sure I'm reading the right one, is it you're referring to the words that's on top of the petition you submitted, right? Okay, so the original, what was given to us, it says, quote, "A petition for a referendum election to repeal Public Act 1 of 2025, which reduced the minimum wage for Michigan tipped workers, established a new schedule for increasing the state minimum wage, and changed the way future inflation adjustments for minimum wage increases will occur."
I think that's very simple, very direct. Unlike what the deputy director has provided, I must say, when I read it, it almost sounded like an advertisement in favor of Public Act 1 and almost arguing that it shouldn't be repealed. And I would point to you that while when you read this, it talks about the increase in minimum wage for non-tipped workers. And at the end of the statement, it does have some percentages, but it doesn't have the dollar amounts. And the reason why I think that's misleading, because according to the Senate Fiscal Agency, let me just get this right. The current tip minimum wage is was $4.01. February 21, it was supposed to go to $5.99. Instead, with the legislature, it went to $4.74. In 2026, it was supposed to go up to $7.97. With Act 1, it only goes up to $5.49. In 2027, it was supposed to go up to $9.91. With the from the legislature for SB 1, it only goes up to $6.30. In 2028, it was supposed to go up to $11.98. Instead, it's going to $6.60. In 2029, it was supposed to go up to $13.47. With the legislation, it went to $6.90. In 2030, it was supposed to go up to $14.97. Pursuant to the legislature's act, it only goes up to $7.20, literally less than half of what was the court had ordered and what was supposed to go. It was supposed to go up. Because I'm sure you're all aware that this.
So the question I would ask is, are you suggesting that the 100-word summary that was drafted by the Bureau of Elections has inaccurate numbers? Is that what you're saying?
It omits numbers. It omits the disparity.
Yeah, probably
in the
with the
tip wage.
summary.
I mean, for the people who are non-tipped wage, the numbers are correct. They comply with the court order. Because as you may recall, there was a referendum on this. Legislature adopted it, but then they amended it in the same session. There was litigation, and the Supreme Court ultimately said legislature couldn't do that. And the court came up with its own calculations. And that's what I'm talking about. And I think that why this is misleading is that while Deputy Director has included in here the numbers, the exact numbers of what the minimum wages goes up for non-tipped employees, but not for tipped employees. And I think that just is misleading because it doesn't notify the people of exactly what's going on. And that's one of the reasons why, and what was read in the original petition, is that it reduces the wages of tipped employees. And that was one of the main motivations for us submitting this referendum.
The legislation itself, though, uses dollar figures for 2025, 2026, 2027 for minimum hourly wage, but then it's the legislation itself doesn't list out dollar figures. It uses percentages, right?
Right, correct.
You just used exactly what was in the legislation.
But what was in the legislation, I don't believe that for non-tipped employees, it had the amounts. So again, I think it's misleading in the sense that it shows these increases for non-tip employees with specific numbers. but not for tipped employees.
Cummings, would you?
So are you suggesting that we need to include that information, or are you suggesting to stick with your 100-word summary?
I'm suggesting you stick with my 100-word summary because I think it's very brief. It's to the point. It is not, it just points out what we believe are the flaws in the legislation. And it doesn't, I don't think it could be considered advocating for anything. It's just informing people, this is what this act did. One of the key points being reducing the amount that tipped employees would receive. And again, it's sort of what my, when I write things, what's the cliche? Brevity is the soul of wit. Well, I think in this case, I'm sorry. I mean, I like to always think that brevity is the soul of wit. And I think that our description of it's not advocating for anything. It's not giving numbers. It's just saying, here's what it does. And of course, you know, the act is printed on the back of the petition. But, you know, that'll be a political battle where the people who are against this will point this out. We'll advertise this. We'll advertise the fact that non-tipped employees get what basically the court had ordered, but non-tip employees there's a big disparity over the years. And I think that's something you leave to the voters. It's to the proponents of the referendum and the opponents of the referendum.
One other thing, in your brief summary, you say reduce the minimum wage?
It initially did, but they eventually, with the court order, brought it up to whatever the number is here. What is it?
So I do think that's confusing with your 100-word.
So it reduced the minimum wage for tip workers, but not for other workers. Isn't that correct?
Correct.
The statute
Yes.
that you're seeking to.
Yes.
Right. Do you understand that that if this were to go on the ballot, the referendum would say, it would say Public Act 1 of 2025 does as follows, and it would present the same numbers as are presented in the summary drafted by the deputy director, and then it would say, do you approve? Yes or not?
I'm
Yes or no?
I'm suggesting you don't put any numbers in.
I'm sorry?
Why would you need any numbers in?
Why would you?
You said no. I mean, it will. I understand it will say that we're seeking to rescind Public Act 1 of 2025.
I mean, on the ballot,
Yes.
but it wouldn't, because on the ballot itself, you're not proposing to repeal. The ballot wouldn't say that you're proposing to repeal or rescind Public Act 1 of 2025. It would say a referendum on Public Act 2025, which in Public Act 1 of 2025 says, blah, 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 you approve or not, yes or no.
Okay.
It would summarize the act that you're seeking to put before the voters. But what you're really asking, you're not asking the voters, do you want to repeal this? You're asking the voters if they approve or reject it. So I think I know that what Mr. Fracassi has done is essentially to prepare for the petition language, the language that would be on the referendum ballot.
Well, not necessarily. I mean, you know, when you get to the point where, assuming we get enough signatures, what's put on the ballot is a whole different matter. The director of elections decides that.
He does, but the director of elections in a referendum doesn't have really there isn't as much to decide at that point, because a referendum requires that the ballot question be a summary of the legislation which is being referred to the voters for approval or rejection. And so these numbers are going to be, I think that what Public Act 1 of 2025 does would have to be set forth on the ballot for voters to either approve or reject.
I guess I'm scratching my head about is that, doesn't the language we propose essentially do that? I mean, would you have on the ballot, all the numbers for the non-tipped employees and the numbers for the tipped employees?
I think you would.
You would probably have a summary much closer to Mr. Francasi's, the simple standpoint that if you put what your summary on the ballot, it begs the question of what is Public Act 2025?
Well, I mean, again, our description of it, I think, is clear. I mean, if you're talking about putting numbers on the ballot, I think that you got to put the tip wage numbers on the ballot, and maybe on the petition as well. What I'm suggesting is just for the petition, I mean, it talks about what it does, and again, I'm just scratching my head as to why you only have the numbers for the non-tip employees, but not for the tipped employees.
The way that this would normally work is that we would listen to the cases, and Mr. Francesi would then also give a summary. And I was going to let you do the summary first. So perhaps this would be a good time to have an explanation of what you did.
This one was hard, not gonna lie. So couple of things. What made this one deceivingly difficult was the posture with just everything that's happened with this one in general. So what I was trying to balance was several different things. First, I believe from what I can tell at least is that this is the first referendum petition that the board has been asked to approve summary language for. We've had some referendum petitions submitted, but no request for summary language. It was just submitted. So this is the first one that at least I'm aware of, that we can draft, or that we have been asked to draft summary language and seek board approval. This is also, we have not had a referendum on the ballot since 2014. So it's been quite some time since we've seen it on the ballot as well. So what I was balancing when I was looking at this was trying to inform voters of what exactly the petition is asking you to do and what the act does. And write that in a way that is clear to the voter that Public Act 1 did the following, and that by signing this petition, this is what is going to happen. So that's why I put that last line in there that says this is going to pause it and go for the next one. And the reason I did that was, again, because when I was writing it, I didn't want it to skew or lead voters to think that by signing something, they are supporting an increase or a decrease in either tipped or non-tipped wage, because that's not what they're doing, actually. What they're doing is, by signing this petition, they are asking to go to the ballot in the next general election, which then it would appear on the ballot as Public Act does these things, and should this law be adopted, yes or no? That is a different posture that we've been in with constitutional amendments and initiative petitions that we've had, where a petition is putting a new right in or creating a new system or something like that. This is the exact opposite. We're removing something entirely. With an initiative or a constitutional amendment, you might have removals of pieces, but it's pieces. A referendum is essentially asking to take the entire law away altogether. So when I was drafting it, I looked at the Senate Bill 8, which is Public Act 1 of 2025, and I looked at the bold strike through. I looked at what was being put in. I looked at what was being done, because if the referendum goes through and is approved by the voters, this whole thing is just basically gone. So what I looked at, and the reason why I put some of these things in and why I put the numbers in, was because I wanted to try to capture what voters again, like we normally do, what is the change we're looking for here? And I wanted to try to explain it as best as possible to voters to say, this is what the bill did, but you're not being asked to support or anything like that. Again, you're asking, this is what the ask is, that's clear. So that's why I first phrased it the way I did. I included the minimum wages specifically. I took them directly from the Public Act 1 itself. The numbers were in there for non-tipped employees, with the specifics saying the minimum wage is this, the rate is this. And then for tipped worker wages, it's in the statute as a percentage. So that was why I used the percentage versus trying to calculate and determine whether like a hourly dollar rate of what that would be. I went with the percent because that was directly what was in Senate Bill 8 and Public Act 1. The other change that I saw that would be removed, in addition to the adjustments to wage, I saw this bill increases minimum wage as it's written, and then for non-tipped employees, and then it decreases the tipped worker wage to specific percentages over between now and 2031, compared to what they would be currently. So then as far as the consumer price adjustments, the inflation adjustments based on the consumer price index, there were changes to that. It does change how how it gets calculated. And then it finally added it being again the Public Act 1 adds a provision that says that if an employer fails to pay the minimum hourly wage, then they're subject to a civil fine of $2,500. So that was my mindset and why I drafted it the way it is presented now, and kind of the pieces that I went back and forth on.
Perfect. Thank you. Does Madam Vice Chair, do you have any questions for Mr. Rankins?
No. I have done a couple of referendums when I was practicing, and I went back to look at the way they were framed, and they set forth the language of the statute which was being referred and said, do you approve? Yes or no? Do you approve? So that the voters are being asked, do you like the statute or not? But they have to understand what the statute is, and so it sets forth, and is required to do so, I believe, the language of the statute which is being referred. It doesn't say, do you want to repeal? It just says, do you approve or not? And so having on the petition, the language of the statute seemed reasonable to me. I understand that Ms. Hanson and Mr. Doster will argue that there needs to be other information, but you're saying that there should not even be that information about what the statute says?
I think the problem is going to be that I think it gives you a brief summary. I mean, it doesn't do it in detail, and I'm not sure in 100 words I could get into the level of detail you're talking about. And of course, on the back of the petition is the Public Act. And so people can see what it was. Now, I mean, I guess the only other thing I could do is do sort of a red line of what it changed, which would inform people of seeing, okay, if we go back to what the law was, before the enactment of Public Act 1, I mean, that might be more meaningful. And
which is, I think, what the opponents of this referendum are suggesting. So
we may.
And I guess my question is, would the board accept that? Because I'd be glad to do it.
I'm sorry, would the board accept?
If we did on the back of the petition, essentially a red line that showed how Public Act 1 changed the law
So let me rephrase what I think you just said. Are you asking the board if you were to withdraw this and then come back with something different? Is that
Yes.
what you're saying?
I mean, yeah, if the board feels that's necessary, I'll do it.
Well, I think the board is prepared to work through the rest of the 100-word summary here. I, I think the board, I can't speak for my other three colleagues, but I think that the board is going to be much more leaning toward the more detailed version of the 100-word summary as opposed to the summary that you have here. If you were asking me if it's a good strategic move to pull this and rewrite it and come back to us, I can't make that, I can't help you with that.
Well, again, the question I have is, are you looking for something that shows people how Public Act 1 changed this statute in essentially a red line version?
I have to actually ask for some Department of Elections to weigh in on this because this is a referendum. I don't know what the legal is for.
So as I understand the question, so I think there's kind of two things going on. So on the back of the petition has to be printed Public Act 1 in its entirety, which they've done. I think the question is similar how we have with like initiative and constitutional amendments, you have that bold strike through whether that should be added. I don't think that would comply with election law because election law mandates a reprinting of the Public Act that has been signed. The Public Act that has been signed is
Exactly
this. The Public Act that gets signed does not have a bold strike through like it. That would be the bill, like the Senate bill in this instance, that gets printed. So again, kind of like when we're talking about like telling voters why, like what's going on here, that's why I drafted the summary the way I did. And then you have the reprinting of the statute as in its entirety in the back.
I think that's where the board will weigh in as well, is that a more detailed 100-word summary reflecting what Public Act 1 performed or provided is the way that we're going to end up working here.
So in other words, when we talk about it, reduce the increases for inflation, I have to quote that or something, or I'm having a hard time with this because it sounds like what you're asking me to do, it's going to be really hard to do it in 100 words.
I don't think we're asking you to do something. I do think it would be helpful to hear from the opponents because they're asking for a different, you want less
Yes.
and they want more. So maybe we can hear from both sides before
If we can hear
make a
from,
determination.
we have a second attorney, Andrea Hansen.
Yes.
Is here as well. Let's hear what she's got to say as well. We've heard what you have to say, and then let's collectively figure out what to do.
All right. Thank you.
Good afternoon, Ms. Hansen.
Good afternoon.
Hi.
Andrea Hansen, Honigman Law Firm. I'm here on behalf of Michigan Opportunity, a ballot question committee that is opposed to the referendum petition that has been submitted by voters to stop pay cuts, also known as One Fair Wage. The referendum petition before you has a more than decade history with this board. This is the fifth petition that this group under various names has submitted in the last 11 years. And all 5 petitions have addressed 2 topics, the minimum wage and the tip credit. So that's really the 2 issues that we have to discuss. With respect to the tip credit, in each one of these 5 petitions, they have sought to eliminate the tip credit. we can discuss policy for or against. That's just what they've tried to do, and that's been very consistent. With respect to the minimum wage, the prior 4 petitions all sought to increase the minimum wage. In contrast here, the petition before you, the referendum, would actually decrease the minimum wage. So it's different from what you have seen previously. Now, given the 11-year history, and I have, for better or worse, been involved in each one of these petitions, I could talk a long time about this, but I'm not going to. You guys have already been here a long time, so I'm going to try and get to the point, because really we're just here about the summary, right? And I do want to address some of what you've raised, Madam Gerwitz, but and I will get to that. But I do want to give a little teeny bit of history because I think it's relevant to, we have to understand what this proposal is to create a proper summary. And I have to say, I've never once heard anyone want to use less words. Usually we're like, how are we going to get this all into 100 words? So this is kind of unusual. But following the Supreme Court's decision last July in Mothering Justice, our state was on the cusp of going back to the 2018 proposal that was submitted by One Fair Wage. And that would have, among other things, eliminated the tip credit. It would have been catastrophic for the restaurant industry. It would have forced restaurants to shut down, to raise prices. It would have been disastrous. I mean, everybody agreed that that would have been highly problematic. We would have had fewer tipped workers in the state. And a lot of tip workers protested, and ultimately, we had a compromise. A compromise was reached. Particularly in this environment, we actually had a bipartisan compromise. It was very unusual. And this led to 2025 PA1. And this was a compromise. It was approved by both houses. It was Democrats and Republicans. It was signed by our governor. And the compromise tried to balance these competing interests and resulted in an increase in the minimum wage, but it preserved the tip credit, but at slightly adjusted numbers. So this amendment, like I said, it was supported by both parties, and it really tried to reflect, I think, what Michiganders wanted, which is a decent, livable minimum wage, but a tip credit system that allows restaurants and small businesses to survive. So I view this is one of the very rare opportunities I get to be before you on a fairly partisan neutral issue. Despite this bipartisan approval, the One Fair Wage folks are, I'm presuming they're upset that their original language in the 2018 proposal was not put in place exactly as written, even though 2025 PA1 actually increased the minimum wage over what they were proposing. So really, what they're trying to do is go back to their proposal and repeal the amendment and go back. So they are obviously within their rights to do that. That's, everyone has a right to pursue a referendum, but they have to accurately describe what would happen. So as discussed by Deputy Director Fracassi, I think this is the first referendum petition that we've had to deal with where the board is actually approving a summary. And I struggled with this one too, because it's confusing because you have a repeal, you have, it's not only a repeal of a law, it's a law amending another law. And so, normally, like what you were saying, Madam Gerwitz, is we have a summary petition that's pretty similar to what the ballot question is going to be, but they are different processes. They don't have to be the same. We will come, if we get to that point, we're going to come before this board and probably argue about the ballot question too, right? They don't have to be identical. It's just normally they're very similar because they're doing the same thing, right? You have an initiative that's doing X, Y, and Z, and you're going to put the same thing on the ballot question. Fundamentally, it's going to be similar. But that's not what's happening here, because when we go to the ballot question stage, the question is going to be, should 2025 PA1 be approved? So the voters have to know what that act does. I mean, it's really only going to talk about that act. It's not going to talk about what happens if it's not approved or approved. It's just going to say, this is what this act does. And presumably at that time, if we get that far, that law is going to be suspended. So it's not going to be in effect. So it really is, do you voters of Michigan, do you want this law? Whereas here, 2025 PA1 right now is the current law. We have that right now. So if this goes forward, we are taking that away. From my perspective, it is the reverse of what we would be proposing in the ballot question stage, which I realize is unusual, but I think this is a pretty unique situation. And the point of the summary of petition, obviously, is for people to understand it, right? We all know that most people are not going to read the back of the proposal when they're being asked to sign a petition. We're lucky if they read the summary. And, you know, a lot of times they're going to rely on what the circulator says, which, whether intentionally or not, is not always entirely accurate. So it's really important that the summary be clear and understandable and in plain English. And while the words like repeal and referendum are commonplace to all of us, those words are not necessarily understood by the general public. And so my concern is if we just say repeal and we're not really explaining what a repeal would do, a lot of people are not going to understand what this. They're going to look straight at this summary. They're going to see the word increase. They're going to see minimum wage, and they're going to think, oh, well, if I do this, I sign this, I'm supporting an increase in the minimum wage. And that's not what's happening. That's just not, it's just not true, right? So what 2025 PA1 did, it did two things primarily. It increased the minimum wage and it preserved the tip credit. You do a repeal on that, you're going to decrease the minimum wage, and you are going to eliminate the tip credit. That's just a fact, right? That's not really something that we should be disputing. So I feel like I think the deputy director did a good job with a difficult summary trying to balance that, but I feel like it's still not really telling voters what is going to be the consequence. What are you supporting if you sign this? So I did come up with some proposed changes, which it may be easier for me to pass this out as I walk through them.
You have copies for opposing counsel of the, good, okay. And for Mr. Doster as well.
So if you look at this, you can see I kind of tried to strike the balance. First of all, my concern with the whole first clause in the deputy director's proposal is it's too long, right? You're talking about what the referendum petition would do, and then you're talking about what the Improved Workforce Opportunity Wage Act amendment would do. And I feel like if you read it straight through, it just looks like there's going to be an increase if you support the referendum petition. So I added a period really to just make it clear, okay, this is what this is, and a repeal, we're seeking a repeal, and a repeal would do this. It would decrease the minimum wage. Let's put what the decrease is so people can understand it in plain English. This is what it is. This is what it would be. And then it would eliminate the tip credit. That's just a fact. That's the goal of this. And so I think it's appropriate to put that in there. I did add in, which I think Mr. Lancaster will appreciate, that it would raise the tipped worker wage and put it in. I mean, that's what it would do. That's what they want to do. But I do, I think it's appropriate to keep the percentages for the tipped wage. That's how, what's the statute reads. That's how the Supreme Court discussed it in their opinion. In every single iteration of the Improved Workforce Act, it's the tipped percentage is all done. It's based on percentages. So if you start putting in dollar amounts for the minimum wage, which is how it is put in the statute uses the specific dollar amounts of what the wage is. The tipped credit portion uses percentages. So that model follows exactly what the statute is. I think most people understand what that means. And it is the clearest way to describe exactly what would be changed here. And then I suggested suspend rather than pause enactment, again, just because I think that's simpler verbiage that people would understand rather than pause enactment. So that was just kind of more of a, and it's one less word. And then the only other thing was the addition regarding the civil fines for employers. That was really to ensure that tipped workers receive the full minimum wage, because, one of the other things that's a little bit, I didn't even get into that here, but it's a little misleading, is tip workers also have to receive the full minimum wage. So if the set minimum wage goes down, it goes down for everybody. It's just that tipped workers receive their minimum wage partially from the employer and partially from tips. But I thought that was too complicated to get into here, and so I'll let that one go. But so I think I tried to keep as much of the deputy director's language as possible, but to flip it a little bit to make it a little bit more clear.
Thank you. Questions for Ms. Hanson? Yeah, we have one other, thank you for presenting to us. There's one other attorney who's requested to present, Mr. Doster.
Thank you, Mr. Chair, members of the board. Eric Doster on behalf of Small Business for a Better Michigan. I'm I'm going to be mercifully brief. My only comment here is that I think that Mr. Fracassi did a great job in a very unusual situation. The only thing I differ with, I thought our last referendum was in 2012. He said 2014. Was it? What did I miss? Darn it.
There was a wolf one in 2014.
Oh, that was one of mine too.
Even
Sorry.
better.
Gosh darn it. Pretty soon I'll forget that Mark Brewer's in the audience. But at any rate, this is a different posture. And to make this clearer for the voters, what are they signing? Well, what are they signing? This petition seeks a repeal of PA 1 of 2025. So I'm here to wholeheartedly support the language offered you by Ms. Hanson on behalf of Michigan Opportunity. But I really want to focus on what if I sign it, what does this do? Well, this is a petition to repeal PA 1 of 2025. What does a repeal of PA 2025 do? And that's what Ms. Hanson has provided to this board. A repeal of 2025 PA 1 would, and then she went through and ticked everything off. Exactly, very, very few differences. Just a couple of, there's only two differences. One, she added the insured tip rates, which is right, because I think there were fines for both, for the non-tip wage workers before. So this is what repealing of 2025 PA would do. So Ms. Hanson is being faithful to what a repeal of PA 1 would do. And so I would urge the board to adopt the approach suggested to you by Ms. Hanson here today, because it's just clear, what am I signing? That's it. The substance is the same as what Mr. Fracassi has suggested. So that's my only point, and that's all I need to say.
The substance isn't exactly the same because it includes more numbers, right? So what Mr. Fracassi did was summarize Public Act 1 of 2025. And what is being suggested by Ms. Hanson, and I believe by you, is that what it needs to do is also indicate how Public Act 1 differs from what would be in effect if it were repealed.
Yes. This is what a repeal of PA, what am I
Right.
being asked to
So,
sign?
You know, one of it's not really, a referendum doesn't say a vote to repeal such and such. It said, here's the act, yes or no,
Correct.
right? And so it's really asking the public to weigh in the way the legislature weighs in.
Absolutely.
And so what Mr. Fakasi did is essentially what would be, for the most part, what would be on the ballot. This is PA 1 of 2025. It increases the minimum wage and it decreases the tipped wage.
Should this law be adopted? Yes, no.
Right, yeah. And you are advocating, both you and Ms. Hanson are advocating that in this particular circumstance, more is needed.
But not
And
much
Mr.
more.
Lancaster doesn't want to say how, as I understand it, he doesn't want to say how what PA 1 and PA whatever from 2018 differ. He just wants to have his characterization.
Yeah, but I don't understand. Yeah, the original summary that they proposed, I don't understand what I'm signing. Am I signing for a minimum age increase or a decrease? I'm not really sure. Here, what Ms. Hanson has laid out for you, I know that if I sign this, this is what I'm asking, this is what I'm being asked to support. A repeal of PA 1. What would a repeal of PA 1 do? She lists it all out.
Right. Now, Mr. Lancaster's summary, I think, is not really accurate. And leaves out, it starts out saying that it reduces the minimum wage for tip workers, which I don't think is quite accurate, but it then says it establishes a new schedule for other workers, but it doesn't say what it is, which, I mean, it's just half of it and maybe a not accurate half. But I think the question that we're grappling with is how does what goes on the petition, which I don't think that the director has ever considered before, or the board, what goes on a referendum petition, and how does that relate to what ultimately goes on the referendum ballot?
Right.
Right.
And this is, right, and to be clear, this
If
is
it
the
gets
first
to the
one.
ballot.
Right, the proposed petition summary requirement came into effect in 2018. So
Right.
this is the first one. So, yes.
Right.
So, and I'm just suggesting, just for voter clarity, the style or I don't think the information's different. It's just phrased differently to be clear to the voter what they're signing. And I understand that when we get to the ballot, if we get that far, if we get to, PA 1 of 2025 would do, and then tick, 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 should this law be adopted? Yes, no. But, in the Attorney General's opinion, I forget what question it is, 3 or 4 from a couple of years ago, says that the petition summary language, although they share a lot of the same principles, aren't necessarily what has to be what's on the ballot.
Right.
So that's why I'm suggesting in this peculiar instance that we're dealing with here, I think what Ms. Hanson is suggesting to you just makes sense. That's my only point.
What I like with Ms. Hanson's is a real subtle one, that contrasting the opening with Mr. Francesi's. I always want to call you that, and I apologize. That's awful. I never speak your name. I always read it, and
It's Fracassi, it's like Lassie.
Would you mind if I just called you Adam? Is that okay? Good. What I like, Adam, with the second one is that it gives the general public the idea that A, what are we really doing here? We're repealing. And then B, it goes one step further and says, what exactly are we repealing? It's a really subtle distinction, but when I read yours, I'm reading yours with the idea that the repeal and the act of repealing all go into one. And I didn't phrase that right, did I? Let me read yours aloud. Referendum petition to repeal Public Act 1 of 2025, which amended the Improved Workforce Opportunity Wage Act 2. And then you go very accurately into your summary. Just on the first line without anything else. what Ms. Hansen's purporting is referendum petition to repeal Public Act 1 of 2025. My mind stops there. And then which amended the Opportunity Act, a repeal would. It's that line right there. If I take that line, a repeal of 2025 PA1 would, and I weasel word the same kind of line into yours is perfect. Does that
No,
make sense?
no, because his doesn't have.
Well, I
the-
know it doesn't, I said weasel word, it would have to be phrased a little differently.
Because
What I'm after is not, I'm after the idea that you're telling the voter that they are going to repeal something. And then you're telling them what exactly it is that they're repealing.
I feel like the kicker here is that you are repealing an amendment. So you're reverting to something else rather than going from something to just nothing. So I think that's what the kicker here is we are reverting to something else, not just having a public act just go away and then there's nothing there. There's what's left from the original document. So I would tend to agree that we need to tell people, okay, if you do repeal this, here's what you're left with. You're not left with nothing. You're left with what Ms. Hansen has put in here. So I would tend to agree.
If I could just add one thing I was thinking, this is kind of analogy to me. This could have been done by initiative, right? Because this is in effect amending a law, right? You're taking away. So this could have been done in an initiative form. If it was done in an initiative form, we would be explaining what the differences are. We wouldn't be so focused on the fact that this was a referendum. Okay, this is the change that they're proposing to the law. And I think what my proposed summary presents it in that manner.
I think there's a little confusion in Adam's summary, where the first line says referendum petition to repeal Public Act, and the last sentence says this referendum would place it on the ballot for voter approval. I think a referendum is more accurately summarized as saying referendum petition to seek voter approval or rejection of Public Act 1 of 2025. And then perhaps then setting forth what I guess what we're really talking about is what approval or rejection would result in. And your summary says that it would decrease the minimum wage, a rejection would. And you're saying, you're calling it a repeal, but I think more accurately would be the public's rejection of would result in the following changes from what PA 1 does.
Well, they called it a repeal, right? In their proposed summary, they say that's the purpose.
I think it would be better to say that this is a referendum to seek voter approval or rejection of what the legislature has done. And this is what the legislature has done. They've changed from this to that. And the question that I think we're grappling with and that you suggested in your position letter was, or you wouldn't ordinarily expect, although we haven't had this too much, the difference between the ballot question language and the petition language. But that you're suggesting that in the context of this, we need to be more specific about what.
I think
because the ballot question is just going to say, here's PA1.
Right.
Here's PA1.
Do you like
it or not?
Like it or not?
And you're saying that the petition language should be more detailed about what rejecting PA1 would.
Well, yeah, because what they are seeking is a repeal, right? That's what they say, right? In their proposal, that's what they want. That's why they're doing this. And it's the law we have right now. So they are seeking, and the purpose of the petition is to get this on the ballot because they want it repealed. That is their purpose. And if they are successful in getting the signatures and it gets certified, that it's going to be suspended. The law will be suspended. And so you're taking away a law that we have now. But at the time, if we get to the point where it's actually at the election, that law will not be in effect. So it's a much cleaner, you're just saying, hey, voters, do you like this or do you not? Do you approve it? Do you not? I just feel like we're in a very different posture because they're looking to suspend the law that is in place right now and then hoping to have it repealed. Whereas, at our next election, it's just a completely different posture. And so I recognize that it's not what we typically do, but I also don't think a referendum to repeal an amendment of a law is also, it's just not a typical scenario. It's not something we deal with a lot. And so I think if the goal is truly to present a summary that the reader will understand, the only way to really understand it is to understand what the impact is of taking away this law, and they may like it or they may not like it. That's not really the point. It's just let's accurately
Right,
tell
I
them what
understand.
the difference is.
What would you think about language that said, as I suggested, a referendum petition to seek voter approval or rejection of Public Act 1 instead of to seek repeal? I just think that maybe I'm being unduly picky, but I think that's really what a referendum does. It doesn't.
Well, I think I'm less concerned about that.
Yeah, your
piece.
concern is these are the differences between what we have and what we would get.
And what we
you-
take away. I
Right.
mean, I think I understand what you're saying. I mean, a referendum technically is you're putting a vote to the people of a piece of legislation for voter approval or rejection. But I also think this is a summary of purpose, right? And the purpose of this is to repeal 2025 PA1. And so I think if we get away from that, it's not necessarily reflective of the purpose. They're doing the referendum because they want to repeal.
Well, that's what you, that's what
I
they're seeking a
understand. I mean,
referendum,
but
right?
I'm more,
Nobody files a referendum to.
but I hear what you're saying,
Right.
and I understand why you're saying that. I think I'm more concerned in terms of that it reflects what it would do. If it is, I mean, whether we call it repealed or rejected or whatever, what that would mean, given that this is the law that we have right now. I think
You are,
people,
though. You're answering that question exactly the way I would expect you to. What you've given us here is what will happen if the law is repealed.
Exactly.
This is the outcome.
this is the outcome they're seeking.
What Adam has given us is, this is what the law is that would be repealed.
Right, which makes more sense for the ballot question, I think.
Right.
And I think that's accurate.
Right, he's got the ballot question.
But that's the point is on
She's-
the ballot,
right,
you were, I
yeah.
know, but on the ballot, you are saying the objective here is to either repeal or not repeal. And if you repeal, this is what we're repealing.
Yes. So yes, and I agree that it can be different if we want it to be. So I would like to respond to this because there are some things that I am okay with, but there are other pieces that I'm a little concerned that and why I didn't phrase it this way initially, to be frank. So the issue that I had when I was drafting it, I originally had tried to say that the repeal would decrease it from this to this, and it would do it from that to that, But the problem that I have had with that is I don't see where those numbers come from, to be frank. I don't know where I can't tell you sitting here based on what I was able to find between Senate Bill 8, the petition, all of these things to say that if this law is suspended, if it's paused, if this is just kind of paused, what will the minimum wage be? I don't know the answer to that. So that was why I didn't go down the road of it would reduce it from this to this, or it would increase it from this to this. And the reason that that was why I phrased it the way it was as well, because I was worried when I was drafting it that if you start getting into too much of increase from this to this, that one, it gets confusing for the voter, but two, does that lead to any sort of prejudice or for or against the petition? So that was why I drafted it in the way to keep it purely as this bill does the following, period. I think we can clarify that a little bit, but If you're, by saying like, Vice Chair Gerwitz said, by saying a referendum to seek voter approval or rejection of PA1, period, PA1 did the following, and then go into that. I think that would clarify it a little bit more, but I just am, I'm skeptical of trying to put in too many numbers that aren't in any of these, to be
Well,
frank.
and there's a plot, there's an underpinning in what you're doing too. And the underpinning, I think, is important that we don't miss. What you're doing is you're being very objective here and saying, this is what that law is. And what you folks are doing is wonderful in saying, this is what you're going to give up. But I also go back to the fact that if PA1 was repealed, correct me if I'm wrong, the legislature could meet the day after. Oh, no, they'll be on Christmas break. They could meet in January, right? They could meet in January and do PA1 of whatever year came, and they could come up with a whole new set of minimum wages, including but not limited to precisely what is being overthrown. Is that accurate?
Sure, the legislature.
That's what they did with the emergency manager.
Right, I mean, the legislature can do what they want to do, but that's not really, I mean, that's not really the issue
That's not
here. I
what
mean,
we're doing
that's a tomorrow problem, I guess, but I mean, to address what Mr. Fracassi said, I just have a couple quick comments. One, the numbers are from the Mothering Justice case. So I realize it's confusing because if you look just at the Improved Workforce Opportunity Act, it has certain numbers. And I did add that to our public comments. So the Supreme Court did they said how it should be calculated, and then the treasurer did the calculation per the inflation dates, so that we know what the numbers are, that the number would be changed to. I mean,
Sure, it's just easy to compute and you have all the material to do that. In fairness to Mr. Lancaster, who's representing the petitioner, I see that you are standing there, which
and I could-
suggests that you want to participate here.
I do.
I thought you might.
Am I okay without being near a mic or?
You are okay wherever you'd like to be, sir.
I can talk.
And
Oh,
yeah,
that's right. You know what? I'm treading outside my area here. You have to be somewhere where the
and also for live stream.
reporter can hear you.
Difficult.
No, Jim, please. I think if the concern about this is what happens if it's repealed, I don't think it goes back to the 2018 law. I think it goes back to what the Supreme Court ordered.
Right. I
And
don't think
it-
there's
and
any
that- and that
disagreement
didn't-
about that.
And that didn't reduce the minimum wage. So if the issue here for the board is that you want to say, if this is repealed, then this is what's gonna happen. And we basically put in a summary or whatever of the key provisions in terms of what happens with minimum wage, what happens with tipped wage, what happens with the rate, how they calculate the rate of inflation and so on. And if that's what the concern of this board is, then we'll do it. And I guess if you're looking at me saying, yeah, that's what you need to have in this.
When you say we'll do it, I mean,
Let me-
we're doing it. So are you saying that you
let
want
me
to
ask
do
you a
something
question.
else?
If you had the opportunity right now to say, we're going to make a decision on your 100-word summary based on everything you've heard,
Mhm.
or you can have what's behind door number 2 and take your petition back and say, we want to reword it and then resubscribe it or re-present it.
Well,
You could resubmit your,
petition.
you could resubmit it in, there's a filing period, but I mean, there's a public period.
So there's no filing deadline, but I just want to be clear with what
What's being discussed here?
yeah, because again, we will not accept a petition that puts a bold strike through on the back.
No, I'm sorry.
I want to make sure we're.
You are, what we're really talking about is
Oh,
There's a
you
100-word
could,
statement.
you could, to keep it out of this discussion, you could pull what you have presented.
Mhm.
You could rework your 100-word summary. You can't change what's on the inside because that's the statute.
Right.
And you could resubmit that to the Bureau of Elections.
Doesn't a referendum have to be submitted with a certain, within 60 days of the?
The signatures need to be submitted within 90 days after the final adjournment of the
Yes.
Okay.
legislature.
So there's no, okay, I'm sorry,
A little
that
bit.
I'm mixing things up here.
And the one other thing that I just wanted to, I think as Mr. Lancaster indicated with this discussion about what does it go back to, that's exactly why I did not go down that road and why I kept it at this is what the bill does, because I don't know if, so the legislation that passed, as I am assuming, was intended to override the mothering justice case, which overrode the amendment that was done in 2018, if I remember correctly. So it's not clear to me that if this referendum is, let's assume that signatures come in, I don't know which version of the law goes back into effect, to be frank. I don't know if the mothering justice case is revived, for lack of better terms. I don't know if the underlying amendment is revived. I don't know if the 2018 version is revived.
Correct.
So that was why I didn't go down that road ultimately, and why I kept it purely at this. This is what it does, and a repeal would basically be asking you to undo this.
I think I think your 100-word summary presents it accurately.
No, but the Supreme Court said the amendment, okay, we have adoption, we have amendment. The amendment was unconstitutional. Therefore, this is the remedy. And if you don't do something, this is the remedy. This is the remedy implementing the 2018 initiative. You know, obviously changing the numbers to account for the number of years that have passed. And this is what's going to go into effect. So I don't see the issue that you've just raised, that if PA1 were repealed, that you would not go to the Supreme Court order. It seems to me that you would.
But by virtue of the legislature passing this bill, does that nullify the court order? I don't know the answer to that. Because the court said this is what's going to happen. The legislation went into effect then. So that's the part I struggled with.
No,
I don't know the
understand
answer.
you're saying that, but you know, I just don't know why the court's order would not.
Because the legislature did act. So that's what I'm not sure about.
Well, the problem is that what you're suggesting is that a statute that was declared unconstitutional, somehow it would go back to that. Well, it can't. The next, you got to go
That's
back
not
to
what I'm
that.
suggesting.
You wouldn't go back to that.
That's not what I'm suggesting.
Well, then you got to go back to the sort of the status quo ante. I mean, that's the court order.
But one of the problems with your summary is that PA1 was a compromise. And so it increased the minimum wage generally and made a change in the tip.
Mhm.
So that isn't what your summary says. And we need something that reflects, I think, that there was an effort that there were changes made, both positive and negative. And depending on whether you thought it was negative, I mean, maybe you didn't think it was negative in terms of tip wage, which was what the most difficult issue was.
If you would like the opportunity to get with your client and to reimagine a 100-word summary, that's the landscape we're talking about.
Right.
And then resubmit it, that would give you the ability to take a different approach to it.
Okay. So what you're asking for is an explanation of what it did in more detail, and if it's repealed, what does it go back to? Is that what you're telling me?
It's revealed that may be a question beyond the scope of
That
the
was a
board.
question that Adam raised. I didn't know that anybody else raised it, but
That actually would, if you do in fact take this back, that would be something that I think you could get an answer to, but not from this board. Right? I don't have an answer to it. Mary Ellen, you don't,
Well,
you have a
I
theory.
disagree with what Adam is suggesting might happen, but I haven't looked specifically at whether the legislation, I don't think the legislation addressed that she shouldn't.
Yeah, maybe I can help answer some questions.
Just, can I jump in with it? Just a time.
Would you identify yourself, please?
Yes. My name is Sarah Rose, SARAHROSE, and I am with One Fair Wage. So I think one of the main questions that was talking about is yes, it is, what it would reverse to. And so with the passing of Public Act 1, it doesn't nullify what the Supreme Court order. So it would go back to that Supreme Court order. And so that was actually one of the suggestions that we were thinking about also wanting to add and have into the original language is this reversal of and upholding and the restoration to the Supreme Court order of that original language of the bill. And so we are not looking to, we don't want to have to resubmit. We don't want to have to go through the whole process. We would like to be able to work this out right now so we can get going on the work that we want to do with it. Yeah,
So
because
basically,
we're all in the room right now. We have all this in front of us. I feel like we should just be able to sit down and talk about it.
that's good. Certainly if what you want is what it would go back to, and we believe, or what we believe it would go back to the Supreme Court order.
But that's
What-
conjecture. If we put that on here, we don't have a definitive on it. We can't put that on onward summary. I mean, you're making a statement. You're asking somebody to sign something based on something that is absolutely not proven at all. You have the ability here to ask for a referendum to be appealed. You have a referendum to be appealed, but you can't say that, you can't in your 100-word summary say, hey, if you guys repeal this, it goes back to the 20.
Is what, Ms. Hanson, is this in your document, is this reverting back to the Supreme Court ruling?
You have,
And that's your understanding of what would
Yes.
happen as
Yes,
well.
correct.
Yeah.
Yeah, which is why I thought originally we had agreed on that and then it kind of strayed off course again. So that's why I wanted to redirect back to that to start off with.
so if we do,
That's my understanding.
but if we were to do that, then we could simply take Ms. Hanson's summary does exactly that. Is that correct?
It does. Yeah.
Add something real quick. Sorry, you guys. So you can have it back in a second. Yeah, thank you. So just a few things. I'm Mariah Ross, also with One Fair Wage. Just to clarify a couple of points. So we're not saying that, you know, we need to get into the weeds as much as we're getting into the weeds. We're just saying that it would be simpler to explain that the fact that it will go back to the Supreme Court order, because the Supreme Court order did become law temporarily for a few hours before Public Act 1 was signed into law. So the law before Public Act 1, legally, technically, was the Supreme Court order. So that's part of why we're saying it is important for voters to know that it will revert to the Supreme Court order. It's not just gonna lower minimum wage. So I just wanted to add that in there.
Thank you. That's helpful.
Would it be sufficient if we put in the underword statement that the intent is to go back to the Supreme Court order and print on another page the Supreme Court order?
We can't, again, you can't put things on the petition itself. Like there's very strict requirements on what can go in the back of the petition. So, but what I am hearing though, is that it does seem that everybody agrees that, if this repeal is if this referendum is successful in submitting signatures to us, that the, law, for lack of better terms, that would go back to is what the Supreme Court put in their order. That's what I'm hearing both sides agree to.
So then
Right now.
if that's the case, and if Ms. Hanson's 100-word summary reflects the Supreme Court, well, then that's a pretty easy creek to walk across here, isn't it? And we could take her summary.
If we decided to take her summary as opposed to the director's summary.
Correct.
Deputy director's summary.
Yes.
So just
Yeah.
one point on her summary is that she's saying that it decreases the minimum wage. And it does not, because the previous law was a Supreme Court order, and for tipped workers, it is an increase. And so there is
Tip
no,
workers.
yeah, and so there's no
But
decrease.
for other workers, it's an increase.
It's
which is-
increased both ways. The Supreme Court order also increases the wages for
Can I
all
interject
workers.
before this?
But it also increases and fully ends the sub-minimum wages for tipped workers. So there is no decrease. A decrease will be a decline in the current pay rate. And that is not what it is. It is a change in the gradual implementation of the increased schedule. So there is no decrease. So we
I
would.
would,
want
I,
the decrease.
So-
Hold on.
Can I make a
please
suggestion,
do.
just for sake of time and for sake of, because it's
We've gotta-
2:45 and we have to be out by 4.
no, we've
So,
got to move quickly.
Can I suggest that we pause for a couple minutes, let me work on some things, and then maybe that can kind of bring us back and we've got a little bit better of an idea as to what I've heard this conversation going and kind of what the board has, and then maybe we can, I can make some tweaks and have a new draft for everybody and we can kind of,
7 minutes, okay?
yes, I will make.
Board will recess for 7 minutes. We'll be back here in 5 minutes to 3.
This is both. This is Hanson and.
Are we? Hang on. Just a second. Adam, would Adam's come back with a 100-word summary that has 82 words. Would you take this compromise from the top and read it to us?
Sure. So the words, I'll read it and then I'll kind of talk about what I did and why. So it says referendum petition to repeal Public Act 1 of 2025, which amended the Improved Workforce Opportunity Wage Act. A repeal of Public Act 1 would decrease the minimum wage from $13.73 to $13.29, parentheses 2026, and from $15 to $14.16, parentheses 2027, with annual inflation-based increases thereafter. Increase tipped worker wage to 48% of the full minimum wage in 2025, 60% in 2026, 70% in 2027, 80% in 2028, 90% in 2029, and 100% in 2030, and eliminate civil fines for employers failing to pay minimum hourly wage. This referendum petition would suspend Public Act 1 of 2025 and place it on the ballot for voter approval or rejection, and that is 82 words. So a couple of things. As far as the numbers go, those numbers are taken from the court case that I've already forgot the name, the Supreme Court case, Mothering Justice. Thank you. Those numbers are taken from Mothering Justice because, as again, I hear everybody on both sides of the petition agree that that's how they think that this is going to happen. So that's where those numbers are coming from. I kept the structure with the decrease increase the same because I think that in most circumstances that's charged to say if you're increasing or decreasing something. So I'm trying to balance that with the factual matter that is what it does. So I'm trying to balance those two, which is why I used the parallels of increase and decrease and didn't change the words in others. And then I rephrased some of the other clauses to just make it grammatically correct. And then added the approval or rejection language that Vice Chair Gerwitz had mentioned. I put it into the bottom clause to say it would go for approval or rejection.
Do any of the board members have questions for Adam?
I don't have a question. I have a comment, and I think that the way you have put increased tip worker wage makes sense, and it's easier to understand than eliminate the tip credit by reducing the amount of.
That was.
So.
Yeah.
Yeah, I think that's a good way of putting it.
Mr. Cordes, questions, comments? If you think that's a good way of putting it, Mr. Cordes has no questions or comments, I would ask, do we have a motion? Really, like a 1 minute, okay?
Microphone on, please. Push the button at the base of it. Thank you.
Okay, so again, that word decrease is in there. And again, there is no decrease. It's a change in the implementation schedule. So since there are words left in our 100-word summary, I would propose that we change the word Public Act 1 would decrease the minimum wage to Public Act 1 would adjust the implementation schedule of the minimum wage.
This is where it is right now. So I know, but we are really on, we've got to stay on schedule here.
No, I definitely hear that. But we spent 5 hours on the previous
We did.
part. So I just think a few minutes on this one, we're only asking for a word to be changed and we have words left in the in the summary, and a decrease is inaccurate to the voters. Over 1 million people in this state have been signing petitions to get this
But
enacted
if
for
you,
over a
ma'am,
decade,
if you
and you're
look,
saying that it's a
ma'am,
decrease when it's just not.
if you look at the
not the case.
numbers, if you look at the numbers,
Mhm.
if in 2026 and 2027, which is what this does, those are decreased numbers. That's an accurate way of framing what happens. People don't understand minimum wage schedules. We try to give people very common words, phrases they understand, words they understand. They understand this, and that's exactly what this
I
does.
think voters can understand change the schedule. We all pretty much have schedules and that we all abide by. And I think that many voters can understand the words change the schedule. So I do think those words are words that voters will understand. And again, it's not a decrease. A pay cut is a permanent cut in workers' wages. And that's what happened in February when SB 8 was implemented. It's just not reflective of what this actually does.
The time is up now. Okay,
Mhm.
we have to do our work now.
I do have one quick question.
No,
It says, and eliminate the civil fines. Why are we eliminating the civil
I'm
fine?
sorry, say again?
This is in, it's the third, you start at the end of the third line from the bottom. It says, and eliminate civil fines for employers failing to pay minimum hourly wage.
So the reason that's in there is because Public Act 1 added a provision that said an employer that fails to pay the minimum hourly wage to an employee is subject to a civil fine. If this repeal goes into effect, that goes away. So that's why that's in there.
So yeah, back to our main point of contention.
Mr. Chairman, I
think it's
move
the
that the
word
Board of State
decrease.
Canvassers approve the summary of the purpose of the referendum sponsored by voters to stop pay cuts as drafted by the Deputy Director of Elections and
Again,
presented to
we
the
spent
Deputy
5
Director
hours.
on June 27th, 2025.
Do I have a second?
Yes, I second.
Motion's been made and it's been seconded. Is there any discussion among the board members? All in favor of the motion?
Aye.
Aye. Opposed? No. No, there is no opposed. I said there are.
But you didn't even hear public comment on the issue.
We've gone through public comment.
No, earlier we were told to wait
Okay.
because you were only doing the earlier issue. We had people who wanted to speak on this issue as well, but we were told we couldn't. So, yeah.
We are on to item number 7 is a consideration of the form of the referendum submitted by voters to stop pay cuts. We have the petition. You've given us the model. Has that been reviewed?
Yes, the petition's been reviewed by staff, and the same caveat that I mentioned before applies. Again, this is slightly different because it's repealing, so the entire statute is reprinted, and staff has reviewed it, and determines that it meets the requirements.
Okay, and it's a referendum, so it is unique. Does anybody have any questions about it? I don't.
No.
I have a motion to approve the form.
I move that the board approve the form of the referendum submitted by voters to stop pay cuts, conditioned upon the replacement of the summary language approved by the board today, with the understanding that the board's approval does not extend to 1, the substance of the proposal, which appears on the back of the petition, and 2, the manner in which the proposal language is affixed to the petition.
Support.
Then moved and seconded. Any discussion?
Nope.
All in favor?
Aye.
Moving right along. 2-second outline here 2-second housekeeping before we do that. There were 2 individuals in the room here, Eudora Brennan and Sarah Rose, who had asked to speak to item 6. I had to take you off the schedule. If there's time at the end of the meeting, I will let you make a public comment for 1 minute each. Moving along to number 8. We have a consideration of the 100-word summary of the purpose of the constitutional amendment sponsored by Invest in Michigan Kids. I'm sorry, Invest in MI Kids. The summary as draft. Okay, let's try again. Hold on. The summary as drafted by the Deputy Director of Elections is as follows. No applause while we do this, okay? Constitutional amendment to add 5% surcharge on all taxable income over $1 million for joint filers and $500,000 for single filers. In addition to existing state income tax, deposit revenue from this surcharge into the state school aid fund require funding be used exclusively on local public school district classrooms, including career and technical education, reducing class sizes, and recruiting and retaining teachers. Subject funds to annual audits and laws passed by the state legislature. The word count is 73. Before we have the attorneys present, I would ask Adam, can you present us with your summary?
Sure, sorry, I'm just trying to get myself organized a little bit. All right, so you have read it in already into the record. So a couple of things that I looked at when I was drafting this one. This is in scope, in terms of size of the amendment itself, a relatively smaller petition itself. So a couple of things that I was trying to balance with this one was, again, as always, the fairness and the neutrality with what it is doing, and trying to capture the taxation element as accurately as possible. So first, I, as always, look to the text of the constitutional amendment itself, and I'll kind of walk through the specific language that I have. I use the phrase 5% surcharge specifically versus saying an additional tax, just because that's what the constitutional amendment referred to it as. And specifically the constitutional amendment refers to it as a fair share surcharge. I am trying to find it quickly but it refers to it as a fair share. I did not go down the road of calling this a fair share just because I think that the word fair is subjective. And I don't want to put subjective elements into what we're putting into what I drafted, at least. And the second piece was trying to make it clear that as I'm understanding this amendment, it is it's putting this 5% surcharge on any income that is above that threshold, whether it's 500,000 or 1 million, depending on how you file. And that only applies to every dollar that is over that. So, but the underlying tax that you are currently obligated to pay continues through. So for somebody who's making over that one of those thresholds, if you file jointly and you jointly make $1,001,001, then you would pay the income tax rate, the current income tax rate of 4.25% on that $1,001,001, but then you would pay an additional 5% on the $1. That's at least how I understand it as it's working. I see some heads nodding, so that's reassuring that at least I understood it correctly. Then the requirement for that money has to be used for exclusive, as this constitutional amendment says, exclusively on local public school district classrooms. Wanted to try to provide some information as to what that means. With local school district classrooms, and the including career and technical education and reducing class sizes and retaining teachers is specifically in here. I did take out the phrasing. It said, if I'm remembering correctly, like qualified teachers, things like that. I did take out some of that to make it more, in an attempt to make it more neutral. And then the final piece was subjecting it to annual audits and additional laws that the legislature may pass. So that's in general how I framed it when I was drafting it, so.
Excellent. Will you go that way? Will we bring the attorneys? Okay. We're good. We have 3 attorneys that are representing, but Rowan? Well, we have Mr. Liedl and Rowan Cunnybear. Oh, you know what, Rowan? I didn't even see you back there. I apologize. I was looking over here for you.
It's okay.
Good to see you again.
Rowan has copies of the document that was submitted before the 9 a.m. deadline. So this is not anything new. This is just a paper copy of what was submitted by 9 a.m. on Wednesday of this week. And there is a proposed markup at the back. I think it's in color this time too. So.
Before you guys present, just that the deadline we are under is actually imposed by the Senate. And so here's the trick. We have between now and not too long after 4 o'clock before they're going to come in and ask us to leave.
We understand, Mr. Chair, there were some individuals here associated with Invest My Kids that had signed to testify. They've withdrawn.
That they withdrew.
Yes, and so that will just be Rowan and I from Invest in My Kids, and we have just some very brief comments to sort of refocus your attention on the new issue and highlight a couple items that are already in the menu, and then just answer any questions.
We asked if they were willing to put cots in the room across the hall if you wanted to stay. They said for us, no, but for you, they were willing to do that. So please feel free. Go ahead.
Thank you. Good afternoon. Thank you, Mr. Chairman and members of the board. Again, I'm Rowan Connie Bear, and this is my colleague Steve Liedl of Dykema here on behalf of Invest in My Kids, the sponsor of this proposal. We're appearing on agenda numbers 8 and 9. Invest in My Kids' proposed constitutional amendment seeks to impose a fair share surcharge on the highest earners to create a more balanced tax code and fund Michigan's chronically underfunded schools. The surcharge will raise an estimated $1 billion each year for Michigan's public schools, money that will go to our children and educators to ensure that the next generation thrives and makes Michigan's economy even stronger. As Steve said, I will be rather brief because we explained our positions in length in the memo, and I also won't remind the board of the Michigan election law's legal standards because we are the third summary considered today. We believe that the deputy director's summary is a good summary of the purpose of this proposal and complies with the requirements of section 482B with just 2 exceptions. First, the deputy director's summary fails to include any element of key time periods, even though the proposal does explicitly provide that the surcharge is imposed for tax years beginning on and after January 1st, 2027. Those tax years are the annual periods that would be used to determine whether an individual had sufficient taxable income in a tax year to be subjected to the surcharge. This is important information, and the proposed changes that we suggest indicate that the surcharge is added beginning in 2027 to clarify in the summary that the $500,000 and $1 million thresholds are determined on an annual basis for each tax year. The proposed changes would also indicate that the surcharge is imposed on annual taxable income, which is also explicitly provided for in the proposal. These changes would ensure compliance with section 482B, which requires that the summary be true. And though this doesn't happen often, the board does have some extra words to work with here. Second, the deputy director's summary erroneously indicates that the proposal will, quote, subject funds to laws passed by the state legislature. But this is inaccurate, and actually the opposite is true. Under the proposal, laws passed by the legislature are subject to the proposed constitutional amendment, with the proposal actually providing, quote, the legislature may enact laws consistent with this section for its implementation. Implementing legislation consistent with the proposal is vastly different from granting the legislature free rein to pass laws subjecting funds generated under the proposal to those laws. To correct this error, we propose amending the last phrase of the summary by striking out laws passed by the state legislature and adding allow the state legislature to implement by passing laws not inconsistent with the amendment. Without this change, the summary is inaccurate and not compliant with section 482B. And finally, I would like to address one argument that opponents of the proposal have raised, which is the assertion that the proposal creates a new graduated income tax, so it does not comport with the common everyday meaning to the general public to say that the proposal is implementing a surcharge. But this is wrong. The proposal does not alter the existing constitutional prohibition on graduated income taxes, which will continue to apply. Instead, the proposal would amend the very section of the Michigan Constitution that includes the graduated income tax prohibition to add a new additional tax, a surcharge, in addition to the existing state income tax with a different tax base and a different rate. That is exactly the common everyday meaning of a surcharge. It's a new additional tax, otherwise known again as a surcharge. That is the common everyday meaning to the general public. And how do we know that? Of course, I brought my dictionary here, which provides the common everyday meanings of words. And it says that a surcharge is, quote, an additional tax, cost, or import. People also know what a surcharge is, an additional charge. Businesses impose surcharges and consumers pay them every day. Credit card surcharges, fuel surcharges, energy cost surcharges, etc. The surcharge imposed under the proposal is in addition to any other income taxes and does not modify any income tax imposed by the state of Michigan or its political subdivisions. To the contrary, the opponent's use of the term graduated is far more technical. The common everyday meaning to the general public of graduated is when someone finishes high school or college. So use of the word surcharge, including in the deputy director's summary, is consistent with the plain and ordinary usage and understanding of the term. Use of the term graduated would achieve the opposite result. And lastly, I'll mention this very briefly, the state legislature, when exercising legislative power delegated by the people of Michigan, regularly refers to additional taxes as surcharges. When amending the Constitution, the people should be able to do the same. For example, MCL 208.12A1 imposes and levies an annual surcharge in addition to the base Michigan business tax. The legislature uses the word surcharge multiple times, but never refers to the surcharge as a tax. MCL 124.508A allows counties to impose a surcharge on households in addition to other charges or taxes to pay for waste reduction programs and separating materials for recycling and composting. I am getting the watch, so I will not say my last several examples, but there are several more. All of this to say use of surcharge is appropriate. Thank you all for your time, and I'd be happy to answer any questions.
Thank you. Do we have questions?
Yeah, I have questions. So a person who makes less than $1 million pays 4.25% on that income, but pays, let's say the person has 2 million, they pay 4.25% on the first million and 4.25% on the second million and 5% more on the second million. I understand that you don't want to call that a progressive tax, but it sure progresses upwards. And it's not, I mean, some progressive taxes, the more you make, the more you pay. But like in the federal income tax, it goes up by, by certain income ranges. So for taxes of, let's say, I don't even know how to express that, but it goes up in increments depending on how you go. So the marginal tax rate increases, but that's sort of what the more you make, the more you pay here. And that's a surcharge, not progressive taxes, is what you're saying.
Okay.
I mean, that's the whole thing. That's what this is all about, right? You're calling it a surcharge.
Mm-hmm. Well, I think, Member Gerwitz, two things briefly. One, I think the Deputy Director of Elections has this correct. In the summary, it is clear that it is a tax. It uses the phrase accurately, as the department indicated, because that's exactly what it is. The legislature imposes a sales tax. They could call it something else, or you could refer to it something else. It's a sales tax. It could be a retail sales tax. The language used in the actual proposal is a surcharge, and that's what it is. A surcharge is a kind of tax, right? It's a tax in addition to another tax. That's what a surcharge is. The director uses the words in addition to existing state income taxes. So it's clear it's in addition to other taxes already in the director's summary. And I think the other thing is we should avoid the use of surcharge. Somehow that's not fair. What if you had a proposal before you that said, the state shall provide every resident of this state each year a golden delicious apple pie. Right? Well, boy, folks love apple pie. It might be unfair or biased to use the actual words, but how do you describe what it is? And you could say, well, delicious, that makes the pie sound better than it might otherwise be. But it tells the voters, that the type of apple that will actually be in their pie. So I don't think the board ever has a risk of deviating from its statutory duties when it relies upon the language actually used in the proposal. There's barely more than 100 words in the proposal. The proposal itself could almost be a summary. So that's why we believe surcharge is most appropriate.
You are in fact basing this, if you were looking for a 5% surcharge predicated on I'm living on one side of the street versus another, or I'm living in the UP versus the Lower Peninsula. But you are basing this 5% purely on an income bracket.
Mhm.
That to me makes it an income tax.
I don't think there's anyone claiming that it's not an income tax. If you wanted to make it clear, you have words to work with. I think in the third line of our proposed summary, where it says in addition to existing state income taxes, you could say in addition to other existing state income taxes. That clarifies it's a tax, but you're also making it clear
And
that
I
it's
would
a
also make the
surcharge.
point that I think it's a graduated income tax since you have to reach a certain level of income in order to pay the tax or be responsible for the tax.
Well,
That's a graduation, if I'm understanding graduated.
no, I think if you had multiple rates, then it would be graduated. And graduation is in steps. There's no step. There is just one surcharge. I don't think it's accurate.
It's
to
still a
point-
step. Otherwise, that one surcharge could apply to everyone.
But a graduated tax is either graduated as to base or rate.
Graduating from something to $500,000 seems like a graduation to me. I'll
Different
graduate there
tax.
for you.
Different tax. The
No.
legislature imposes the tax under the Income Tax Act of 1967. Under this proposed constitutional amendment, it's a different tax. It's imposed by the voters through the Constitution. And so it's not amending the same tax, it's an additional charge. It's exactly why the legislature, when they added additional rates for different businesses under the Michigan business tax, called it a surcharge. That's exactly what it is. The dictionary definition is clear. It's an additional tax in addition to another tax. And the voters are free to add an additional tax. The legislature and local units of government cannot impose a graduated tax on income as to base or race. The voters are not prohibited from amending the Constitution to do so. It's exactly what is happening, and there's an additional tax in the same section as the graduated income tax. So I don't think it's accurate to say that it constitutes a graduated tax. It's accurate to say exactly what it is, and the director's summary is clear, that it's a tax, that's a surcharge. Not everyone's going to pay it based on income, and that's a clear and accurate description.
Is any other questions?
You're saying that the voters are free to impose a graduated tax.
The Constitution doesn't restrict constitutional amendments, right? The Constitution restricts the legislature and its political subdivisions, not the voters, the people of the state.
You have exactly what the Constitution
Yeah.
says there. It was pretty straightforward that it was no one could put in a graduate
Correct.
tax.
And this is an exception, why it is in the same section. Right? There's nothing that requires the voters to say, except is required in this section.
Regarding
When
income
this-
tax, it simply says no income tax graduated as to rate or base shall be imposed by the state or any of its subdivisions.
Correct. This
And
tax is being imposed by
And then the very
people of the
next,
state
in the
of
very
Michigan.
next sentence, you say that if you make more than $500,000 or $1 million, we're going to tax you more.
Correct.
A graduated income tax.
It's not a graduated.
It's
income tax.
absolutely a
It's
graduated
an additional
income tax.
surcharge.
It's a
And
graduated, that's
It's an
exactly what it is.
exception to, it's an exception in the existing section. It's a surcharge. Graduated taxes as to rate or base have more than one rate or base.
Before we
The
go around
surcharge
this
has more- and
merry-go-round
it's
one
not
more
the same
time,
tax.
because we're going to keep going down this same question and answer. We've got two more attorneys to hear from.
Sure.
Let me propose this. I would propose that we hear from the other two attorneys.
Mhm.
And then we'll have all of you to help us make our Well, we're actually going to make the choice, but you can.
Right.
Yeah.
We
And-
believe
and
the
we've got-
director
and
is.
We've got a half an hour to accomplish all that plus the form.
We think the director's summary that he has recommended is already a good one, with a
We've
couple
noted that,
exceptions.
yeah. Two other attorneys, I'm going to call Don Ziegler first a minute. And Mr. Ziegler, I would ask you to please keep it down to a couple minutes.
Absolutely, Mr. Chairman.
I know that's not fair to you. It's at the end of the day and you've waited all day, but
I brought a handout that might speed review along. May I pass it
Sure.
out?
thank you.
Thank you, Mr. Chairman. My name is Dan Ziegler with the law firm Dickinson Wright, here on behalf of the Coalition to Stop the Business and Family Tax Hike. My associate, Mr. Charlie Spees, and I sent in a letter. I'm here to very, very briefly just summarize that letter and then make myself available for questions. So first of all, on this surcharge issue, the word surcharge, I believe, does violate the legal standards set out, and here is why. Because this is a tax. How do we know it's a tax? Well, first, it meets the very definition of a tax. A tax is a compulsory contribution to state revenue levied by the government. That's from the Oxford English Dictionary. Now, it was said that the word surcharge is also a tax, but the examples given of a surcharge are not taxes. That's because all taxes might be surcharges, but not all surcharges are taxes. If it's on a credit card bill, it's not a tax. If it's being levied by the government to raise revenue, that's what a tax is. We also know this is a tax because it's in Article 9 of the Constitution, which is titled Finance and Taxation.
Everybody already agrees it's a tax, both sides.
So it's a tax. It's also a graduated tax, and we know it's a graduated tax, and this matters because, as you pointed out, Article 9, Section 7 of the Constitution declares no income tax can be graduated. This thus needs to be specifically called out to voters, because if they read the 100-word summary as proposed by Deputy Director Fracassi, and they read the text of the amendment, and they read the altered and abrogated provisions, they will never see clearly that this is a graduated income tax. All they will see is Article 9, Section 7, prohibiting a graduation, and then they'll never see that this is a graduated tax. I would also ask that the words permanent and a reference to inflation be adopted. And here's why that matters, because our Constitution was adopted in 1963. And in 1963, an individual making $47,000 a year would make the equivalent today of $500,000. So what that means is in 62 years, someone making $500,000 would be making the equivalent of $47,000 today. My son is 2 years old right now. He will start work in 15 to 20 years. He will work for approximately 40 years. And if he ever makes the equivalent today of $47,000, by the time he's done, that's going to be $500,000, and he's going to be subjected to this tax. I have here a study by the Michigan Center for Data and Analytics that shows that in 2023, the median income of Michigan residents was $46,940.
That has nothing to do with this argument, okay? We don't have time to go through statistics here. I'm
Yes,
sorry.
Mr. Chairman. I apologize. I'm simply arguing that the word permanent to emphasize that this amendment, which will be in the Constitution permanently and which does not account for
For
inflation.
We totally get that. No, that point is well made and we probably agree with you.
Okay. Then I would lastly just move on to my point about how the money is going to be used. The amendment carefully talks about how the money can be used for recruiting and retaining teachers. I would ask that that be swapped for the more specific function of the money, which is school employees' retirement systems. That's allowed by the Constitution as it exists, and I believe specifying that for the voters would be helpful. My final point would just be that the $500,000 should be done first, but
Presentation is beautiful. I just don't mean to be rude. I'm just kind of pushing you along.
I apologize. Yes, I thought I would have slightly more time. But if I can answer any questions at all.
Still the COTS option. I mean, I'm sure they'll put them up across the hall for us, but I don't want to stay. No, so questions. Do you, questions for
Yeah, I'm just looking at what you have said with regard to how the money is to be used. You want to add school employee retirement systems. Do you think that the language about using it for like if the language in this which says benefits for classrooms, do you think that excludes retirement systems?
I don't think so,
No, because it's also gonna.
because it specifies that the money can also be used for recruiting and retaining teachers. So if you look at the amendment, Article 9, it adds in, if you look at Article 9, Section 11, that creates the school aid fund. And Article 9, Section 11, Clause 1 says how that school aid fund may be used. And it's for only three purposes, right? It's for exclusively for aid to school districts, higher education, and school employees' retirement systems. This amendment does not allow these additional tax revenues to be used for higher education, but it very carefully works around not saying that it can be used for school employees' retirement systems by instead talking about recruiting and retaining high-quality educators.
You're talking about the piece that says attracting and retaining high-quality educators. And yes, I would agree with you that that could certainly be it. Retaining a high-quality educator might involve a pension.
And that's why we would ask that the words from the Constitution. That's right, because I think the as written, the 100-word summary sort of pushes the idea that this is going to create more better classrooms, shiny 21st century image of a classroom, when in fact, and I had other stats that if I had had time, I would have brought up. But for example, the teachers' pension fund is currently $32 billion underfunded as of last year. I do think that this amendment is largely created to fund that pension fund deficit. So I think given the fact that it can be used and that we already see a need for that to be used that way, voters should be apprised that, in my opinion, a very likely possibility is these extra revenues will go to teachers' pensions and not necessarily directly towards public school classrooms.
One you have in here that actually is very intriguing is you've added in the line, but without prohibiting the legislature from diverting other funds away from education, which I think is relevant, right? I mean, that.
That's right. I think that's highly relevant because in the letter I talked about the cake analogy, which is the legislature puts a big chunk of money into the school aid fund, and that's what we might call the cake. And this tax would, masquerades itself as icing on top of the cake, but that cake can disappear at any time, leaving the icing to be the only thing actually funding it. Which then means while this gives the perception that more and more money goes to students, in fact, students could get the same money or even less, depending on what the legislature does.
Take money away somewhere else.
Exactly. It's a money shifting game. Money could go to other projects or to teacher pensions funds. And we just think voters should be apprised of that fact.
You don't know that for sure.
No, absolutely not.
Okay.
That's why I just want voters to be apprised that
But
as
it might
written.
be, I mean, I don't feel comfortable saying.
Kind of conjecture.
Exactly, right. I mean, we could put, it might be used for other things too. We don't know for sure.
Well, and so I would not advise, and I don't think I have advised the board to go out on a limb and conjecture, merely to say factually that it does not prohibit the money from being withdrawn. That's as far as I would go. I would not recommend getting into a realm of,
Okay,
postulating about what could happen.
thank you.
Thank you. Mr. Doster. This sort of like represents the symbolic last word, doesn't it?
May I begin?
It's all yours.
Yeah, that's what it's feeling like, but I'm going to take a longer, little 10 seconds if you don't mind. But not much longer. Members of the board, Eric Doster on behalf of Small Business for a Better Michigan. Members of the board, this proposed constitutional amendment seeks to repeal the ban on a graduated income tax, to create a new graduated income tax with a new tax bracket with a combined rate of 9.25%. Whether a voter will support this tax or not, this is what their proposal says and does. And to be very, very clear, this is a graduated income tax. According to the Michigan Supreme Court, and I quote, "A graduated income tax is generally understood to be a tax on income that imposes a proportionately greater tax burden on the earnings of higher income taxpayers than on that of lower income taxpayers," end of quote. And for those of you taking notes at home, that's from the Supreme Court decision available at 490 Mich. 295. The Invest My Kids in My Kids proposal imposes a proportionately greater tax burden on the earnings of higher income taxpayers than on that of lower income taxpayers. This is a graduated income tax. The text of this proposal uses the word surcharge to describe this new graduated income tax, but yet the actual text of their proposal incorporates the, quote, Income Tax Act of 1967, end of quote, not the income, oh, quote, Income Surcharge Act of 1967, which does not exist. And by the way, there is exactly one I heard some from respected counsel here, uses of the word surcharge, but within the Income Tax Act of 1967, which is cited in the text of their proposal, there is exactly one use of the word surcharge, and that relates to some assessment approved by the Federal Communications Commission. So we don't even use the word surcharge in the Income Tax Act of 1967. So when Michigan last used the term surcharge was in this Michigan business tax surcharge contained in Public Act 145 of 2007. But unlike the creation of this new tax bracket before this board today, the MBT surcharge was essentially an assessment multiplied by the MTB tax liability. But so it was a multiplier of a tax, and that's not the proposal before this board today. Invest in My Kids proposes a new tax. This is not a tax, and how does it get collected? I mean, what authority does the Michigan Department of Treasury have to collect a surcharge if it is not a tax? And I think they've admitted today that it is a tax. 2 days ago, Invest My Kids submitted a public comments to this board, and I believe they passed the same comments out earlier today, to justify the use of the word surcharge. And again, today, they're requiring this board and the members of the public to go to their dictionary to look up what a surcharge is instead of just using the word tax, which has a common everyday meaning to the general public, and I did not bring my dictionary today. Members of the board, this proposed constitutional amendment seeks to repeal the ban on a graduated income tax to create a new graduated income tax with a combined rate of 9.25%. But do not take my word for it. Let's look at the Invest in My Kids website to see how they are explaining their proposal using common everyday meaning to the general public. And remember, using common everyday meaning to the general public is one of the standards that this board must adopt to create the petition summary language under Section 482B of the Michigan election law. And what I'd like you to do is to go to this slide here. This is from the very top of their webpage. Invest in My Kids. The second line, tax the rich, not surcharge the rich. So their common everyday use is tax the rich. In fact, I see some rather cool looking shirts in the audience today where they say you can applaud that, where it says tax the rich. It doesn't say surcharge the rich. So now before this board today, they're saying the word surcharge and not tax. So But let's keep looking at the Invest in My Kids website to see how they're explaining their proposal using the common everyday meaning to the general public. And I'd call your attention to the next handout. Again, this is right from their website. It talks about this why a fair share surcharge. And they say, and I've highlighted that for you, that this creates a new tax bracket for annual income over $500,000 for individual and over $1 million to joint filers. That's exactly what I'm saying. That's exactly what they're saying. And then they say, to explain what this new tax will do, then they talk about how it works in practice, and then they're telling the voters about the 9.25% combined rate, which I absolutely suggest is mandatory for this board to tell voters what they're being advocated upon. So, or being asked to adopt. So what I would like to do is to look at the director's language. And again, I'm using, and my comments are going to be based on the standards that this board is required to adhere to in preparing the proposed summary language. You know, language that doesn't use.
Could I at least, we've got about 5 minutes before we have to start the regular discussion.
I'll be done in 5
You're
minutes.
okay with that?
Yeah, maybe 7.
I know, but no.
But if you want to use the case, I'll try to be brief.
No, I know. I've run it up against a physical. I mean, they're gonna
Oh,
toss
okay,
us here.
okay. Well, all right, so let's go right to the director's language then. And that's the last page that I've given you. And these are our requested changes to, and they're not that many. I think
That's
that,
okay.
I think the
Read through 'em
deputy director did a pretty good job. And so, again, I think this has to be honest to say that this proposed constitutional amendment seeks to repeal the ban on the graduate income tax to do what they want to do, and that's add a permanent tax. So I agree with the previous speaker. And then you have to talk about creating a new tax bracket with a combined rate of 9.25%. You have to tell voters that, you know, once they reach these two thresholds, that they have to, it's going to be a combined rate of 9.25%. And then really, I've only have 2 other suggested changes. My suggested change is that you put a semicolon after where Adam put local public school district classrooms. Because if you look at the text of their proposal, these funds have to be exclusively used for local public school district classrooms, okay? This other stuff that they add later, including, these are just examples, and they are examples only. So my suggestion, and I know the previous speaker, he had some other examples to throw in there. My suggestion is you just put the semicolon right after the word classrooms. But if you want to add things that create prejudice for the proposal, like career and technical education, I don't care if it's in the text proposal, it still creates prejudice for the proposal, then let's add some other things like resurfacing tennis courts, no bid contracts, and firing teachers, because that's also what these funds could be spent on. So my suggestion is, as opposed to us arm wrestling on who gets what good or bad term, just take that out of the equation. And it makes it a lot simpler, and frankly, it's more faithful to the text of their constitutional amendment, because it's only limited to the public school district classrooms. And then I would suggest annual audits come out, because there are no standards. It doesn't say who does the audit. Maybe you guys are going to do the audit. I don't know. It has no, we don't know what that means, so just take it out because it's meaningless. And I thought that what Adam did at the end, laws passed by the state legislature, was absolutely accurate. So those are my comments, and I tried to be as brief as possible.
Thank you. Questions for Mr. Doster? What is?
No, I'm good.
I just have one comment, and that is I keep coming back to, we've been viewing this as a graduated income tax since I first saw the proposal. The fact that you printed off the website and the petitioner themselves has referred to it as a balanced tax code, creates a new tax bracket for individuals, and then puts in the percentages on the tax bracket. That seems to confirm that it's a graduated income tax.
According to the Supreme Court, it certainly is.
So I would hope that we could at least put into the summary something to the effect that it doesn't strike me as a surcharge, it strikes me as a graduated income tax. I know you guys don't want to call it that, but is there someplace in between?
Looked at it, I didn't, surcharge was, and I
Yeah,
thought
I was-
about like the kind of adding 4% to the cost to a bill if you use a credit card, right? That then someone will often make you pay surcharge if you use a credit card. They give you. So
Right.
they might charge you more. Yeah. Like that one. That's what in 2005.
Well, that's why it's critical that you got to put what the combined rate of 9.25%. You got to tell voters that.
The proposed amendment and said, where's the definition of surcharge? Find it.
Yeah, and if you don't,
Higher tax on higher income.
if you don't put that 9.25% in there, is that 5% of the 4.25%? I mean, you got to make it clear. You got to make that clear. And they do too in their example on their webpage.
I do have one quick question. You say repeal the ban on graduated income tax, but they don't repeal the ban in the first
To
part
the extent
there,
they do.
right? Like they're just adding a graduated income tax after they say no graduated income tax. So do you think that that's a repeal or is it
Maybe
just a
an
direct
ad.
contradiction?
Maybe it's a contradiction, and I'll get to that in the discussion on form. But we could say add.
Once again, to be the bad Grinch of time, it's 10 minutes to 4, so here's what I'm proposing. We have the assistant directors 100-word summary. We have a 100-word summary presented by the folks at Dykema. We have a 100-word summary presented by Dickinson. We have a 100-word summary presented by you. So we have 400-word summaries here to pick from.
Yeah.
I would, could you give us just a few minutes to chat about those and figure out if we can make a 100-word summary that has something for everybody?
Let me ask a question.
Yes, please do.
But let me ask the question. If summary didn't say anything about the graduated income tax, it would be up to the courts to decide if this 5% is a this 5% surcharge is a graduated income tax, right? Well, but if there's a prohibition on graduated income taxes and then there's a surcharge, I understand what Mr. Lidl is saying is that it's just that it's not a contradiction because it's an addition. It seems to me like a graduated tax, Mr. Lidl, and so I'm trying to figure out. how
We're
it
happy
is
to
that
do our
you-
part to help move this along. Just let you know that if you look at the director's summary, we don't believe it has to be a 5% surcharge. If you make the changes we've requested to the director's summary and say, beginning in 2027, an additional 5% tax, that's fine. That's accurate. I don't know that adding the word graduated provides anything with regard to the meaning or not. It is not particularly relevant whether it's a graduated tax or not. The people have the ability to add it, right? Add an additional tax. And they can read the proposal for more. Some of the other suggestions, I don't want to belabor it. They're not in the director's summary, and a number of them are just an inaccurate description of what the proposal provides. But if that would move you towards a resolution that can get sufficient votes, dropping the word surcharge and making that, a 5% additional tax, which is what it is, 5% additional tax, and it's clearly graduated. It's clear that it's graduated because it tells everyone what incomes it applies to, right? They can read for themselves. They can understand it better by seeing the actual numbers. There's enough room here to provide the numbers. You don't have to explain that there are rates and brackets because there's one rate applicable to one. The Supreme Court case doesn't apply. There's no lower rate. no one else pays anything other than folks above the threshold. The tax, there is no tax for anyone else under the new additional tax. So those are my comments. Happy to answer any questions about other changes. I would note that I think that many of them are inconsistent, both with the actual language and the statute as well.
I don't want to cut off questions. I have a couple of suggestions, like just
Before we
kind
do
of
the
what I heard,
questions,
so.
You do the suggestions and then we can ask questions too.
Mhm.
That'll clear up some.
Yeah, so a couple of things. I'm okay with a number of things. I'm kind of hesitant with a couple of things as well. I actually was going to suggest what Mr. Lidl just suggested as well. It's starting it off with saying adding an additional tax. I don't think the average voter is going to know what a graduated tax is versus just the idea that this is an additional tax on income above these thresholds at 5%. So I think that still gets at the heart of kind of what it is. So that was going to be what I would recommend with that piece of it. As far as whether or not we want to go down the road of 9.25%, I think you have to be careful with that because I don't think it's accurate to say that this just results in a 9.25% tax, because that suggests to me that you're going to be paying a 9.25% tax on everything, and you're not. The 9.25% would only apply to the income above the threshold. And I have separately have concerns with combining that 4.25% income currently for the same reason that I don't want to say permanent in this, because it's what it is now. I mean, if we want to say that, but I would want to caveat that to say currently would 9.25 or something like that.
A good point, because the percentage would actually graduate as your income went up.
It would.
No.
4%.
No, because because as I interpret it, the 5% would just be flat.
I'm just, if
Right.
work the
I'm
math.
too tired for
I
jokes
know,
at this
you
point.
are.
Yeah. Adding anything.
I can understand that.
I'm tired to deliver that
Right.
line correctly.
Adding
So-
anything with regard to a statutory rate ignores the fact that the legislature is free at any time to change the rate, including while the petition is circulating. So it may not be accurate to say current while it's circulating. In fact, there are proposals in the legislature to alter the statutory income tax rate currently pending.
That's my
Yeah.
hesitation with
Yeah,
saying anything.
but how else do you put down, I mean, this more than doubles the current income tax rate for those people that are in this new tax bracket.
They have full notice. If your income is above this, you're going to pay an additional 5%. This summary gives them all the notice anyone could ever want or need. No, absolutely not.
Your letter confused me on that note. To be
Right. From Mr. Fracasse's example, paying one additional dollar is not doubling your income tax burden.
It's doubling your rate.
No, it's not.
Once you get into that tax
No, it's
bracket,
not.
most certainly is. It goes from it's not doubling the tax, it's doubling the rate.
After the first.
Right. Right.
This is where, yeah, I'm not agreeing to putting them.
But let's look at what their own schedule says that.
Yeah, I would,
Websites
I think there's a
are
way
not
to,
before the board.
I think there's a way I do think that we need to find a way to make it clear that your tax isn't going from 4.5 to 5%. Like it is an additional 5% going on in that. I think whether it says 9.25 in there or whether we're saying you are going to pay an additional 5% tax, like making it very clear that the rate doesn't go from what it is to 5% on that income. It is 9.25%, and you do have that directly on the website. So I'm not saying that.
But if you call it an additional 5% tax, and you say that right at the beginning.
Yes, that's clear.
Constitutional amendment to add an additional 5% tax on all taxable income over $1 million.
That's pretty good.
Yeah, that's.
But you're only saying that because you've got the benefit of their nice little chart and graph that I just gave you. I mean, if you're the voter looking at this for the for the first time.
Right, and it goes on to say, in addition to existing state income taxes.
Right. Again, we would add a reference to 2027 and annual to make it even clearer that.
I'm sorry, what?
We would add to the director's summary a reference to that the tax begins in 2027 and that it's an annual tax that persons pay. That if you're saying you're paying it annually, you're telling people that they're paying it each year until someone amends the Constitution. Nothing in the Constitution is permanent. But saying, adding the word annual makes it clear that it's an annual
I
tax.
understand that you said that they could change it at any time, and I do understand that you wouldn't want to put that it's 9.25 because it could change, right? But if you put in addition to existing state income taxes currently 4.25%, I think that highlights how much, that this is.
We would not object to that.
No, okay.
But the problem with it is that
I understand, but it might.
it will be inaccurate, and it's not the sort of thing the board normally does.
inaccurate at some
If there was, if the legislature were not in session and there were no ability between now and the filing deadline, but what happens if they change the rate? Now we're giving people inaccurate information. They can look up the rate themselves or they know the rate.
What's that? We are gonna run out of time if we don't. So let's look, we're gonna take a stab at creating the 100-word. Okay, with what we've got to work with here. So we don't want to use the word graduated. I'm okay with that. I think you're okay with that.
I don't know that I'm okay. with
Are
that
we-
saying graduated? I mean, I think people know what the term graduated tax is.
Can I ask,
People
are we
understand
going to
that.
sit here for 20 minutes and argue what the example should be after the words classrooms? Or can we just put a semicolon there and eliminate all examples? Or we can sit here and for 20 minutes and argue what examples? Okay. Okay.
Mr. Ziegler, what did you want to?
So we're talking about the word permanent and about how the permanent can't be applied to the rate. And I would agree with that. My concern with the word permanent was with the 500,000 and the million and the fact that this amendment does not adjust for inflation. That's what I think needs to be called out for voters, that the number doesn't change. And I had stats, but I have stats that my 2-year-old probably more likely than not, more than 50% of the toddlers in this state in 50 years will be making more than $500,000, which means this tax, which currently would only apply to a very small top percent, will within my child's lifetime apply to more than 50% of Michigan's residents. I think,
Yeah.
well, 47, but I'm sorry, what's that?
I said if they're educated properly.
And that's yes, ma'am. And that's where I have copies if the board would like to see it. But the average income in Michigan is currently more than 47, which would mean more than 50% would be taxed under this tax.
Well, but again, so our mission to go back to is to have a 100-word summary that accurately and simply reflects what's in this proposal. So we have an income tax. We have an income tax that applies to 500,000 single filers, 1 million joint filers. The purpose of the income tax, we have 4 petitions here, all of which adequately describe the purpose of it, including your semicolon. Can we just kind of confab here and figure out how to put those words in place?
We have one.
I think we do too.
To add an additional 5% tax on all taxable income.
Well, and I think Adam has been taking all of our notes and probably putting them into a new
What have
100-word,
what
right?
have we got so far,
Is
Adam?
that correct?
Tried my best.
Could you do me a favor? Could you read what you've been absorbing all of our notes and I've been watching you type? Could you read what you have for this?
So this is what I have. It's constitutional amendment to add, beginning in 2027, an additional 5% tax on annual taxable income over 1 million for joint filers and $500,000 for single filers, in addition to existing state income taxes, and then in parentheses, currently 4.25%. Deposit revenue from this tax into the state school aid fund. Require funding be used exclusively on local public school district classrooms, including career and technical education, reducing class sizes, and recruiting and retaining teachers, subject funds to annual audits, and authorize implementing legislation. So the things that I changed, I did add at the beginning in 2027 and saying that this is an additional tax on your taxable income over the respective thresholds. I added the 4.25% to say currently at the end. So that way, in an effort to make it clear that it's just this right now. And then at the end, I changed from what I had before and laws passed by the state legislature to authorize implementing legislation. I used that phrasing just because that's the same phrasing we approved with the ranked choice voting petition, as well as several other petitions that deal with that. So that's the main changes that I made, that I heard, so. And that's 74 words.
What if we run that to print and we look at it and then we can use the word?
Mr. Chair, just one technical change resulting from the word surcharge. I think Adam rightfully changed, and so I think it's around the fourth line just before state school aid fund. It was this tax into the state school aid fund. We're now referencing two different taxes, the current tax and the prior. So I would just suggest adding the word this new tax. Yeah, the revenue from the new tax only goes, and was clear before when it was surcharge. Yeah, that's it. We know it's getting close to beer o'clock and would be supportive of the director's summary with that change.
Well, we got some issues here. Did you strike out the word, anything after classrooms?
I did not.
Yeah, well,
You wanted that out?
well, I would suggest you just strike out after that, or we can suggest that we add other things that also fit within their constitutional amendments purposes. So again, to make that easier.
That information is, or that language is right in the proposal
That
itself.
was fair share
I'll put it-
surcharge, but that's still prejudicial.
Well, and so,
But you
again,
cannot, if the proposal is prejudicial, then you just, I mean, it is appealing to the public, which is what you want it to be.
again, back to my example of apple pie. It may be very appealing. How else do you describe it?
Well,
But yeah, let's, okay, stay out of the vineyard for a second. But if we go currently, okay, the currently 4.25%, but you're still not telling voters that it creates that new tax bracket with the combined rate of 9.25%.
There's no new
Gonna
tax
add
bracket created. It's a separate
4.25.
tax. If you were amending the existing income tax to add a new bracket, it would be accurate to say it's a new bracket. This does not. This is a new tax with a single surcharge on a single income level.
Well, I hope that we're not rushing to judgment here, just trying to
It's a
get it done and get it
bracket of
Well, I
done.
hope we're not either.
Right.
What I was hoping is we could print this one so that we can line it and then
Okay,
I have a hard time visualizing the words unless I can.
I understand.
see 'em. And I know that we're really dangerously close here, but do we have time to print it? You can do that? You're probably already doing it, right?
It's probably already done it.
Sitting there, yeah.
Or maybe pausing for a second because it,
And then, but then we've got a hard copy and you'll have a hard copy and we can, and Mr. Dosser, I think when you get that hard copy, we're coming down to like, there's three pieces of this, right? There's what
There's
funds
more,
are gonna
but-
be used for. There's what are these funds really called? What do they represent? And then there's the last piece, which I don't think anybody disagrees with, and that is the state's gonna legislate to make it all happen, right?
Yeah, but I like the director's language before was more accurate about the laws passed by the legislature, but
Well,
that somehow got changed in the
Well,
last.
that's because
we
it
can
wasn't
tweak
accurate.
that. That's the point is, so we'll
Okay.
redline this one.
Okay.
And that should take us like right in, I'll bet you when we get done with this and we get done with the form, the Senate guys will be standing right in the back and they'll all be helping us out.
We can come back.
We can
I
do
don't
it.
want to rush to judgment here. This is an important process.
Well,
It's an optional approval as the form. Folks have plenty of time to exercise their judgment as to whether or not they sign the petition and vote for the proposal. This is just simply a summary of the proposal. The board's had it for a while. They have a 30-day deadline.
Which is the word permanent. No, but it says public school district.
They only have 2 votes.
A question for you guys. You guys are the pros. Doesn't say local public school districts in the proposal. It says local schools.
Yes.
It says local public school districts.
No, in the current version,
Local,
So does that
Yeah.
also mean charter schools, parochial schools, et cetera, et al?
I can answer that. I can answer that question. So we're amending an existing provision of the Constitution, right? And you see no reference to public school academies in section 11, right? It says school aid fund can be used exclusively for aid to school districts, higher education, and school employees' retirement systems. You know, that's the current law. Okay. How is it that public school academies get state school aid? Are they a school district? The courts in Michigan have determined that, yes, they are, right? In fact, some of them are actually chartered by local school districts. So the current version of the proposed constitutional amendment uses the term local school districts. It has its plain and ordinary meaning. ISDs are school districts, they would be local districts. And there's nothing in this provision that would indicate that public school academies are no longer school districts for purposes of receiving school aid. Yeah.
Like the term local school district.
That the word public in here should be.
Yeah, I think
stricken.
the initial version of the petition submitted used the term initial local public school districts, but the revised petition that was submitted used.
When did that get switched? Because my version from the announcement, did you do it post-announcement?
No.
Because this says classrooms in local public school districts.
Well, I can tell you the current form that's before the board. It's right here. You would like, if you'd like a copy.
We're going on the.
Yeah, because the announcement that we're here on says, oh yeah, this says local, this says classrooms in local school districts.
Yep.
Well, that's not what was passed out. Yeah, Stephen was graciously provided me a
You
copy.
may get your wish after all.
Yep. I'll just note one other thing.
It
Understand.
doesn't change anything.
Right. I think you're right. It's just one less word. Currently, 4.25%. I noted the issue. I'm not saying that you want to include it. What about 4.25% as of June 27th, 2025? As you're reworking, please consider that, so that we don't have a situation where it's inaccurate when the group is circulating the petitions if the legislature changes the rate.
Because somebody could later argue that it's, that it's inaccurate, even though,
Correct.
supposedly, if we
Right.
approve it,
Right.
they can't challenge
If
it, right?
the board would like to inform voters the current income tax rate, we know what the current income tax rate is as of June 27th, 2023. So instead of
just say
currently
June.
4.25%, you could say in parentheses 4.25% as of June 23rd,
You
or
could just say
27th,
as of
sorry,
June 2025. You don't
Yeah.
have to add the date.
Yeah.
I'm okay with,
The day.
I have no objections to that
So on
suggestion,
the,
because we're not trying to.
we go down to the one line here that says require funding to be used exclusively on local public school district classrooms. If we looked at that and said instead, require funding be used exclusively on local school districts, semicolon, classrooms, career and technical education, reducing class sizes, and recruiting and training teachers. Does that give you what you were looking?
No, it's still prejudicial, because it can still do, that's still the problem. I mean, it should be, okay, since they've changed their language,
Right.
and I apologize. We could say, we could go right to their let's just use what their language says. It says must be, this is, I'm reading from their text here, must be expended to support classrooms in local school districts. So let's just say exclusively on classrooms in local school districts, semicolon. Because that's what their proposal says. And this rest of this is prejudicial because it says including is like, for instance, for example. So we could have lots of examples
Right.
that they didn't include in the text of their proposal. So rather than subject this thing and violate your standards of, creating prejudice for or against the proposal,
If
just put the
proposal
semicolon there.
is, If the substance of the proposal makes people favorable to it, you cannot say that our describing it is creating.
Well, then you
prejudicial.
go down a slippery slope.
Well, perhaps there's another way to look at this. If you were only describing those things and it only said, including, lawyers can argue about that, but the purpose is to describe and summarize the entire proposal. It's not there in isolation. Look at the first part of subsection 5. It says 100% of the money in the fund under this article must be expended. Okay. And then look at the last sentence. The money may not be expended for other purposes. Right.
Right.
So the proposal is saying twice, here is only what you can spend this money on. Right. And if you tried to spend it for something else, you're going to have some sort of
But
claim.
If we shorten it under where somebody is simply saying local public,
Right, because you're rewording their proposal for them, because their proposal says, quote, classrooms in local school districts. It doesn't say classrooms in local school districts, which necessarily means, which can only mean career and technical education. Those are examples only. I'm just trying to make this less partial here.
School district.
And this is just summarizing taking the words here.
Local school district. We could actually say. Classrooms.
And just stop.
We are really.
If I can respond to just a couple of things that I've heard. So I'm fine with that if we want to say, where is it in the last? Require funding be used exclusively on local school district classrooms, period. Or sorry, semicolon, and then continue to subject funds to annual audits. I'm fine with that. I think it's still accurate to say that. It still accurately represents what's in the proposal. The piece that I'm struggling with the currently 4.25% and putting dates in it. And to be frank, that's exactly why I didn't want to go down that road and just leave it at in addition to existing state income taxes. Because then no matter what happens with that fluctuation at any point, it's still fairly accurate. It's still impartial. So I'm okay with putting a date in. I think if you start getting into dates in the summary, then it's going to get very confusing for a voter. So
You're suggesting we leave.
I would just strike currently 4.25% and just leave it at in addition to existing state income taxes.
Okay with that. I'm actually good with it.
Yeah, I'm okay with it too. Yeah,
So
I
that
mean,
would
when you say several times, if you say it's an additional 5% tax and it's a new tax, and it's in addition to the existing tax,
Yeah,
people
I'm good
people
with
get the message, right?
If we take that percentage out, we make these changes we talked about here. We give Mr. Doster the elimination of those pieces for technical.
No, I
education.
wouldn't give him the elimination of that.
Well, you
Because
should,
it's right.
because those, he's right. Those are just being used as
But-
examples.
No, except that it's the
Included in
fact
plan.
that it says including, I think that's more than just an example. Including is a very specific thing, not just for instance.
Particularly when coupled with the additional language, 100% of the money must be spent. Those are specific. It may not be spent for other purposes. Well, what are the purposes that the exact examples that are used? You know, we've got references to things that are not in the proposal at this point. I don't know why you would be including things in the proposal that are outside of the proposal, the existing income tax, right? But excluding actual language used in the proposal.
But their proposal says including, it doesn't say limited to.
It doesn't say including but not limited to. And again, you can't read it in isolation. It may not be expended for other purposes. What purposes are specifically authorized? The only safe use are for those specifically delineated.
Right.
The uses are classrooms in local school districts. That's what this proposal says.
Including funding for career and technical.
And you could also say including a whole bunch of other things.
But it doesn't say that.
But you could. For
But
the,
it
that-
didn't.
but we're
If
not
you'd like to-
rewriting your
If you'd like,
proposal.
if you'd like to submit a new proposal that says that, you can get that description, right? Here, you're ignoring, again, the money may not be expended for other purposes. What purposes?
But-
Those purposes specifically detailed in the language of the proposal.
There are a million examples of what would qualify as expenses.
Okay, we got to do this.
What have we got now, Adam?
And you added the word permanent. You added the word permanent as well.
Oh, I don't think it's necessary, but you like permanent? Okay.
I think you've got to.
A permanent
A permanent, yeah, a permanent additional
5% tax on annual tax.
I don't like.
The permanent only simply underscores the fact that they're adding a tax with an amount to it into the Constitution.
Okay.
You don't like the word permanent?
I don't,
That ignores the language in the Constitution that permits both the legislature and the people to amend it. It's misleading.
But
There-
it reflects the fact that this would be the only set income tax in the Constitution.
Okay.
The
Everyone
sales
knows
tax,
that
the
because
sales tax isn't.
everyone knows that. Actually, that there is language that permits the legislature to impose a sales tax of up to 6%.
Correct, the
And
legislature.
mandates that 4% be levied.
Correct.
Right.
Correct.
Okay.
You and I are.
can I pause you guys?
Sure.
Sure.
Our poor court reporter needs to have a clean
Oh, we're
record.
sorry.
I really need you guys not to talk
Gotcha.
over each other like that. If I could please
Yeah, no,
ask,
no,
I would
we're
really
sorry.
appreciate it.
That stops now. Okay. Mr. Ziegler, if you would like to step between these gentlemen and be the only one speaking and keep it like 5 seconds or less.
5
you're good.
seconds. At the
Not
last
5
board
minutes.
meeting, the board considered a petition that would have added specific criminal penalties. And it found that the inclusion of those specifics was noteworthy since normally constitutions don't get into specifics. They leave specifics to the legislature to sort out. That's why I proposed the word permanent and the mention of inflation, because here we're doing something novel. We're adding specific dollar amounts.
Inflation's out. We're not talking about that. but
Okay, but the
Permanent
word
is a word
permanent,
that,
because normally, like with the criminal penalties at the last meeting, normally those are left to the legislature. Normally,
I think it's only permanent until somebody changes it.
But we don't put
right?
permanent on every clause that's in the Constitution, right? I mean, why are we?
we
The
put permanent.
citizens of
Sorry.
the state imposed a permanent ban on
Leave it
gay
out.
marriage,
Okay.
and it's not permanent.
But the permanency is because it's a
Comma, Beginning
novelty.
at 2027,
Commissioner.
comma,
Gotcha. I know, I understand.
an additional 5% tax on annual tax and taxable income over $1 million, for joint filers, blah, 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 single filers. Chairman Housecamp would add period after single filers. This tax is in addition to existing state income taxes. And the revenue is to be deposited. To be used exclusively on local public school districts. No, we're included, because it's included in the proposal. It's fine. Yeah. Okay. No, we're not putting permanent. No,
we got a Fisher Cup.
I think we have.
Not time, man. I get what you're saying. But it is in that petition.
No, what's in their petition is it's limited to the local school districts.
Say that again.
That's not what's in their petition. The petition says that it's exclusively for quote, classrooms in local school districts, end of quote. And then you pick up some including language.
That's exactly the same way we're wording it, though.
Those are the detailed
We're
purposes.
taking
under
the
which-
wording right from the
But that's
petition.
prejudicial. I mean, it could be, a lot of things come under the categories of quote, classrooms in local school districts, end of quote. A lot of things could come in there. So let's put some of those in if we want to play,
But they're not-
to
but
make
they're
it.
not in the petition. That's the problem.
Other things can't come in when the provision says the money may not be spent for other
I mean,
purposes.
if we're talking about the merits of this is a constitutional amendment, that's a different conversation.
Oh, I understand that, and I'm not doing that.
But from 100-word summary that reflects what this is, I've got a hard time arguing with the rest of the board that we're
So they
writing
could put
something-
anything, including curing cancer? I mean, come on, let's be serious.
No, I know
that-
what you're saying, but I'm saying it's right. The wording in the 100-word summary in this particular instance is identical to what's here. We took out the word public because in this new model, you guys submitted this later or first one I saw, I thought.
We
it said
updated the
public.
form of the petition and notified the Bureau at the same time that we had withdrawn to correct the form and make this change to the words local public school district to local school district.
I clearly understand what he's saying, and when I read the money may not be expended for other purposes and expenditure of the money subject to annual law, may not be expended other purposes other than to support classrooms in local school districts.
It actually says something different. It says, because it's including, it's defining what those funds within the school districts are going to get used for. That's how I'm reading that. I'm not reading that as examples of.
It is an example, including.
I read it as examples.
Well, the Legislative Service Bureau, we know they do write bills regularly. They write constitutional amendments, and they would, if you wanted Mr. Doster's interpretation that it's just an example, they would write it including but not limited to, right? And we have no but not limited to in the words of this proposal. And at the end of the day, are we going to tell the voters what the individuals supporting this proposal intend to spend the money on or not? Right? There's room to do it. Why not tell them what it's for? If they don't like it, They don't have to sign a petition or vote for it.
Problem is if the 100-word summary reflects precisely what's in the proposal, the petition. I understand I understand the argument that you're making, Eric, but
But here, please look at 42B, the standards as far as prejudicial meaning. Otherwise, what you could do, if that's what your logic is, then you're going to encourage petition sponsors to come up here and use terms like fair share surcharge, and they're going to, do the focus testing group and put all these flowery terms in there. And then, I'm going to come in here and do that. And I'm going to say, but it's in my petition text, so you got to use it. Then I'm going to cure cancer with it. And it's the Cure Cancer Fund. I mean, come on. Yeah, that's ignoring your duties under 482B.
I'm not disagreeing. No, and
Everybody wants their petition to create some response in the voters, right? We're just trying to use fairly neutral language, but if the petition itself is not neutral,
If the
but
Board of Canvassers were to do things like to say,
and by the way,
this big, beautiful constitutional amendment, when the words big and beautiful are not
you're
included
singing my
in
favorite
the
song.
constitutional amendment.
We've seen
That would be
petitions come up
prejudicial.
here that are awful. Okay. Now, and by the way, this would rank right up there with them. But if I go back to what we're charged with doing, we're supposed to do the 100-word summary, right? It's fair, it's accurate. Right now, in this case, I can't argue with not using the words that are in the petition. Because we're not.
Or can we add other things then?
What's that?
Can we add other things then that could be under the category of classrooms in local school districts? Because there, again, it's excluding, it says 100% of the funds have to be expended to support, quote, classrooms in local school districts. So let's include other things. If you want to include the three things that they've mentioned.
You could say include school busing, but it's not here. It's not, I mean, that's the point.
Just because it's not there, it can still be used for that purpose.
But it doesn't say that.
And it's.
I don't care. It's still, we're telling the voters what these funds can be used for, and it's not limited to these three categories.
It is when you have it followed by the sentence, the money may not be expended for other purposes. You're requesting the board to include other purposes that are one, prohibited, and two, not included in the text of the proposal.
No, the
Well,
text
you just-
proposal says,
Is it conceivable that if this ended up being passed and the Constitution was amended this way, could you ever see a case where somebody used those funds for school buses and you guys were representing the opposing side in court saying, wait a minute, you can't do that?
well, it's not
These are only
a
for these
classroom,
funds.
expense. So we're talking, firing teachers. You could have no bid contracts. I mean, you have a classroom on a tennis court, that resurfacing a tennis court. So those are classroom.
yeah, let's get on.
Are we printed?
We got something?
Yeah, I think we have to.
Yeah, oh, yeah.
Are we waiting? That's,
Yeah,
okay.
no, I think that was-
I was burning conversation with you. I'm sorry. I thought we were printing. I'm reading. I think we've improved it, yeah. But I understand where Mr. Dosser's coming from. I'm just reading this in a different way, I think. I'm not reading it as an attorney would read it. I'm just reading it that.
It's attractive. If you don't find a way to make it not attractive.
Well, maybe. I don't know that would make it attractive or not attractive.
Move this in addition.
Thank you.
Just move that phrase. right?
I can explain why if you would like.
So I think the way we had it before, after filers,
So
that phrase in addition, then say this new tax is in addition to existing state income taxes.
So the reason I didn't do that was because then it throws off the structure everywhere else for the rest of it. So if you cut that sentence right there and say for single filers, period, this deposit, this this is and you say that this is a new tax, then deposit revenue doesn't make sense, require funding be used doesn't make sense, and all of the other things following it doesn't make sense grammatically. And then to change it to say is deposited, it doesn't read well to me. So that's why I moved I tried to move that up front to make that point, because I do hear that you wanted to that to be a little bit more clear, so that's why I moved that up front.
But I just think that the way we had it before. Yeah. And so, in terms of at a period after, that was what our Chairman Hauskamp suggested. Add a period after filers and put this tax is in addition to existing state income taxes. And the revenue is to be deposited, then and
then require
used
funding
exclusively. Then your structure is correct.
But then subject funds to annual audits and authorize implementing legislation doesn't make sense. That's the structural problem.
I don't think that's a big problem. They make subject funds in a sentence, subject funds to annual audits. Adam, I just. No, right, but. Yeah. Yeah, that's it. And beginning in 19, yeah, that's just much better.
What you got?
Thank you. Adam moved this phrase and I don't think that works. So I think it's better to have add beginning as we have before, add beginning. Before. Yeah, add beginning. Now he's worried about the structure, but we can
fix it.
Yeah. So this tax is, we can, in addition to existing state income taxes, and is to be deposited, and the revenue is to be deposited to the state. Used, yeah.
What? It says had past tense is going to. Okay. I'm no longer in violation. Currently I was in violation. This long guy. Steve,
Yeah, I think it is.
People, when they read this, have to look at the fact that this is a brand new income.
Well, they had to go 9 because you had.
Top
3
of regular state income. That's. Seen at the same.
Yeah, I don't think it's an afterthought either. I think where we have it, this tax is an addition to.
Adam, did you didn't like the structural change of creating a sentence in there?
The problem is that when you create the sentence there and say, this tax is in addition to existing state income taxes and is to be deposited, and you do all of that, then subject funds to annual audits doesn't make sense. And if you reword that, then authorize implementing legislation doesn't make sense. Because that clause that you added refers to the taxes. Authorize implementing legislation refers to what the constitutional amendment does. So it creates this like, it blurs the two, yeah. So something's gotta move.
It wasn't an easy
If the
thing.
statute wasn't.
I thought you did a good job. I thought you did a good job. I agree.
Like I can fix the subject funds to annual audits, because you can do like something like that, but then this doesn't make sense.
Mark's here. He's still.
He's still.
No, he's gone.
Oh, he was here.
He was here.
He's not.
But it doesn't make sense with what you put before it, with this tax is in addition, and then you've got a semicolon, and then you have and authorize implementing legislation. So the only way that would make sense would be to change this to a period and then say this amendment would authorize implementing legislation, which then creates this weird structural between constitutional amendment to colon, do all these things. And then you say this tax is in addition. And would do all these things, and then you go back to what the constitutional amendment would do.
Did they?
Oh, I see what.
Like,
Very good.
yeah, like, cause you've got like
Few things.
3 different parts.
Okay.
Yeah, do the quarter.
Yeah. Yeah.
I'm fine with that. If we want to take that out. I mean, if you want to do that, I'm fine with that.
Yeah, it's fine.
Yeah, you got a long way
It's
to
up to
go.
you guys.
Yeah.
Not so much longer.
Wait, where are you guys going?
At least I think we're done at like the end of 7. We don't know. We have to figure out.
Hey, you can buy the state party building for cheap. 11,000 square feet. How much do you
Talk
need?
to Hanson. I don't know. We should talk to Hanson about that.
You can buy it really cheap. We're selling for $500,000.
We want like a better, we want to maintain the view.
Oh, we don't have that. We're far, we're too far away.
There's not a ton of good options. Yeah.
That's true, because I gotta come here for the inaugural. I love your view.
And you put your, because then you got on local school district classrooms,
Yeah.
honestly, just get rid of that career and technical.
You know, we do legislative receptions, and then we have like a dining room.
Because then you keep it, it's just this money is exclusively on the following colon.
He's still firing around.
He is.
He's all right.
His mind is still.
You bet it is. You bet it is. For a lot of years.
The word, basically including
Yeah,
career and technical
yeah.
education, just
And he's
leave
up
that
there.
word.
And he's the same.
So it's used
He's
exclusively
like
on your classroom, career and technical education, do.
Their birthday's falling a little bit. But yeah, 83, 84.
The word again that.
I just deleted equipping.
Okay.
Yeah, I think.
I don't think it
I'm fine.
hurts. I think it's still accurate.
I just would prefer it.
Oh.
Yeah, I think that's fine.
Right.
Come on.
Come on down.
And then 2, once you find out there's a component, bring the opponent in, do the same. Yeah.
Just-
And if you think it's all, you come up, and then you can control.
Why are we still here? Why have we been?
You might get.
I'm sure the power.
Or you can at least say it's agreed to everything, but this side wants this.
That's right.
My youngest daughter always wanted that.
That's right.
Father's Day.
And there doesn't have to be anything.
Katie always comes up with something cynical.
Could say, hey,
say
here's
here,
the proposed.
always
here's
finish
the
That's right.
opponent,
But it's
and
always
here is
done
the-
a lot of it.
But as it stands,
I'm not sure.
we're going to share with you.
I know, what?
The Father's Day, you just did that.
Oh.
On my desk, I have a talking George Bush.
We have communications. You're on that.
Ouija things for Donald Trump.
Would you submit anything for the bureau or the board this week?
That's little.
Just to.
Yeah, just right now.
But I think there are other that submitted stuff for some of the other. They don't
They
share.
should put that on the website.
Right. I mean,
We don't have to worry about it.
yes, and if things are updated, if the petition is updated.
You don't even have my comments from last week on the website, right?
Did you think?
That's not even.
No, I got those. Because that's.
Wait, your oldest, your youngest, or
Then, yeah, so.
Oh, my gosh.
But I know you got my comments because you're talking about my comments, so.
Maybe. So were you were.
Where are we here on this?
You were.
Yes, we got, I think I got it.
No, you got.
We're talking this one, right? The one with the, that's a whole different.
With my,
We can't tell that.
if you don't, I'll give it to you right now.
No, I know, right here.
Five there.
You like that?
Yeah,
I like the,
anything graphical.
I like the graphic. I
Anything graphical.
did a graphic for the first one too.
That's what, that's my.
Congratulations.
Sort of the vision.
I did some
You
graphic.
call it the Grover North.
Birthday celebration for my sister. And all of
You're
her
here today to
grandchildren.
summarize the purpose of. I can tell you what it's all about. The purpose, whatever year he said, we need to make government so small that we can ground it in. And that's essentially what do.
Yeah, pretty much.
So same thing with your, put an image in.
I like my image.
Like it.
And it's really nice and straightforward.
Did you get permission from the artist to use?
No.
What do they?
Have you got the latest one?
I guess they could.
I mean, that's like.
Oh, you did?
Very nice.
I guess they could.
It's so.
That's what I'll argue.
Yeah.
Yeah, I like it. It's gonna work.
Yeah.
It sounds like their focus was like restriction, right?
Yeah.
Because. Oh, wow. Thanks. We're talking about other things.
Look over each other.
I can look over.
Oh, okay.
So
Yeah.
dark, but.
It rained.
Is this different than
what
we had in here?
Yes. Oh, yes.
It's a different one.
The outside, yeah. Part.
And then now it's fine.
That go away.
I wouldn't disagree with you. I mean,
You seen this, Fred?
it permits authorizing legislation. I don't have a problem with it. There's room to add it. I don't know.
We throw in the word non-mandatory, subject funds to annual non-mandatory.
Well, I don't think that's quite right when you consider the rest of the Constitution that provides for an auditor general and that school districts are subject to.
That's okay.
gonna make the audit?
That's okay.
Well, here's the deal. You want to go for the motion?
Auditor general would be like independent legislative.
So it'll be
You have two
one
audits.
audit, it'll be
You have,
every school district.
you have one audit. that audits all the state entities. And then you have mandate under state law every year, every school.
The wisdom and the logic here would be.
Certified account.
But these specific funds just say subject to.
Another question.
Yeah,
So with these funds not.
I think that,
Because they're subject
I
to,
think,
but not
I
required.
think in implementing legislation, one, like, or any appropriation you would have, like,
Maybe,
in
but
order
now
for
we
us,
don't even have mentioned.
in
legislation.
order for us to comply, and that's why I say, hey, I got the problem. with that.
Okay.
I mean, just, I think on that, but I mean, if when you consider the rest of the Constitution and it comes to state law, it's like, in fact, hey, the legislature, we're gonna make- they can
Well, I go
implement that
What is
inconsistent
for
and
sure?
detailed
What is?
It's sort of like
Theoretic,
promote.
but if they don't, then it remains not mandatory. That's what I'm
Well,
trying to
all
describe it as
expenditures
it
of
stands.
state funds and expenditures to local units are subject to audit by the constitutional auditor general.
You know, what I've got here does,
I mean,
you can never find,
I think in this instance, it's fair.
they're not in order.
I would understand your argument,
well, I'm sure.
right? If there was not a mandatory audit provisions.
Question, have you got your packet there with the agenda in it?
Okay, I've got the motion.
And I think it's sort of inherent, like, can the legislature legally appropriate these funds without requiring? audit?
I just need to borrow it for one.
My argument would be no.
Okay, well.
That's right.
No inflation.
Well, there's all sorts of references to funds
Yes.
in the Constitution and elsewhere.
But not specific dollar amounts to be taxed.
Uh,
Within my child's lifetime, odds are more than 50% of Michiganders will make more than half a
Look,
million.
we could have
That means we're now, I mean.
We could have a
this bill
deflationary
doesn't- As tax.
speculation
is how
on
down.
economic analysis. That's not the job of this morning.
But it's not speculative.
We have a,
It doesn't, that's right.
Make the case.
all right, we're gonna read it either way.
Yeah.
We have a final version of this. I'm going to read it to you. Constitutional amendment to add, beginning in 2027, an additional 5% tax on annual taxable income over $1 million for joint filers and over $500,000 for single filers. This tax is in addition to existing state income taxes and is to be deposited into the state school aid fund and required to be used exclusively on local school district classrooms, career and technical education, reducing class sizes, and recruiting and retaining teachers, and subject funds to annual audits.
If I may, Mr. Chair. Is it and I hate to put you on the spot, Steve, but I'm going to put you on the spot. Is it on the language on what this is spent for? Can it only be spent on quote, career and technical education, reducing class sizes and recruiting and training teachers? Is that the only thing you can spend these funds
That's how
for?
we're reading their proposal.
Oh, I'm asking Steve.
I know you are.
If that's the only, is that the only thing you can spend these funds for?
The language of the Constitution sort of speaks for itself. I'm not going to say 100% yes, because the language here deviates from the actual text, and I don't want to belabor the 100-word summary. The language is broader. It's educators. It's not simply teachers, and it's high-quality teachers. The language here suggests that it could, you could spend money on poor performing teachers. The constitutional amendment itself prohibits that. So if you want to talk about adding high quality in, because it's prohibited from expending money on poor teachers, I don't want to allow the perfect to be the enemy of the good. In my view, the board, assisted by the director's, done a good job, and you could quibble until 5 p.m. next Friday. You and I can argue over little minor things. I think this is a fair summary. You'll have another
I'm
opportunity to make the
interpreting your
case.
proposal that that's what it says.
And that's
I think-
not what he just said, though.
I know.
He's an excellent attorney.
I know what he just said.
Well, again, I mean, I've said repeatedly, what are the purposes? Something else is not another purpose. So something else is another purpose. The money may not be expanded for other purposes. So anything other than these, I would view as a other purpose.
I think it's clear from Mr. Lidl's response that these three are not the only things that can be spent on. And unless those phrases are, that phrase is redacted out to make this not a prejudicial summary, then I would urge this board not to approve. I would strongly urge this board not to approve this proposed summary.
Mr. Lidl believes that a surcharge and a tax are the same thing too.
He's a brilliant attorney. What can I say?
I have to smile because you know what, as we go, I'm remembering too many times over the last 3 years where we argued opposite of the way we're arguing today. And I guess that's the beauty of this, right? Do I have a motion?
I move, am I on? Yeah. I move that the Board of State Canvassers approve the summary of the purpose of the constitutional amendment sponsored by Invest in MI Kids as drafted by the Deputy Director of Elections and presented by the Deputy Director on June 27th, 2025.
Can we have a roll call vote?
Sure. We'll call the roll. Been moved and seconded. Ms. Cummings. Mr. Cordes.
I think that this
This
is
is a yes or no.
a I'm a no.
Vice Chair Gerwitz.
Yes.
See where this leaves me, right? I do think you don't believe that this limits the funding.
So Mr. Lidl just said,
You
or he
don't
tried
believe
not
that
to
this
say.
limits the funding. That's a yes or no question.
Oh, you're asking if it limits the funding? Yes, I
don't
do.
bu-
I think if you look at the entire, subsection 5, it limits the,
Say again?
yes, if you look at the entirety of subsection 5, it limits the money. 100% of the money must be spent for the designated purposes, and the money may not be expended for other purposes.
Period. That's your interpretation of this.
That's the language that's actually used in the proposal.
You're saying that that's not the language that'll be applied.
He's not answering your question, Mr. Chair. It can be for other purposes other than these three named examples. That's the point here. I understand it's in the text of their constitutional
No,
amendment.
I get it. I understand it. What I'm gonna do is gonna be the really unpopular thing. You know what? I'm gonna actually vote to deadlock this. I'm gonna actually vote no on this. And I'm gonna send it out and let it be deadlocked. Is that the way we want to go here?
Well, I'd remind them,
I mean, really, before I've had that put into the record, okay? We have worked here all day long. We have gone through 3 petitions. You guys are telling me that this constitutional petition is so poorly structured and so poorly thought out that 2 of the best legal minds, 3 of the best legal minds in the state of Michigan are going to tell us that, yes, this is what it says, Mr. Hauskamp, but that's really not what we intend to do with it. It really doesn't mean that.
my answer was yes.
What?
My answer was yes.
That's how I'm interpreting the conversation between you guys. I'm hearing one guy say, doesn't mean it.
Guy who's opposed to it, say.
Yeah.
Who is quoting
Correct.
the language from the
Correct.
proposal itself about how the money is to be used.
Representing the group proposing this amendment. We have Mr. Doster over here who represents groups and others that were reported in MERS News Service. Their intent today was to deadlock this board. That was the reporting in MERS News.
No.
They said the quiet part out loud. And I'd remind the board that you have a duty to either approve or disapprove under the Michigan election law. That's the oath that you took to perform the duty. The board can find 3 votes to disapprove or find 3 votes to approve. But the duty that the legislature has imposed on the board is to make a decision one way or another.
So as a representative of the client that put this petition out, you are saying that this last line exclusively on local school districts, classrooms, career and technical education, reducing class sizes and recruiting and retaining teachers. That is the only thing that these funds can be used for.
Yeah, that's what the language says.
Yeah, I know, I
100%
know.
of the
I
money
get it.
funding in the fund must be expended for schools. And the money may not be expended for any other purposes.
All right.
Yes.
I'll vote it yes, we'll put it through. That's. Well. Are you moving your motion? Oh, I'm sorry, you know what, because of my theatrics with the deadlock, we need a new motion. Somebody want to put it up?
Okay.
I'm gonna go with it.
I move that the Board of State Canvassers approve the summary of the purpose of the constitutional amendment sponsored by Invest in My Kids as drafted by the Deputy Director of Elections and presented by the Deputy Director on June 27th, 2025. Support.
Been moved and supported. You still want a roll call vote?
Please.
All right. Ms. Cummings,
Yes.
Mr. Cordes.
No.
Vice Chair Gurwitz.
Yes.
And myself, I'll vote yes.
This is extensive litigation. Okay. Well, they're spending. Let me.
To go on to the next one.
Thanks. Good job today.
Next time you come to Ferndale, I got you. Never buy
All
a
right.
drink there again,
All right.
okay?
Good to see you.
Hang on one sec, my friend. I gotta adjourn this meeting.
We still have the form.
We got a couple of, we
still
have
have
one
the
quick
format.
item here. Mr. Doster, you're gonna want to hear this one. We have to hold the approval of the form until the meeting on the on the 10th, maybe, 10th or 11th? July 10th, we will approve look at the approval of the form. We're just out of time. We're.
Can't have 1 minute.
So would the board like to receive an updated petition before the meeting on the 10th with the summary that you just approved so that there does not need to be any sort of conditional approval as the form to provide for an updated summary? That just allows a quicker turnaround time for the proponents.
Yeah, please.
Okay. Thank you.
Thank you. Appreciate
Thank
your
you
time.
guys all for your patience and, yes. And this meeting, we could ask about new business, but there's no new business. Meeting is adjourned.
There's no time for any new business.
If I can, if I can, anybody that, excuse me,
Did you want that?
before we jump, before everybody, if I can ask that anybody that wants to talk to the board, please go wait in the hallway for them. We have to clear out. Like, we have to clear out of this room like now. Thank you.
There was extensive
I
litigation.
made him say that multiple times because I don't believe I already said it. I know, I'm being my usual.
Except that with regard to, the Headley Amendment prohibits